And just before we do introductions, we'll just get the housekeeping done. Thank you very much. Right, thank you for that. Can I just check the mics operating okay? It's operating, yes. Right, all right. We'll just do some introductions. Tiffany, would you like to just introduce the panel? Or introduce yourself, I should say.
Kia ora koutou, Tiffany Wilson. I live in Rotorua. I am from Te Aroa, from Turatangaka and Ngongotaha, which has links into Ngāti Whakaue and Ngāti Tutiaiti, and then also Ngāti Marukukire in Te Poke Tapuika, and have connections into Tainui Waka as well, Waikato Mani Poto, Ngāti Koroki Kaukura, and Ngāti Apakura. Do a lot of work in the natural resources space, including commissioner work. Kia ora.
Yes, good morning. My name is Rob Van Voorthausen. I'm an independent hearings commissioner based in Napier in the Hawke's Bay.
And my name's David Hill, and I have the pleasure of chairing this particular hearing. Just a little bit of context. I'm also an independent hearing commissioner and have been doing that now for a good many years, and just do that now, so it's my luxury. Just in terms of background, both Commissioner Van Voorthausen and myself heard PC2 and we're going 2020, I think it was 2019, 2020. So we have that sort of familiarity, and that was certainly helpful also. And will be interesting to get some updates on that with respect to all the downstream issues, respective flooding and stormwater and those sort of issues. And also introduced us obviously to the housing issues of Rotorua. Also last year, of course, I chaired the hearings into the contracted emergency housing motel application. And again, be very interested in catching up on that particular issue over the next week or so as to how that's gone, now that we're nearly a year advanced on that matter. So we do have context. That's really all I'm saying in terms of Plan Change 9. And in terms of Plan Change 9, it seems that as bureaucracies mature, acronyms also mature. So we now have PC9, which is an IPI under the IPSS, under the RMA, being heard by an AHP, which underscores some of the nonsense that surrounds the particular legislation that we're dealing with. But we do have to deal with the legislation. It is not an option. I know there are submitters out there who would enjoin upon us to reject Plan Change 9. not in that position. It's a statutory imperative. We do have that option, of course, if we think it completely fails all the tests, but on the assumption it doesn't, plan change 9 in some form or other will progress. I think that needs to be stated right at the outset so that people are under no illusion in terms of what the mandate that this panel has. We're required to report, our recommendation report is required in order for council to make a decision, I think by 31st of March next year. Yeah. So we're sort of on a timeline, or everything else being equal, to, I guess, to get our recommendation to council sort of November-ish, I think we have in mind. I'm not quite sure what the council has that in mind, but that's what we have in mind. And of course, that will depend on the progress of the hearing and various other matters. So just in terms of background context, that's it. We don't have any preliminaries. I've flagged an issue which to council that she will address, which we'll talk about as we go through, which relates to qualifying matters and the way in which qualifying matters are to be taken into consideration or not to be taken into consideration, because unusually a number of us are doing IPIs around the country. This is I'm doing 5, but this is the only one that involves a tier 2 urban environment, local authority, territorial authority, and so a slightly different crosscut on the matters that we need to think about from those that are tier 1 local authorities, and we'll get into that in more detail a bit later on. So in terms of prelims, that's it for me. I think we can, unless anybody, are you poised to? Feedback? Right. Okay. All right. So no, that's fine. That's an important interruption since people are online, and presumably if they're online, they want to hear what's going on. I don't know why, but never mind. Right. So over to you, Council.
Make sure I turn on my microphone. Just a couple of procedural issues, and then I'll move into the hot seat there to do my submissions. So firstly, we have updated the version of Plan Change 9 to incorporate the changes that were recommended in the addendum to the 42A. So that is now on the web page, and that is the document that we've put on your table, so that we've got one available on this table too, so that we're all working from the same latest version. And just the second matter is that we have given some thought to site visit and the locations that would be worthwhile visiting, and we will provide those maps and schedule to you today for that purpose. And Mr. Ward is available to accompany you on that site visit, just to help you with those locations, and he's not giving evidence as part of this hearing.
Thank you, and just let me flag. I mean, if anybody has any problems with Mr. Ward, well, I shouldn't say problems with Mr. Ward. Any problems with Mr. Ward actually acting as our guide in this capacity, then they should let us know. But as far as we're concerned, Mr. Ward is not a witness in this particular hearing, so we're quite relaxed about him operating as our guide.
Could I just double check? You mentioned that about the PC9 update being in the hard copy. Is that the one that we also have electronically? Okay, thank you.
There seems to be an absence of light. I'm not sure whether that's deliberate or not, but
We did discuss that. It seems to be a feature of the lighting in this room, but hopefully that's not going to be too much of an issue. I think I can see what I'm
well, as long as
reading.
we're not going to hear from the dark side, that's fine. Right.
Right, now I trust that you all have my legal submissions that were circulated in advance. We do have some hard copies available if that's any help to anyone, but
No,
otherwise
I think we're fine. And I just evident, but I mean, we've read everything basically. Well, no, I shouldn't say we've read everything. We've read as much as we possibly can. Sorry? Is it very difficult to hear? Oh, okay. All right. Well, that's good. I'm pleased you can hear me anyway. So that's all that matters, you know. Right, right. Yeah, no, and I mean, all the statements of evidence and the rebuttal have been read, so everybody should be aware that that we won't be wanting chapter and verse.
Right, I'll try and make sure that I'm speaking right into the microphone. Does that assist? Yeah. Okay. So there are some sections of these submissions that I may be able to go over in a little less detail, but there are a number of issues and I have endeavoured to deal with them relatively succinctly anyway. So I will take you through some of those. Can I just check? I know that Commissioner Hill has done a number of these IPI hearings. The other commissioners been involved in a...
I have been chairing the hearings for the Selwyn District Council on their district plan review and also their IPI. We've finished that process. Our recommendations go to the Selwyn District Council on Wednesday this week.
Excellent.
In terms of, sorry, say the question again?
Whether you've been a commissioner on an IPI hearing.
No, I haven't.
Thank you. Just helpful for my own information in terms of going through some of that detail, although as Commissioner Hill's pointed out.
And yes, don't skip over
Yeah.
stuff for that very reason. Thank you.
Perfect. Okay, so just by way of introduction, I am appearing, of course, for Rotorua Lakes Council in respect of Plan Change 9 to the operative Rotorua District Plan, and it is an intensification planning instrument under Section 80E of the Resource Management Act. So before moving on to the detail, I do want to just address some big picture issues for this plan change. And firstly, that's the purpose of Plan Change 9. And the purpose is essentially to provide more housing and more housing choice within Rotorua. And that's to be achieved in two ways. First, as has already been mentioned by Commissioner Hill this morning, by providing for intensification in the manner directed by the National Policy Statement for Urban Development, with a focus on Policy 5. And as noted already, intensification is required by the NPSUD. That's not an issue here. The focus of this hearing will be on where and how that intensification should be enabled. And second, by incorporating the medium density residential standards into the relevant residential zones. And again, this is directed by regulations which include the council as a specified territorial authority for the purpose of the Resource Management Enabling Housing Supply and Other Matters Amendment Act. Again, that is directed. There is no discretion in terms of implementing the NDRS other than in respect of qualifying matters, which we will come to. Now, I just note at the outset that while some submitters may disagree with either intensification or inclusion of the council in the Amendment Act, I submit that it is not the role of the panel to question the regulations, and any submissions to this effect are not relevant and should not occupy the panel's time. Secondly, the Rotorua context. While Rotorua has been included as a specified territorial authority for the purposes of the Amendment Act, it's important to keep in mind that the council is and remains a Tier 2 local authority, and Rotorua is a Tier 2 urban environment under the NPSUD. There is a little bit of confusion in submissions that somehow Rotorua was elevated to Tier 1. That is not the case, and hence the context for this IPI hearing is different, as already noted, to all of the others. And as I've pointed out, this means that different provisions of the MPSUD apply, most notably Policy 5 rather than Policy 3. In addition, the provisions being proposed in IPIs for Auckland or Wellington or for Tauranga or Hamilton may not be appropriate in the Rotorua context. And I wanted to make 2 points there, not only that different provisions apply in the MPS, but also that Rotorua is different on the ground in the sense that it is at a different place in its intensification journey than those other centres that I've mentioned. In terms of consultation on Plan Change 9, you will have seen from the reports and evidence before you that the Council has engaged in significant consultation on this plan change, both before and after notification. This is a council that has embraced the opportunity to provide more housing and a greater variety of housing as a means to address the acute housing shortage that has been identified in Rotorua. And as a result, there is a large measure of agreement on the key issues for consideration by the panel, with many of the remaining issues for this hearing being focused on specific wording changes to the district plan. Similarly, in terms of scope, as you'll be aware, the Council has not applied to strike out any submissions in advance on the grounds that they're out of scope, and that reflects again the Council's support for intensification and for all of the options to be on the table before you for consideration. Having said that, there are limitations in Section E of the Act. Section 80E of the Act in terms of the scope of an IPI. And that has been recently clarified in the Environment Court decision of Waikanai. So I will be drawing those limits to your attention where relevant in the submissions. So just turning then to Section 2, where I've introduced the Amendment Act, and I don't propose to spend much time on that section, but really I've just recorded there that the Council has been added to the Amendment Act by regulations. The regulations having the long name of the Resource Management Territorial Authorities required to prepare and notify intensification planning instruments regulations 2022. And those regulations required the IPI to be notified by the 20 August 2022, which was the same as all of the Tier 1 territorial authorities, and it does require decisions to be notified by the 31st of March 2024. So I'll just move on to Section 3, which is the scope of Plan Change 9. So the matters that may be included in an IPI are described in Section 80E of the Act. And this is unlike a standard plan change or variation. The IPI must contain the mandatory matters and it may contain the discretionary matters. And just to reinforce that, it may not be used for any other matters. So the mandatory elements in Section 80E are that an IPI must incorporate the NDRS and must give effect to, in the case of Tier 2 territorial authorities, Policy 5 of the MPSUD. In terms of discretionary elements, Section 80E1B provides that an IPI may amend or include the following provisions: financial contributions, provisions to enable papakainga housing, and related provisions that support or are consequential on the NDRS or Policy 5, and that includes qualifying matters. So turning then to Plan Change 9, Plan Change 9 incorporates the following mandatory elements of an IPI. It incorporates the NDRS into relevant residential zones, and it gives effect to Policy 5 of the MPSUD in urban environments. It also contains the following discretionary elements: It modifies the MDRS where necessary to accommodate qualifying matters. It proposes amendments to related provisions which support or are consequential on the MDRS. It proposes changes to the financial contributions provisions, and it proposes amendments to enable papakainga housing. An IPI can only be used for the mandatory and discretionary elements set out in section 80E, and I submit that accordingly, any submission seeking relief outside of those matters is considered to be out of scope of the plan change. In addition to the limits in section 80E, I also submit that the usual tests in Clearwater apply to plan change 9. And those, of course, are the usual tests in terms of whether a submission is on the plan change, which addresses whether it's within the pre-existing status quo advanced by the proposed plan change and whether there's a real risk that people affected by the plan change would be denied an opportunity to participate. Now, I do just want to add a point to the reference to Clearwater. The submissions that have been circulated for other parties, in particular Department of Corrections and the Retirement Village Association, do accept that Clearwater is well-settled law or orthodox position, as mentioned in their submissions. However, I do acknowledge that the extent to which Clearwater applies to an IPI is perhaps not as well settled. And that's because an IPI contains mandatory requirements, unlike any other plan change. So I do acknowledge that where plan change 9 is required to make changes in respect of the MDRS and policy 5, it cannot then use Clearwater to avoid those mandatory obligations. And I will come back to that issue again in the context of some of those submissions by those particular parties. So to date, the only judicial consideration of the hearing panel's scope under section 80E of the Act is by the Environment Court in Waikanae Land Company Limited and Heritage New Zealand. And in that case, the court recognised that as wide as territorial authorities' powers may seem to be in undertaking the IPI process, it is apparent that they are not open-ended. They are confined to the matters identified in a number of relevant provisions. That particular decision arose in the context of a resource consent application, not the IPI hearing itself, but it considered whether Kapiti Coast District Council's IPI could list a new wahitapu site. The court considered the extent of the council's powers in respect of qualifying matters and in respect of related provisions. And I've set out their conclusion in the quote there, but at paragraph 3.10, I've set out their overall conclusion. It shows that the mandatory requirements of section 80E are not open-ended or without limitation, and any proposed rules must be carefully considered to ascertain whether they fall within one of the subsections of section 80E. Rules that are proposed as qualifying matters under section 77I may be ultra vires if they remove the rights that presently exist under the district plan. Now, I understand that the Waikanae decision has been appealed to the High Court and a priority fixture has been requested. As it is possible that the High Court's decision will be issued before recommendations are made on Plan Change 9, these submissions will address the position both with and without the Waikanae decision in the relevant parts of these submissions.
And the latest information I have on that, which may not be the latest information, is the High Court won't hear that until next year.
So again, I'll return to the implications of Waikanae where it becomes relevant throughout my submissions. And perhaps the better process might have been a declaration before the Environment Court on that issue. So just turning to section 4, I have set out the legal framework for evaluation of Plan Change 9, but essentially it is the same framework that applies to other plan changes as set out in sections 72 to 77, as well as section 31 and section 32 of the Act. And I've noted as summarised in Colonial Vineyard decision, just a couple of additional matters that do apply to IPIs, and that is that there is under section 77G8, the requirement to incorporate the MDRS into a relevant residential zone applies irrespective of any inconsistent objective or policy in a regional policy statement. And that simply reflected that these plan changes were required to be notified within a short time frame, which may have predated the regional councils having an opportunity to update their regional policy statements. In fact, in this instance, both the Bay of Plenty Regional Council and Waikato Regional Council have since notified changes to their regional policy statements to give effect to the MPSUD. And secondly, additional evaluation requirements apply to qualify matters under sections 77J to 77L. The High Court in the Southern Cross decision has recently confirmed that the panel should consider the extent to which Plan Change 9's proposed changes to the district plan would give effect to all of the relevant provisions of the MPSUD. And I submit that in practice, this means that where the panel has been asked to consider more than one set of proposed changes to give effect to Policy 5, it must consider the extent to which those proposed changes give effect to all of the relevant objectives and policies of the MPSUD, and indeed any other relevant national policy statements or regional policy statements. In addition, the panel is required to give effect to the extent possible to any national direction that comes into force after notification of Plan Change 9, but before the panel makes its recommendation. And in that respect, I've referred specifically to the National Policy Statement for Indigenous Biodiversity, which has come into force very recently on the 4th of August, and it has been addressed in the addendum to the 42A report. A slightly different position in respect of the Emissions Reduction Plan and the National Adaptation Plan, while they did come into effect on the 30th of November, in fact, the transitional provisions mean that you don't have to have regard to those. Nevertheless, we have considered those in the 42A report.
Can I ask you on that one? Is that a should not or a cannot?
You're not required to. I would not suggest that that was a cannot. Certainly, if they are heading in the right direction of those documents, that would seem to me to be relevant.
Yes, I just couldn't recall what the wording actually is and whether it actually allows a discretion to consider that or not. And I didn't think it did, but maybe that's something we can come back on.
I can make a note of that.
Yeah.
And then finally, as I've already mentioned, proposed change 6 to the Bay of Plenty Regional Policy Statement was notified just before notification of Plan Change 9. So it wasn't considered in the Section 32 report, but it is considered in the Section 42A report. So I'm just going to move on now to Policy 5 of the MPSUD. And I have set out the background in terms of the provisions of the Act that require the IPI to give effect to Policy 5. Section 77G requires that every residential zone in an urban environment must give effect to Policy 5, and Section 77N applies to urban non-residential zones. Policy 5 itself provides that regional policy statements and district plans applying to Tier 2 and 3 urban environments enable heights and density of urban form commensurate with the greater of the level of accessibility by existing or planned active or public transport to a range of commercial activities and community services, or relative demand for housing and business use in that location. There is further guidance in terms of giving effect to Policy 5, which clarify that a council may create new residential zones or amend existing residential zones. It may enable a greater level of development than provided for by the MDRS, and it may create new urban non-residential zones or amend existing urban non-residential zones.
And can I flag just before you move on, because Policy 5 is so different from 3 and 4, obviously we're going to be very interested in how a number of these elements of Policy 5 in actual fact are articulated. Obviously, the first one is what the heck commensurate actually means. The second one is what on earth the greater of means. And I'm not being sophistic here, but these are quite complex thoughts. But importantly, what B in terms of relative demand actually means, because that is obviously fundamental to the whole question as to how much capacity is required to be produced.
The council does have a comprehensive accessibility analysis that's been prepared, and it's part of the Section 32 report. That was prepared by Cameron Wallace, who will be giving evidence. So he will provide a lot more detail in terms of the way that that's been developed. Susan Fairgrave will also be giving evidence in terms of issues relating to demand
Yes.
on that.
Yeah. I guess I'm just flagging, I haven't read yet something which persuades me that someone's analysed what relative means in this context. And obviously that's the heart of the disagreement, apparent remaining disagreement between KO and council at the moment in terms of extent. But it's also, I think, underscores one of the other submitters, I think Kate Darman and some of the planners who are saying you've gone too far. So one of the questions in my mind is, in terms of satisfying Policy 5, how far do we need to go?
Yeah, I certainly agree that that's an issue, and I will deal with that in a little bit more detail just further in this section. So just in paragraphs 5.6 and 5.7, I've just noted there the definition of urban environment and the spatial reach of Plan Change 9, but I don't understand that to be an issue. So just turning to paragraph 5.8, Plan Change 9 contains the following key changes to give effect to Policy 5. Enabling residential development where appropriate in the city centre and commercial zones, and increasing the height limits in those zones to support the centres. Secondly, amendment of the residential to high density residential zone to enable high density residential development, particularly by increasing the permitted height from 12 metres to 22 metres and amending the height in relation to boundary control. And thirdly, by increasing the extent of the residential 2 zone by rezoning areas of land from residential 1 to residential 2 in areas which reflect a high level of accessibility and support the centres. And the detail in terms of those changes will be explained to you by Rachel Morgan as one of the Section 42A authors. Now, I submit that those proposed amendments collectively give effect to Policy 5 in a manner which best gives effect to the wider objectives and policies of the NPSUD, including enabling a significant increase in the variety of homes throughout the Res 1 and Res 2 zones and the city centre and commercial zones by increasing the heights and densities of development, enabling the greatest density of development to occur in the most accessible locations where there are existing jobs, community services and open spaces that can be accessed by public transport, providing for sufficient development capacity to meet expected demand in the short term, medium term and long term, and recognising that the planned urban built form may involve significant changes to an area and that these changes may both detract from and improve amenity in different ways. Now, I do want to deal briefly with consistency with the future development strategy. Subpart 4 of the MPSUD requires every Tier 1 and Tier 2 local authority to prepare and make publicly available a future development strategy for its urban environment. And on the 1st of June, the Council, jointly with the Bay of Plenty Regional Council, notified a draft future development strategy for Rotorua for public consultation. Now, while the draft FDS is relevant to Plan Change 9, the panel should keep in mind that it is a broad spatial strategy that extends beyond Plan Change 9, both in terms of its spatial application and its timing. So while Plan Change 9 is part of implementing the FDS, it is only the first step in the implementation plan.
I agree with you with respect to weight. I guess I'd go further and ask the question as to whether we should actually have any regard to it whatsoever, given the fact that it's a long way from being complete. The public yet hasn't had a say on it, and we don't know what the outcome will actually be.
Yeah, that's exactly right. And I have in the next paragraph just submitted that while the draft FDS is relevant to the panel's consideration of Plan Change 9, the weight to be given to it will be limited by the stage that it is reached in the preparation and consultation process.
But a number of witnesses actually spent quite some time actually taking us through the FDS as though it actually should have more weight than it probably should have.
Yes, certainly. The consultation process has closed and hearings will be held at the end of the month, but obviously the outcome of those hearings and any changes will not be available during the course of this hearing. I have asked Damon Mathfield from the Council to give you a general overview of the FDS so that you can see where Plan Change 9 fits in the overall plan for the city.
Just whilst we're on that, what's the time frame for determining the FDS? Because it's a local government act process, presumably, is it? So there's no time frame on it, basically, is there? I mean, I'm just speculating that. I mean, it may be available before we get to a point of decision, in which case, or recommendation, in which case we may want to take account of it in due course.
The timing of the hearing process means that it is probably possible for us to provide you with updating information once the decisions are available, because I expect that will fall between this hearing and your making recommendations. So we could come up with a procedure for doing that if that would be helpful.
Again, I'm just leaping ahead here. I mean, in terms of where, oh, no, do I want to leap? No, I don't want to leap ahead.
So turning then to submissions regarding giving effect to Policy 5 and some of the issues that you've mentioned already, there are a number of submissions regarding the proposed amendments to the city centre, commercial and residential zones to give effect to Policy 5. One of the issues raised by submitters relates to the extent of the Res 2 high density zone. Kainga Ora seeks that the Res 2 zone be extended further to the south, and Sigma Consultants considered that the Res 2 zone should be removed, with this land zoned Res 1 instead. Now, I consider that both of these submissions relate to questions of timing and the extent to which Plan Change 9 should provide for development capacity in the short term, medium term and long term. As you've noted, Policy 5 does not specifically provide a time frame for determining whether heights and densities are commensurate with accessibility or demand. However, I submit that the purpose of the MPSUD is best achieved by a forward-looking approach to Policy 5, which extends beyond the 10-year life of the district plan. This approach enables consideration of both the current and the anticipated accessibility and demand in the short term, medium term and long term. Now, that word commensurate is the same word that's used in Policy 3, albeit the test is slightly different. And in a similar way, other IPI processes have taken a longer view rather than limiting to the 10 years. And you'll notice that policy 5 does specifically refer to existing or planned active or public transport. So it anticipates a forward-looking approach rather than being limited to what's there now. So conversely, the draft FDS extends beyond a 30-year timeframe and identifies an extent of development capacity that is in excess of what was identified in the HBA. Accordingly, the Council submits that it is not necessary to extend the Res 2 zone to the additional extent proposed by Kainga Ora. The Council's evidence is that doing so may enable intensification too far from the centres in the short to medium term, thereby taking up the demand in locations that are too distant from and do not support the centres. And you will hear detailed evidence about that. Now, in respect of the submission by Sigma Consultants that PC9 goes too far too soon, the Council submits that it is appropriate to consider the planned urban form for the centres over the short, medium and long term, and to enable a level of intensification that will support the development of the centres. And this is going back to my point that Policy 5 anticipates looking ahead to planned accessibility, and of course demand is looking ahead as well. The Council's evidence specifically considers each of the centres in terms of their current level of commercial activity and community services, accessibility and demand, but also the expectation for these centres in the future. And the evidence will also show the other methods by which the Council proposes to support these centres as part of the implementation of the FDS. So before leaving the topic of Policy 5, I propose to address whether the Waikanae decision has any implications for these provisions. In particular, the proposed amendments to the city centre and commercial zones allow greater height, but the greater height is provided for as a restricted discretionary activity to enable assessment of matters related to urban design. This may be considered to be more restrictive than the current district plan provisions. In my submission, Policy 5 gives the Council a broad discretion to provide heights and densities that are commensurate with accessibility or demand. Unlike Policy 3 and the MDRS, Policy 5 does not specify the heights that must be enabled in each centre. I submit that it's for this reason that the provisions relating to qualifying matters do not apply to Policy 5. In addition, the Waikanae decision was made in the context of the prescriptive requirements of the MDRS. It did not consider the broad discretion enabled by Policy 5, and in my submission cannot be extended in this way.
Let's just pause there for a second. So are you saying there that that the prohibition, if you like, on cutting across existing rights doesn't apply?
That's right. That doesn't apply to Policy 5. Yeah.
Yeah.
But I do want to take you through that.
But you still want to make the argument that I think. Oh no, let me let you make the argument. I was going to touch on the activity status issue, but you just make your argument.
I just want to provide a bit more clarity in terms of Policy 5 and qualifying matters. So Section 77I enables modification of the MDRS, and I'll get to the exact wording. So Section 77I enables a specified territorial authority may make the MDRS and the relevant building height or density requirements under Policy 3 less enabling of development in relation to an area only to the extent necessary to accommodate one or more of the qualifying matters. And then similarly, Section 77O provides a similar provision in respect of urban non-residential zones, but it relates to modifying the requirements of policy 3. And that's because, of course, the MDRS doesn't apply to non-residential zones. Now, it does look at first glance as if the authors have forgotten to refer to policy 3, maybe because the Amendment Act focused largely on Tier 1 local authorities. However, the Amendment Act didn't create qualifying matters. Qualifying matters were already there under the NPSUD. So if you look at the policies of the NPSUD, policy 3 applies to Tier 1 urban environments, and it specifies the heights that are required. It actually specifies it in terms of stories, 6 stories, in certain centres. And then policy 4 enables those provisions to be modified only in respect of qualifying matters. And there are provisions later on in the NPSUD which identify the qualifying matters in a very similar way to what the Amendment Act then went on to do. Policy 5, which relates to Tier 2 and 3 urban environments, doesn't have the qualifying matter provisions applying to it. Now, I've got 2 submissions to make about that. One is that policy 5 contains a broad discretion to apply heights and densities in a bespoke way to reflect the existing and planned accessibility and demand. It isn't prescriptive in the way of the MDRS or policy 3. The second point I want to make is that the qualifying matter provisions are not enabling, they provide an additional hurdle for modifications. The Council already has obligations to recognise and provide for the matters of national importance in Section 6 and to give effect to relevant national policy statements and regional policy statements. The qualifying matter provisions in Section 727J onwards provide an additional hurdle that does not apply to policy 5, but it does apply to the MDRS. So you will note for the assessment tables for Plan Change 9, the qualifying matters relate to the MDRS and they relate to residential zones. Those tables do not, we don't have similar tables in respect of the commercial and city centre zones. However, we are still required to recognise and provide for the matters of national importance, etc. So certainly our provisions in relation to natural hazards, geothermal hazards, etc., will apply across all of those zones. And that obligation has actually been recognised specifically in the legal submissions for the Bay of Plenty Regional Council.
Can I just check my understanding there, please? So, admitting confusion at quoting all those numbers of different policies, in terms of qualifying matters, they still will be applied to every part of the of PC9, sites, but not when applying or prior to applying policy 5. Is that what you're saying?
Qualifying matters in terms of being the additional evaluation required by Section 727J to L only applies to the MDRS in the residential zones.
Yes.
So we aren't required to do a qualifying matter assessment for provisions that apply in the commercial or city centre or other urban non-residential zones.
Okay, so those hurdles aren't present in those zones.
That's correct. We can the provisions like the district-wide rules will just apply in the usual way.
Right. Help me out here, for please. If, say, a qualifying matter is a place of historic heritage, if it exists within a commercial or an industrial zone, how is that provided for under Policy 5 or the implementation of intensification in that zone?
Those provisions are all existing in the district plan already, and they are there to give effect to parts of Section 6 of the Act. they're not proposed to be changed as part of this plan change, nor are we required to review them because
Yes.
we're not required to do any qualifying matter assessment in those zones.
Okay, so those restrictions will already exist as
Yes.
part of any development in those areas, just in a different part.
Yep.
Thank you.
I mean, effectively, if I can characterize or try to characterize it, I mean, the first couple of matters that are QMs are basically matters that we have to have regard to anyway because of either 6, 7 or 8 or whatever they happen to be. But then there's a whole slurry, there's 5 or 6 matters that are QMs that in actual fact are not relevant basically beyond that point. Yeah. So we don't need to worry about open space for public use or the need to give effect to designations and so on with respect to policy 5.
There will be existing provisions in the plan that apply
That cover
to
those.
those areas, but
Yeah.
but we're not seeking to modify the MDRS as a result of those things.
No. And the reality is, as you've indicated, the policy doesn't give any direction as to density or height. So, I mean, that's an open book.
Yes. So that brings me to the end of policy 5, and I'll move on to deal with the MDRS. Again, I've set out the relevant provisions, but I'll go through them reasonably briefly. Section 77G1 requires that every relevant residential zone must have the MDRS incorporated into it. As the MDRS is mandatory, the council is not required to evaluate the MDRS under section 32 of the Act, and the panel does not have power to amend the MDRS except where a qualifying matter applies. So firstly, incorporation of the MDRS, it's defined to mean the requirements, conditions and permissions set out in Schedule 3A, and Schedule 3A consists of some mandatory objectives and policies, some activity rules for residential development and subdivision, rules regarding notification, and the listed density standards. Some further guidance is given in the Act, which clarify that, again, a council may create new residential zones or amend existing ones. They can include objectives and policies in addition to the mandatory ones to provide for matters of discretion to support the MDRS and to reflect any more lenient density standards. They can make the requirements of Schedule 3A less enabling of development if authorised to do so under section 77(1), which is of course qualifying matters. And they can enable a greater level of development than provided for under the MDRS by omitting one or more of the density standards or including rules that are more lenient than the density standards. In the next section, I've set out the definition requirements in respect of relevant residential zones. And at paragraph 6.9, I've recorded that the residential 1, 2, and 3 zones were identified as relevant residential zones. And I don't understand there to be any dispute about the identification of the correct zones. So turning then to incorporation of the MDRS in Plan Change 9, and I've set out there at paragraph 6.11 where the various requirements have been incorporated. They were, of course, required by section 88 to be shown differently and are shown green in the notified plan change. A large number of submissions have been received on these detailed provisions, and they've been addressed in the section 42A report and the addendum. And there are a number of amendments that have been agreed in those documents. And I've just referred to that updated set of the PC9 provisions that you now have. So the key issue for the hearing panel in respect of incorporation of the MDRS is whether and to what extent modifications are required to accommodate qualifying matters. So I've dealt with qualifying matters in a separate section, just recording at the outset that there are essentially 3 different types of qualifying matters. There are existing qualifying matters that are in the operative district plan. There are new qualifying matters that are notified in the IPI. And then there are other qualifying matters which require a site-specific evaluation under section 77L. So I'll address each group of qualifying matters separately. So firstly, existing qualifying matters. Section 77K provides an alternative evaluation process for existing qualifying matters, which recognises that these provisions have already been through a Schedule 1 process. Now, it is important to clarify in respect of existing qualifying matters such as SNAs, the consideration by the hearing panel relates to the extent to which the MDRS should be modified to accommodate the SNA. It's not an opportunity to assess the location or the attributes of the SNA, which has already been through a Schedule 1 process. As the district plan was largely operative when Plan Change 9 was publicly notified, a large number of the qualifying matters are existing qualifying matters, which are subject to the alternative evaluation under section 77K. And I've listed some of those there. Now, the one of the legal submissions circulated suggests that, in fact, we've just rolled over our existing provisions. That's not the case. They have all been reviewed to ensure that they are only modifying the MDRS to the extent necessary. And you'll see that where we feel that we've needed to, we've proposed amendments to them. And where amendments are proposed, we've identified those as new qualifying matters and given them the additional assessment that's required.
Just to check, I should have looked at this, but I can't recall whether I did. The SNAs, the existing qualifying matter was determined to be the outcome of PC3 or not? Or was PC3, which I think your footnote indicates was made operative? Oh, well, you've got one appeal relating. Well, made operative on 27th of March this year. So are the existing SNAs, the existing QM SNAs, are they the PC3 SNAs or are they the pre-existing SNAs?
All relevant SNAs in PC3 would have been operative in effect before notification of Plan Change 9. The only outstanding appeal related to a rural SNA.
Okay. All right. Good. So we don't need to lift.
So it was,
lift the
you can
carpet on
essentially treat the district plan as having been operative. So just turning then to new qualifying matters, and I've just set out at paragraph 7.6 the additional evaluation that's required under section 77J for these qualifying matters. And I will go through each of these in a little more detail. So the first one is the residential 3 zone. The residential 3 zone applies to 3 Māori villages at Ohirimutu, Whakarewarewa and Ngāpuna. Plan Change 9 seeks to modify the MDRS within the residential 3 zones as a matter that is necessary to accommodate a matter of national importance, being the relationship of Māori and their culture and traditions with their ancestral lands, water, sites, wahitapu and other taonga. In particular, the residential 3 zone contains separate standards which reflect the cultural values of the villages, including reduced maximum building heights, increased density, smaller front yards, and reduced site coverage. Overall, the provisions for the residential 3 zone reflect a different character, where buildings are generally smaller in scale, no higher than marae, but can be clustered together with less separation. And you'll find a really comprehensive and useful section of the 42A about those areas with photographs and good descriptions. Now, I submit the panel should approve the identification of the residential 3 zone as a qualifying matter for the following reasons. The council has engaged with the hapu of the villages as part of the development of Plan Change 9. No submissions have been received opposing the retention of the residential 3 zone provisions, and 4 submissions have been received in support. The provisions of the residential 3 zone already provide for high density development in a form and layout which reflects Māori culture and traditions. And table 13 in the 42A report provides a comparison of the various development standards. A section 77J analysis has been provided, and the evidence shows the retention of the residential 3 zone has only a minor effect on development capacity.
I mean, in the normal Schedule 1 process, of course, if no submissions have been received, it would go straight through the gate. Is there any reason why that we shouldn't adopt the same principle?
You still are required to be satisfied that we meet the additional hurdle of the qualified matter assessment in section 77J. Hence, we've provided that evaluation for you. But I have actually noted, just for completeness, that the same result could have been achieved by simply renaming the zone so that it wasn't a relevant residential zone.
In the interest of satisfying ourselves, in the section 32 report, there was a comment there. Iwi Hapu wished to discuss things further with council, and council commits to doing that. Is that the update that you've just provided us? So it's in the section 32 report talked about Iwi Hapu wished to discuss this further, and council was going to do this following notification of PC9. And are we able to assume that what you provided in your legal submission is that update? Like I was just left with a sense in reading it, there was still more conversation to go, but it sounds like that this is the outcome of those conversations.
Yeah, I think that's certainly the case because of the short timeframes associated with notification of the plan change. By notifying it as a relevant residential zone, it left all of the options open, right, so that those discussions could continue and different groups could put in submissions asking for provisions of the MDRS to apply if they wanted, or the opposite if they didn't want. It left all of those options on the table so that those discussions could progress. There may be some updates in the 42A and the addendum that are later, but otherwise we might be able to just provide an update. But certainly you've got the submissions and support.
Yes, sure.
And we don't have anyone seeking.
I just wonder, and so we're not expecting anything different like that, like anything additional, like. You know what I mean? It's asking the question another way. Should we be waiting for something more, or is this?
No, certainly the Section 32 report was way back in August last year, and it was accepted at that time that the discussions were continuing, and it was important to keep the options open so that they could consider whether or not there was any changes needed in those areas. But we aren't proposing any further changes. So we're essentially proposing that the existing residential 3 provisions continue to apply. And you'll see for yourself on your site visit that the character of those areas is substantially different, but it is still a form of high density, but in a different way.
And your legal submissions to us are that there's no impediment to actually not. I mean, it's not just a matter of reducing or modifying the MDRS, it's actually not applying the MDRS to a whole zone.
You could probably characterise it either way. We have intentionally included a table 13 of the 42A report, that identifies each of the density standards in the MDRS and shows you the equivalent density standard in the residential 3. It also, just out of interest, shows you the residential 1, so that you can see that in a lot of respects, the residential 3 standard is closer to the MDRS. It was already providing for higher density. So you can see those as modifying the MDRS rather than as as, I mean, whether you characterise it as not applying it or whether you characterise it as modifying each of those density standards, because that's the way that section 77I is worded, then that certainly you can characterise it as modifications.
And of course, the fact there's no submissions against it limits people's options anyway. So, yeah, all right. We just don't want to get stranded, that's all.
Okay, I'll deal with the next new qualifying matter, which is flood hazard. So Plan Change 9 proposes to modify the MDRS to the extent necessary to manage significant risks from natural hazards, in particular flood hazard. It proposes to do so by amending existing provisions in the district plan, as well as introducing a new restricted discretionary rule to allow specific assessment of development within areas that are susceptible to flooding. And in particular, it proposes to reduce the maximum site coverage for impervious surfaces in the residential 1 and 2 zones from 80 and 100 to 70 and 80% respectively, to clarify the rule and policy framework for minimum building levels in flood-prone areas, and to add a new restricted discretionary activity rule for new buildings where the anticipated flood depth at the site is more than 300 millimetres in a 1% AEP event, taking into account climate change based on RCP 8.5. And that rule is NH-R4, subsection 3. But Kim Smith, one of the 42A authors, will take you through that in more detail. The council's currently carrying out flood mapping on a catchment by catchment basis, and it's expected that this process will be substantially complete by the end of 2024. Once this process is complete, the council proposes to notify a comprehensive natural hazards plan change, which will review and update the provisions relating to flood hazard and geothermal hazard, which I'll address separately. However, it is the council's submission that the amendments proposed by Plan Change 9 are necessary to manage the risks to additional development enabled by the MDRS that may take place within areas susceptible to flooding, and to ensure that new development in these locations does not contribute to downstream flood risk. An evaluation under section 77J of the Act is provided, in particular as development within these locations is restricted discretionary, it's not considered to affect development capacity. There are a number of submissions received regarding flood hazard, including from both of the regional councils. Now, the evidence from the regional councils shows that, subject to some specific wording amendments, the regional councils support the approach proposed by Plan Change 9, and again that's shown in the legal submissions that have been circulated for the Bay of Plenty Regional Council. Just to clarify too that we do have the pleasure of submissions from 2 regional councils, but the whole of the urban extent of Rotorua is within the Bay of Plenty region. So just before we leave that topic, to deal with the implications of the Waikanae decision. So the new flood rule is considered to be a qualifying matter where it modifies the MDRS by making new buildings a restricted discretionary rather than a permitted activity. Outside of the residential zones, the new flood rule and the amendments to the existing rules are considered to be related provisions which are consequential on the MDRS or Policy 5. Now, as the new flood rule amends the activity status from permitted to restricted discretionary, it could be considered to be disenabling of development in a manner similar to the proposed waihi tapu in the Waikanae decision. Now, I submit that the new flood rule is not prevented by the Waikanae decision for the following reasons. Firstly, it doesn't seek to add an additional layer of protection to a specific location, as would be the case for waihi tapu or historic heritage, which are specifically scheduled in the district plan. Instead, development is still enabled in these locations, subject to appropriate mitigation of flood risk. Section 80E1B3, so that should be a little I, specifically recognises that district-wide provisions relating to stormwater management may be required as a consequence of the MDRS or Policy 5. And the new flood rule is necessary to ensure that new development is encouraged to locate in areas which are less susceptible to flooding, or that design measures are adopted to ensure that any risks are mitigated to an acceptable level.
We've had this discussion in other IPIs, haven't we, as to whether the threshold from permitted to controlled may be okay, but from controlled to restricted discretionary or restricted discretionary to non-complying is a threshold too far. Your submission to us is that permitted to RD is okay. Do you have where's your threshold for, or your tolerance for when it's not?
These provisions are required as a consequence of the intensification enabled by MDRS and Policy 5 in any event. And I don't consider that Waikanae should be extended to provisions that are related provisions that are consequential, because otherwise the related provisions in respect of stormwater management that are specifically provided for in the legislation would not be able to be used at all. It can't have been envisioned that it would apply to that extent. I can certainly see in respect of Waihi Tapu, in respect of historic heritage, which I'll come to, and certainly in some instances in respect of other, character clusters and things of that nature, then really you can only put your qualifying matter in between what the operative plan allows and what the MDRS would allow. But when it comes to district-wide matters that are required in consequence of intensification, whether that is transport, infrastructure, or natural hazards, it doesn't make sense to impose those types of restrictions at all.
Well, that's a suitable time for breaking. So we might take a 15. Within 15 minutes. Okay, let's get back close to 11, shall we? Thank you.
As part of the development of the plan change, Council engaged Mr. Markoma of Salmon Reed Architects to consider whether the additional development enabled by the MDRS and Policy 5 would have adverse effects on the historic structures that are identified for protection. As a result of that report, Plan Change 9 proposed a new rule which ensures that additional development on the same site as a historic structure will require consent as a restricted discretionary activity. In addition, in the case of the landmark restaurant, the rule proposed to extend that protection to the adjoining sites at 2 and 3 Mead Street. A number of submissions were received regarding the new heritage rule, including from Heritage New Zealand. The evidence from Ms. Byron on behalf of Heritage New Zealand considered each of the historic structures affected by Plan Change 9 and recommended that protection be extended beyond the site for a further 3 structures. Now, that evidence first became available to the Council as part of the evidence exchange on the 21st of July. So since then, Ms. Byron and Mr. Markoma have had further discussions, and they are now in agreement in terms of the level of protection that would be desirable. However, there are some limits in terms of what we can actually achieve in this plan change, which I'll just comment on now because both Waikanae and Clearwater come into play. Now, I submit that the application of a restricted discretionary rule to additional development on the same site as the heritage structures does not offend the Waikanae decision, and as it was notified in Plan Change 9, will not offend the Clearwater decision. This is because the new rule only applies to the additional development enabled by Plan Change 9. In addition, I considered that the extension of protection to the two sites adjoining the landmark restaurant also does not offend Clearwater or Waikanae for the following reasons. The extension of the rule to those two identified sites was publicly notified as part of Plan Change 9 and therefore doesn't offend the Clearwater tests. The landmark restaurant and the adjoining sites are actually in the commercial 4 zone, so they are not qualifying matters. And again, I've referred to the council's broad discretion under policy 5 of the MPSUD and in respect of related provisions which support or are consequential on policy 5. And it's my submission that for those reasons, the proposed rule doesn't offend the Waikanae decision. However, in terms of the request by Heritage New Zealand to extend protection beyond the site for a further 3 structures, we accept that in fact those extensions wouldn't meet the tests in Clearwater because they haven't been notified, and in particular, they haven't been specifically notified to those landowners. However, just as an added point, we have made the effort of getting the 2 heritage consultants together to actually reach agreement on the facts so that you don't need to get caught up in a whole lot of factual discrepancies in respect of matters which we actually can't address in this plan change.
I mean, I guess that could be cured if the parties on each side were in agreement for that to happen, but that obviously hasn't happened either.
Certainly the council and Heritage New Zealand may be in agreement, but as far as I'm aware, the landowners affected aren't even part of the process.
Yeah.
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 So just turning very briefly then to other matters. Any other matter which relies on section 77IJ will also be an existing or new qualifying matter requiring assessment, but it also has to meet the site-specific evaluation requirements in section 77L. Now, there are a small number of existing qualifying matters, such as notable trees, and they are evaluated in the Appendix 4. Similarly, site-specific considerations apply to the Pukehangi Heights and the Wharenui Rise development in areas. So some modifications of the MDRS are proposed in those areas to recognise site-specific features such as landscape values. And again, they're assessed in Appendix 4 in detail.
Just before you go on, could I get some clarification, not necessarily now, but on the spelling of Pukehangi? I've seen it written three different ways in the document. Pukehangi, as it says, or Pukehangi.
Is that something that we can clarify straight away, or do we need to?
Just that's not urgent.
Yeah.
Just, but I don't want to be accused by my te aroha whānau of misrepresenting the name
No,
when
we'll
the
certainly
decision is
check on that
written.
one.
Thank you.
No problem. So just then turning to requests for new qualifying matters, this is where a submitter has requested a qualifying matter. We do have a submission by Kiwi Rail seeking a 5-metre setback adjacent to the rail corridor. The council's section 42A report didn't accept the submission as no evaluation of the qualifying matter has been provided under section 77J. And probably more to the point, there's no evidence regarding the need for the setback when this particular rail corridor has, as I understand it, been unused for decades, or evidence about the extent of the effect on residential land.
But it might be used over the next 30 years.
So evidence has been circulated by Ms. Grinland and Hancock on behalf of Kiwi Rail. However, it still doesn't provide the evidentiary basis for that qualifying matter assessment. We have just clarified there, though, the council accepts that the rail corridor could be a qualifying matter. There's no issue with that. It's just in this case, there's no evidence that the MDRS needs to be modified. Similarly, First Gas sought a pipeline corridor alongside transmission gas pipelines and strategic distribution pipelines. But again, there is no qualified matter evaluation or in fact any evidence as to where these corridors would apply or the extent to which they affect the residential zoned land. So dealing separately with related provisions, which I did just mention a while ago, but the specific provisions which Plan Change 9 proposes, which support or are consequential on the NDRS or Policy 5, are amendments to manage significant risks from geothermal hazards, additional standards and assessment criteria to ensure a high standard of urban design, amendment of the minimum vacant lot size, and amendment of the district-wide transport and infrastructure provisions of the district plan. And I'll just address each of those briefly. So firstly, geothermal hazard. The plan change proposes consequential amendments to manage significant risks from geothermal hazards. As geothermal hazards are already regulated to some extent under the Building Act and the Council's geothermal bylaw, the Plan Change 9 provisions have been carefully drafted to ensure that they are not less enabling of development than the NDRS. And for that reason, we've categorised them as related provisions rather than as qualifying matters.
On that one, if we were to find differently to that, for some reason, I'm not suggesting we will, but that they were less enabling, is there room then to bring them in as a qualifying matter?
Yes, there certainly is, because it's something that I had to think about at length, because in fact, if you're only allowed to modify the NDRS to the extent necessary. If you do such a good job of minimising your modification, it's no longer a qualifying matter. It actually drops out to a related provision. So you're absolutely right. If there is some degree of modification, then you'll flip back into qualifying matter. And you'll see in the submissions that some people do think it would be better to be a restricted discretionary activity. At the moment, we're proposing it still to be a permitted activity. It just has a development standard, but I don't think there's any particular magic in the way that it's categorised, and certainly the assessment that the council has done would be sufficient for either option. So the notified version of Plan Change 9 proposed a new permitted activity standard which applied to sites within the geothermal systems overlay, which required any venting structures necessary for gas ingress mitigation be directed to vehicle access ways or the street. Now, there were submissions by the Waikato and Bay of Plenty Regional Councils seeking a new permitted activity standard which requires for new buildings and additions to buildings in the geothermal systems overlay that a report be provided by a suitably qualified and experienced person which addresses the geothermal hazards on the site and the measures to mitigate those hazards. And that proposed rule with some modifications to the wording has been accepted in the Council's 42A report, and it is NH-R8. You'll see that there have been some ongoing changes in the addendum to the specific wording, but again, the Bay of Plenty Regional Council's legal submissions indicate that they're generally in agreement with that approach, subject to some minor wording amendments. So I've just noted in paragraph 8.6 that there were also submissions seeking that we extend that rule beyond the geothermal systems overlay, but it's considered it more appropriate to do that in the context of the future natural hazards plan change. So finally, I've just submitted there that the new geothermal rule doesn't offend the Waikanae decision, as it doesn't change the activity status of development within the geothermal systems overlay, and therefore isn't more restrictive. It essentially provides an additional information requirement to ensure that geothermal hazards are identified and that design takes that into account. So just turning then to urban design standards, and the council has, in allowing for additional intensification, gone to quite some effort to try and ensure that that intensification does show good urban design. So along with providing for intensification, there are some additional standards and assessment criteria to ensure a high standard of urban design. And in particular, as I've noted previously, new buildings and external alterations to buildings in the city centre and commercial zones are proposed to require consent as a restricted discretionary activity, with that discretion focused on matters of urban design. There are also additional standards relating to building length, minimum dwelling size, landscaping, open space and fencing proposed to apply to residential development in the Res 1 and 2 zones. And just noting on that topic that Kāinga Ora have suggested that we can't have additional standards. We of course can have additional standards, and there are lots of them. We just can't have additional density standards, which are defined in section 3A. So provided that they are not density standards as defined, we can certainly include additional standards in the plan. And then finally, assessment criteria are proposed to guide assessment of applications for 4 or more residential units. Now, the MDRS does require that to be a restricted discretionary activity, but it doesn't provide any assessment criteria. So I've just noted that there are a number of submissions on those detailed provisions, and they have been addressed in the section 42A report and the addendum. So just turning to the issue of minimum vacant lot size. And really, I'm just wanting to provide some explanatory material at the outset. So firstly, clause 8 of schedule 3A of the Act requires the plan change to provide an exemption from minimum lot size, shape size, or other size related subdivision requirements for essentially subdivision around existing residential units or subdivision which is occurring concurrently with land use. In addition, clause 7 provides that any subdivision provisions must be consistent with the level of development permitted under the other clauses of the schedule and provide for subdivision as a controlled activity. So the exemption that's required by clause 8 is provided in the subdivision provisions of Plan Change 9. In addition to that, the notified version proposed to amend the minimum vacant lot size from 350 square metres to 250 square metres. A number of submissions were received relating to the vacant minimum lot size, and in particular, Kāinga Ora submitted that the plan change should contain no minimum lot size in the residential 1 and 2 zones, and that instead a shape factor of an 8 metre by 15 metre rectangle should apply. You will see from the Council's reports and evidence that the options regarding vacant lot size have been carefully considered by the Council's experts in the Rotorua context. In particular, there are 3 ways in which development might take place. So first, construction of dwellings may proceed or be concurrent with subdivision. This type of development is more common in the larger tier 1 markets such as Auckland, Tauranga or Hamilton, but is currently less common in Rotorua. And it's this type of development that is exempt as a result of clause 8 of the schedule. So we don't need to worry about that type of development when we're looking at the minimum vacant lot size. Secondly, subdivision and sale of a lot from an existing title within the urban area with development to take place by the purchaser at a later date. The evidence of Ms. Fairgray is that this is the most likely form of development within the Rotorua urban environment in the short to medium term. Thirdly, subdivision and sale of multiple lots as part of a greenfield subdivision or subdivision of a large lot within the existing urban area. At present, there is provision for greenfield development at Pukehangi Heights and Wharenui Rise, and in addition, there are a number of larger lots within the Rotorua urban area. The council has carefully considered the type of subdivision that is likely to take place within Rotorua within the short term, medium term, and the long term. The evidence shows that in the short term, it's important to enable subdivision of existing lots within the urban area, as this will enable the creation of smaller lots and smaller dwellings, which will assist with both housing supply and affordability in the short to medium term. So for these sites, having no minimum lot size will provide more flexibility for existing sites to be used for infill development, while applying a shape factor will ensure that a complying development can be constructed on the site. However, for subdivision of greenfields and larger sites within the urban area, pursuing the greatest return on the subdivision may lead to the creation of as many small sites as possible, which would potentially preclude the development of attached housing typologies on these sites in the future. And for that reason, we are still proposing a minimum site size of 300 square metres to lots greater than 1,400 square metres. And the specific provisions that are proposed and a comprehensive Section 32 analysis are set out in the addendum to the 42A report. And the way in which those provisions would apply to the two types of subdivision, infill versus greenfield, will be discussed in more detail in Ms. Fairgray and Mr. Wallace's evidence. But the key thing to keep in mind is that all of these options are enabling. They all enable more subdivision than is currently the case. It's simply a matter of making sure that the specific provisions are going to work in the Rotorua context. So just in terms of transport and infrastructure amendments, I've just noted there that there are consequential amendments required to those sections of the district plan, and they've been considered in the council's 42A report. So I'll just turn briefly to Papakainga. Section 80E1B2 specifically provides that an IPI may amend or include provisions to enable Papakainga housing in the district. The Rotorua District Plan already contained existing provisions for Papakainga and Kaumatua housing. However, following engagement with iwi and Hapu, those provisions were proposed to be amended, particularly to remove the requirement for Papakainga to be located on land adjoining a marae, to amend the provisions for Papakainga in residential zones to be consistent with the MDRS, to enable a greater density of Papakainga development in rural zones, and also to enable non-residential activities forming part of Papakainga development, subject to appropriate performance standards relating to scale, which would be scale and intensity. There are a number of submissions that were received on those provisions, and a number of amendments have been made in the Council's 42A report and in the addendum. And I submit that the final provisions recommended by the Council's reporting officer will enable Papakainga development in residential zones in a manner which is consistent with the MDRS, and will enable Papakainga development in the rural zones in a manner which reflects Māori culture and traditions, while adequately mitigating potential effects on the rural environment.
Are there any scope issues around Papakainga provisions? I mean, it's a very general, I mean, obviously there's the IPI scope. I mean, that's obvious, but the enablement of I'm just trying to hook up 80 here, just whilst I'm reading. I mean, there's no real indication in the legislation as to what is and isn't or how far one might go in terms of that?
No, there definitely isn't. It's got its own subsection. It clearly relates to the district, so it's not limited to the urban environment in the same way that the Policy 5 provisions are. So certainly it's been applied across the district. The fact that it uses enable will actually, I suggest, affect scope in the sense that you couldn't do something that was going to disenable Papakainga housing. So we certainly need to make sure that our provisions are more enabling than the previous provisions. But aside from that, I think those will be the only limitations on scope.
Yeah. All right.
So the next section is financial contributions. And again, this is a separate subsection that enables councils to review its financial contribution provisions as a discretionary element of an IPI. And interestingly, the Amendment Act actually adds some new sections into the Act, which weren't previously there and which now presumably have general application to all councils. And that's simply recording that the purposes for the financial contribution need to be in the district plan, the level of financial contribution and when it will be required. And also it enables the taking of financial contributions for permitted activities, which of course is important in the IPI context because it creates a lot more permitted activities. So Plan Change 9 proposed only very minor amendments to its financial contribution provisions. It is not a complete review. They are very specific amendments relating to reserve contributions. And I've set that out in paragraph 10.3. It proposes to reduce the reserve contribution payable from 5% to 3.5% for most zones and to 2.5% for rural zones. And it does extend the taking of reserve contributions to permitted activities. Now, a number of submissions were received in support of those proposed amendments to reserve contributions. However, there were also some submissions received in respect of financial contributions that are not proposed to be amended by Plan Change 9, particularly those relating to infrastructure. Now, I submit that those submissions are out of scope of Plan Change 9 as those provisions were not proposed to be amended and hence were not included in the notified plan change or in the Council's Section 32 report.
So on that, you're relying on an orthodox reading of Clearwater and Co.
Yes. Yeah. So just turning now to some specific requests from submitters. And at the outset, I note that the following submissions don't fall into any of the sections of these legal submissions relating to mandatory or discretionary elements of an IPI. And my primary submission is that they are out of scope. And I'll deal with that aspect first before I deal with the substantive submissions. So the particular submissions that I'm referring to are those that seek specific activity rules for certain categories of activities. So firstly, the Retirement Villages Association, who seeks specific activity rules relating to retirement villages. Department of Corrections, who's requested rules for community corrections facilities. The Ministry of Education in respect of education facilities. And the Ministry of Housing and Urban Development in respect of community housing. So just dealing with the issue of scope first, in my submission, these submissions are out of scope of Plan Change 9. In respect of the matters in Section 80E, the inclusion of activity-specific provisions and or policies are not related matters which support or are consequential on the MDRS or Policy 5. Now, both the MDRS and Policy 5 are focused on heights and densities. They're not focused on specific categories of activities. And those categories are not proposed to be changed and are not specifically assessed in the Council's Section 32. So, and that brings me on to the first limb of Clearwater. The public notice and the Section 32 report didn't consider changes to essentially the management regime for those sets of activities. And hence, in terms of the second limb, people who are interested in those types of activities, and certainly you'll be aware of the level of interest in community housing, will not have become involved in this plan change. And I have just referred you there to the recent decision of the hearing panel for Auckland Council's IPI, which expressed their preliminary view that these specific activity requests are not within the scope of an IPI. However, in the event that the panel finds that they are within scope, we have considered the substantive submissions as well.
I guess the difference with the Auckland panel one there is that they are talking about poles 3 and 4 rather than pole 5.
The legal submissions for RVA in particular, and in fact for the Department of Corrections, they've all categorised their relief as being related provisions which support or are consequential. So I'm not sure that it would make, certainly they're running the same argument whether it's consequential on policy 3 or policy 5. Interestingly, they've suggested that Clearwater may need to be applied differently because of the mandatory requirements of the IPI. But of course, the mandatory requirements are only policy 5, excuse me, and the MDRS. If their changes are categorised as related provisions, those are not mandatory, those are discretionary. So Clearwater should still apply. So just dealing firstly with retirement villages.
Just close it off in my own head. So what you're saying is if a related provision can't be demonstrated to have a very clear nexus to height and density, then it's not on.
Yes, so there's two issues there. That to be satisfied that they are related provisions that support or are consequential on the MDRS or policy 5, yes, they're going to have to show you that giving effect to policy 5 necessarily includes the relief that they are seeking. But in addition to that, even if they are able to show that they are related provisions, they are still going to need to comply with the Clearwater tests. So nobody else knew that we were going to be considering community housing or retirement villages or education facilities as part of this process. So there's a number of different steps that would need to be satisfied to get through the scope.
In order to get past limb 1, it has to relate to height and density.
Yes.
But limb 2 is a whole different ballgame. Yes. That's fine.
So just looking at retirement villages first, and you may be familiar with similar requests from retirement villages and other IPI settings, but they're essentially seeking a specific policy and rule framework for retirement villages, that they be recognised as residential activity and be identified as permitted, that the construction of the villages be restricted discretionary, and that they have a range of supporting objectives and policies. Now, I've recognised that the incorporation of the MDRS in the sense of the changes to the heights and densities will already benefit the retirement villages alongside any other type of activity, because the incorporation of the MDRS into the Res 1 and 2 zones provides for greater heights and densities of development. It also enables the construction of a range of housing typologies not previously provided for, and it comes with it a set of objectives and policies which specifically provide for a range of housing typologies which recognise the varying needs of the population. So without having to specifically single out retirement villages, it already contains broad policies that would enable consideration of a whole range of different sectors. However, the Council's Section 42A report has recommended a number of amendments which will better recognise the particular features of retirement village development, including amending the definitions, providing for rest homes in a manner consistent with the NDRS, as well as those supporting policies, standards and criteria. There are still some specific issues that aren't agreed, and those will no doubt be identified by the retirement villages. In terms of the community corrections facilities, the request is essentially that these activities be provided for as permitted activities in the specified zones. And I've set out for you that the district plan already provides for community facilities, which would include community corrections facilities in those zones in a range of different ways. Essentially, the council submits that community corrections facilities are already appropriately provided for in the district plan. The submitter's evidence is that community corrections facilities can vary significantly from service centres to community work facilities, and it's therefore appropriate for a resource consent to be obtained to enable management of these effects. In addition, the evidence explains that community corrections facilities are a unique activity only administered by Araputama, and that there is already a facility in Rotorua. So it appears unnecessary for the activity to have a specific management regime for it in the district plan. And essentially, the submitter hasn't provided an assessment of the potential effects of these activities to support the relief that they have sought. So in terms of education facilities, the submission by the Ministry of Education requested education facilities up to 200 square metres as a permitted activity in the residential zones. At present, they're provided for as discretionary activities, and the Council's Section 42A author considers that that status is appropriate because of the potential effects of that type of activity, particularly in terms of acoustic lighting and transport effects. In terms of community housing, again, there were a number of submissions in respect of the definition and rules relating to community housing, particularly in respect of the Ministry of Housing and Urban Development. I've included the current definition of community housing, and it's currently restricted discretionary or discretionary. It does vary between the zones, as you'll be aware. Essentially, the Council's Section 42A report considers that, as evidenced by the recent resource consent hearings relating to emergency housing, community housing can have a range of effects on the environment which require consideration, and we therefore consider that it's appropriate to retain the current definition and activity status. And certainly there's been no detailed planning evaluation provided which would justify a change to that status as part of this plan change. So finally, the rezoning requests. There are a small number of submitters requesting that land currently zoned for other purposes be rezoned to residential 1. Now, we accept that this is within the scope of an IPI. We could have rezoned land as part of the IPI. However, where the council did not do so, we consider that they will be out of scope because they won't meet the tests in clear water. In addition, in respect of the majority of those requests for rezoning, there are no Section 32 assessment or supporting technical reports being provided by the submitters. I have dealt in more detail with the request for rezoning by Somerset at 171 Ferry Springs Road, and that's because they have circulated some evidence in support of that rezoning request. Now, that seeks specifically to rezone a 14-hectare site from commercial 5 to residential 1, and the site is currently the subject of a referral under the Fast Track Consenting Act for the development of a retirement village. Now, I do submit firstly that it is out of scope of Plan Change 9 because it wasn't publicly notified as part of the plan change or assessed in the Section 32 report. And certainly the size of that site I suggest that it can't be considered consequential or incidental. But in any event, we consider that the submission should be rejected as no technical reports relating to Three Waters or transport infrastructure have been provided, and no structure plan has been provided as required by the regional policy statement. Now, the evidence of Ms. McKee on behalf of Somerset does attach many pages of documentation relating to the referral request. Now,
as I will tell her in due course, I have no interest in reading her fast track application.
So essentially my submission in respect of that volume of documentation is that it relates to development of the site for a retirement village. No assessment has been made of the appropriateness of the site for medium density residential development that would be enabled under the residential 1 zone. And as acknowledged by Ms. McKee, the technical reports in support of the resource consent application are not yet available. However, again, these reports will consider the potential effects and servicing requirements of a retirement village rather than the extent of residential development that could occur if the site were rezoned. And finally, we've acknowledged there that the site has been identified for potential rezoning to residential 1 as part of the draft SDF, while acknowledging that it is, of course, still a draft. But nevertheless, technical reports and structure planning are still required to support the rezoning in the district plan. And of course, you've experienced the level of reports and analysis that were required to justify the rezoning of the Pukehangi Heights area, and certainly we haven't met anywhere near that level of information. So I've set out the evidence that we have circulated and will present to you. I am proposing to ask the 42A authors to present first, because there is a lot of detail in this plan change that they will be able to describe to you, and we will use some visuals and things just to assist in that process. And I think that'll make it much easier for you to do your site visit tomorrow as well. We do have a couple of availability issues today. We unfortunately have one person who is ill, Ms. Fairgray, so she won't be available to present her evidence today, and we're hoping that she will be available tomorrow. In addition, Mr. Peddington is not available until tomorrow. He's got a very short statement, so we don't see that as an issue to have that tomorrow. But certainly we will try and get through as much of the rest as we can today.
Thank you for alerting us to that. And I mean, yes, I mean, you've done obviously a comprehensive summary of where things have got to, so we won't need all of that repeated again by other witnesses, so that's very helpful. Thank you. We might, we'll have, over lunch, we'll have a conference as to whether or not we need to see Mr. Pennington at all, and it may well be that we don't actually, because the issues are very clear in terms of what he addresses, so we'll
Thank you, that would be helpful.
Yeah, but clearly, we want Ms. Fairgray to be in fine fettle when she comes. So if there's any doubt about that, then we can put her off for several days if we need to. That's fine.
Thank you.
Yeah. So on you go.
Yeah, thank you for your summary of your legal submissions. There's 3 matters I'd just like to ask you about. Just like to take you back to the legislation initially, section 77I. You got that in front of you?
I do.
Yeah. So in the very first line of that, where it refers to the MDRS, does that refer to both the specific standards in Schedule 3A Part 2 and the spatial extent to which those standards are applied within the district?
So the MDRS is defined, and it's defined to mean everything in Schedule 3A.
Yes.
Yeah, so it extends beyond the density standards to all of those provisions that are required to be inserted.
I'm just interested in terms of the qualifying matters issue, which you've explained in some detail, and it's different for a Tier 2 authority. Does that relate solely to amending the Schedule 3A Part 2 standards, or does that enable the spatial extent to which those standards are applied in the district to be modified as well?
The MDRS can only apply to relevant residential zones. So
Yes,
any
but if-
modification of them would also need to only apply to the relevant residential zones. So
yes.
the QMs will only apply to the relevant residential zones. There might be related provisions that go beyond those zones.
Well,
but
let me
they
ask
won't be
you a more
qualifying
specific
matters.
question. If a qualifying matter, for example, was an existing flooding risk, would the application and the medium density residential standards are to be applied to residential zones? If that flooding risk applied to a residential zone, would that enable council or for us as a panel to say, well, the MDRS Schedule 3A standards should not apply in that spatial area where the flooding risk exists?
It will only be a qualifying matter within the residential zones.
You're even not understanding my question.
Yeah,
I'm
I'm
not
sorry.
asking it properly.
Yeah. So we do have a flood rule that applies across multiple zones,
Yeah.
obviously, because flooding doesn't know what zone it's in. But and it's required, obviously, to meet the requirements of Section 6, plus, in fact, the requirements of the Regional Policy Statement, and that's made really clear in the Regional Council's legal submissions. In respect of the residential zones, we have to complete the additional evaluation required by Section 77J. So that will only apply in respect of those residential, but we can still have the same rule applying elsewhere. It may well be that in the process of doing that Section 77J evaluation, that there actually needs to be changes to the rule as it applies in the residential zone. We haven't suggested that that's the case here, but that could conceivably be the case, and that those changes would only apply within the residential zones.
I'll leave it there. 77K. So 77K, just make sure I understand this, what you're telling us, that applies to existing qualifying matters that are already in the district plan, of which a flooding map might be an example of one. Correct?
There are some existing flood rules in the district plan,
Yeah.
yes.
And so under 77K, 1 subclause B, we could specify an alternative density standard. So would that mean an alteration to the Schedule 3A standards that are set out in the legislation? Is that what that clause means?
Yes. So where you're proposing to modify the MDRS, you need to identify what the alternative is. So, for example, with the flood rule, the MDRS would allow a permitted activity, and our rule would allow a restricted discretionary activity. So that's the alternative. It actually isn't. Some of the qualifying matters lend themselves to referring to specific changes, like, for example, height, but others are actually just a change in activity status.
So I'm just focusing on the words I specify the alternative density standard. So if I just look at rule NHR4, for example, which I think relates to the flooding.
Yeah.
Where in that rule does it specify the alternative density standard? It doesn't appear to do that to me.
No, and this might be clearer if you have a look at the Appendix 4, which has got the qualifying matter assessment, because it goes through each of these headings. But for that particular qualifying matter, there isn't an alternative density standard. It's that the way that it modifies the MDRS is to change activity status, keeping in mind that the MDRS is not just the density standards, it's all of the requirements in the Schedule 3A.
So the fact that 77K1, the first part of that ends with the words do all of the following things. The fact that that rule doesn't do that, where does that leave us?
Well, we're only modifying the NDRS to the extent necessary to accommodate the qualifying matter. If we actually don't have to change the density standard, that's better, not worse. So we're still enabling the same heights and densities in those locations. The same performance standards will apply as applies to the rest of the zone. The only change we've made is to require a restricted discretionary activity application so that we can assess the flood risk, and that's specifically identified in the criteria. So if you like, it's not a qualifying matter to the density standards of the NDRS. But Section 77I goes further than that. It talks about any modification of the NDRS. So we've interpreted that broadly and identified for you any modification of any of the rules of the NDRS, including activity status.
And I just wanted to ask you about this issue of the minimum lot size in relation to the building square. And first question, how many building squares need to fit within a minimum lot?
Sorry, can you repeat that?
How many building squares, whether the building square is 8 by 15 or 10 by 17, so how many of those need to fit within a minimum lot?
Oh, Mr. Wallace will go through this in more detail for you, but the shape factor is actually based on one dwelling. As he'll explain, you could construct one detached dwelling or in fact 2 attached dwellings, but certainly it hasn't been designed to allow 3 dwellings. And remember, this is just an option. This is not what you have to do. This is making it more enabling for infill subdivision that is more likely to consist of a single detached dwelling.
And just remind me, where do I find the rationale for the 300 square metres?
Ms. Fairgrave has given evidence about why 300 would work better for those larger sites than the 250 that was notified.
No, her evidence doesn't explain why 300. She just says she supports 300, but where's the rationale for 300 as opposed to say 360 or 320 or 350 or some other number? Who does that?
It should be in Ms. Fairgrave's evidence. If she hasn't gone as far as having a look at some of those other options, then I suggest that we ask her that question and she can work through that. I imagine in terms of she would have been looking for the lowest, the closest to 250 that works, as opposed to going higher like you've suggested. But essentially her view is that the 250 is too small and might actually preclude future attached dwellings on those sites, which is her primary concern in terms of the long-term use of the sites.
So Ms. Fairgrave can explain why 300 when she comes.
She would explain, that's right, why she thinks 300 is a better minimum than 250, which is what's currently proposed.
And how that relates to the various building square dimensions, whether it's 1, 2 or 3 dwellings.
Yes. Yeah.
All right, thank you. That was all. Thanks, Dave.
Just a couple from me at this stage. This relates back to the Section 32 report. Just a little bit sensitive was where I do a lot of my work in the Waikato catchment. There's reference made to Te Whaimana being a qualifying matter, and it's mentioned no further. From the maps, of course, it seems well outside of the Waikato River catchment. Am I correct in that?
Yes, that's my understanding too.
Cool. There is a reference to your letter from R. Morrison from the Ngāti Whakaue tribal lands, and as it wasn't a submission, it's not considered further in the Section 42A report. So we just accept that as a panel, like we don't need to consider it any further ourselves, but we don't have a copy of the letter. It's on page 168 of the Section 42A report. just checking, that's all, is that,
Okay.
it's referenced and then not considered any further because it wasn't a letter. I just want to make sure that we ourselves aren't at risk by adopting that position, please.
Yes, we can check on that.
Okay, there's a couple in relation, one in relation to the historic heritage and also that public kind of definition. In terms of the historic heritage, there's a recommendation to accept effect of place in caps over setting as a result of the submission from kind of order. I was just wondering if there are, whether the term extent of place, if we were of a mind to adopt that, recommend the adoption, needs to be defined so that there's no unintended consequences of what extent of place means as it relates to those sites. That's one. And then the second was in terms of the recommendation to adopt the Papakainga definition as presented by Kainga Order. Does that have any other consequences throughout the plan in terms of if we adopt it here for the PC9 matters? Is there other things like the chair has also noted Papakainga housing is defined in the district plan? So we just want to make sure that if we were of a mind to support that recommendation, that we're not creating unintended consequences.
Yeah. Yeah, thank you. We'll check on those.
Thank you.
Just in terms of the earlier question and about either amending the Schedule 3A density standards or looking at the spatial extent to which they're applied within the district. Maybe if I use another example rather than flooding. So if we have, for instance, the NDRS had been applied over an area of land that currently contained a marae or another building of significance to iwi, would the application of, say, Part 6 matters enable us to say, no, it shouldn't apply to that bit of land as a qualifying matter?
To say that the MDRS shouldn't apply.
That it shouldn't be upzoned to allow MDRS scale activity to occur.
Yes, that would be modifying the heights and densities in the MDRS to accommodate a qualifying matter, which you've identified as being a matter of national importance.
But my specific question is, would we then be entitled to, in a spatial context, just remove that upzoning from that area, or would we have to specify alternative heights and densities? Do you see the difference between saying they don't apply at all, or we're just going to tickle them a bit?
That's right, and that's the question that Commissioner Hill asked earlier too, as to whether or not what we're doing is not applying the MDRS or whether what we are doing is modifying the MDRS. And we can do either. The way that Section 77I is worded suggests that we're looking at modifications. So we have set out in the table the way in which the various density standards are modified in the residential 3 zone. So certainly they can be assessed as individual modifications.
And so not applying the MDRS as well, is that just an extreme modification? If we were to say there was a particular bit of land, I'm not thinking within the Res 3, I'm thinking within the Res 2 or 1 area. If there was a specific bit of land that for whatever reason under Section 6 of the RMA, we thought it was inappropriate to upzone it to enable medium density type development, would we be entitled to do that under the provisions of the Act? That's why I talk about a spatial extent.
Well, yes, you would, but your Section 77J assessment will necessarily require you to justify each of those modifications. It may not be possible for you to just justify them globally. You will still need to go through the process of identifying why the heights and densities aren't appropriate in that location because of that additional gateway required for qualifying matters. But certainly the outcome might be that you don't apply the heights and densities of the MDRS to a specific location.
All right, just going to write down yes. Okay.
Full, maybe for the 42As, I'm not sure, to just run us through table 13, I think it is, you referred to in the section 32, was it the comparative table?
Yeah, certainly.
Just a couple of lines on that, just to make the point. It would be quite helpful to whoever can do that, and not necessarily now, but course of the day.
Right, so you'd like to start with the section 42A authors? Yes, and I'll ask Rachel Morgan to bring all of her here forward. It is, you get used to it after a while.
Right. Oh, it's good afternoon now. So good afternoon, commissioners.
Thank you. And I understand you can take us through are you taking us through a PowerPoint or something, or some sort of?
It's a bit of a
presentation?
combination. So I've got a bit of a summary statement here, and then I've got a few slides to talk to as well.
I mean, clearly, we don't want to go back to zero and come all the way forward again. So take that guidance.
Yes, yes. So I've really just focused in on the key matters. So the heights and densities, the policy matters, which have been discussed with Ms. Embling this morning, and then talking through some of the other key highlights. But certainly won't be going through all the detail of the Section 42A report. Yes. Right, so just before we get into the detail of it, I have prepared a summary of the provisions, which I thought might be helpful for you. So that summary really just compares the provisions in the operative district plan as they were proposed in the notified plan, and as they've been proposed to be amended through the 42A report, and that covers the residential zones, the city centre and commercial zones, as well as subdivision. So hopefully that's a useful summary.
Also, just check in your right-hand column, section 40A version, is that the first version? That's not the amended version.
That is the latest version, and then the further changes in the 42A addendum are highlighted in red.
Thank you.
It did get a bit repetitive otherwise, so hopefully that's clear enough. So in terms of my summary, I thought it would be useful, and please feel free to speed me up if you feel like you're across this. I thought it would be useful just to provide a bit of an overview of the overall approach to the heights and densities, talking through the zones and the zoning framework just briefly, and then talking through the policy context and the approach to policy 5 and the heights, a little bit on the creating quality environments and the approach to urban design. I will talk about the residential 2 zone and the need for it itself, and also the proposed extent. And I'll also talk to some of those more detailed residential design standards in the zones that I propose, and also subdivision and some commentary on the additional activities as well. I'll try to talk very quickly. So just in terms of the approach to the zone, so up on the screen here, you can see just a summary of the zone extents and the heights that are proposed. And just very quickly to talk through those, the City Centre 1 zone, which you can see is the area in purple up on the screen. That's the core city centre area where a vibrant and diverse range of activities are provided for and sought in the operative district plan. As I'll talk about a little bit later on, this is the most accessible location in Rotorua, reflecting its proximity to services and amenities. And in response to that, Plan Change 9 proposes that 32-metre height limit, which is an increase from the 20 metres under the operative. The City Centre 2 zone is located to the immediate south, where it says 24 metres. That is the Rotorua Central Mall site. It's accommodated, or it accommodates a range of retail type activities in a typical mall complex. And a 24-metre height limit is proposed. That is a change from the operative where there is currently no height limit in that area. The City Centre 3 zone is the area in the north, which is shown in green, and that's the lakefront area on the northern side of Whakaue Street. And a 24-metre height limit is proposed there, comparing to the 20 metres under the operative plan. The Commercial 6 is the other key commercial zone around the city centre, which is, I'm not sure if we can get the arrow there, but it's just on the western side of Amaho Street, which is that trade centre. And that provides for a range of large format retail activities, and that 24-metre height limit is proposed in that area, as well as residential above ground floor level. The Commercial 4 zone is located along Fenton Street and Lake Road, and the district plan intends these to be the key entrance ways to Rotorua from the south and the west. And in response to that, tourist accommodation and residential activities are currently provided for, which this plan change isn't amending. And the plan change is really focused on increasing the height and providing for those supporting design related provisions. And then very quickly on the commercial zones, the Commercial 1 zone is the commercial centre in Nongataha, and that is located in the northwest of the city, and it will continue to have an important role in the future, serving that community in that area, as will the Commercial 2 zones, which you can see in green, which apply to the centres of Owhata, the Tenai Centre and West End as well. And a 20-metre height limit is proposed in those areas. And then the Residential 2 zone, which you can see there in orange to the south of the city centre, that's the high density residential zone. And I'll talk about that a little bit later, where that 22-metre height limit is proposed. So I do discuss the rationale for these heights in a reasonable amount of detail in various places in the Section 42A report, and I can provide references to that if you need that. But briefly, just to summarise what I think are the key policy matters and the overall height strategy. So in terms of the policy context, the MPSUD and the MDRS do direct a significant step change in the approach to enabling development as a means of achieving that well-functioning urban environment. And that step change, I think, is particularly significant in Rotorua, which is a Tier 2 city. So it is quite distinct from the Tier 1 cities. And that's particularly the case given that medium and high density development isn't a particularly well-established building form in Rotorua at this stage. So in terms of the MPSUD, the policies that are particularly relevant, and Ms. Embling has covered these already, is Policy 1, Policy 2, Policy 5 and Policy 6. And it's really important from my perspective, in my view, to read those policies as a whole. And collectively, I think they have a longer term focus and seek to enable housing and business choices, promote good accessibility, enable competitive land markets and support reductions in greenhouse gas emissions, which that compact urban form and greater heights and densities can assist to achieve. Policy 6 supports that and assists to implement it. Implement that change by allowing us to focus on that planned urban built form, and recognising that changes to give effect to that may detract from the amenity values of some people. So that policy 6 is really contemplating that change in my view. Policy 5 is of course particularly relevant, and Commissioner Hill, you've raised some questions on this already with Ms. Embling. So just to refer to that, it's quite different to policy 3, although there are some similarities. It talks about enabling heights and densities of urban form commensurate with the greater of the level of accessibility or relative demand for housing in a particular location. And I did myself grapple with what relative demand actually means in the context of this policy. I have found the MPSUD intensification guidelines particularly helpful in interpreting this policy. I acknowledge, though, that they don't have statutory weight, but they have been quite helpful. And I might just refer to those quickly now, if I can. So this is the MPSUD guidelines on understanding and implementing the intensification provisions for the MPSUD. And section 653 of those guidelines talk specifically about determining relative demand for housing and business use. And it has quite a helpful bullet point list. It says, in preparing intensification plan changes, some principles or types of areas where demand is often high and intensification is likely to be appropriate could include areas with high land prices relative to others, locations close to open space and recreational opportunities, areas within or close to centres, and there's the list goes on. Excuse me. And it also talks about and gives some guidance on the methods that would be appropriate to use in determining areas of relative demand. And it talks about using land value data as an indicator of where people may want to live. And it also talks about analysing recent resource consent data to highlight areas where there may be high demand or that may be market attractive. So reading that and applying that in the context of policy 5, I think what policy 5B is really getting at is a spatial understanding of areas that are market attractive or areas where there might be demand for the market to provide housing in the future. And that is quite distinct from, in my view, from policy 2 and other references to demand, which are more about how much housing is the city expected to accommodate over the short, medium and long term. So it's really that spatial difference, I think, which policy 5 is picking up on.
So can I just so as I'm hearing there are two elements to what the guideline indicates, and thank you for that. We'll have a look at that. So it's both market attractiveness and market preference.
Yes, that's
Those
my
are the
reading
two
of it.
elements that they're focused on in terms of that phrase. Right.
And Mr. Wallace, who'll be presenting shortly, has done quite a detailed analysis of both accessibility in terms of policy 5A, which is specific to the Rotorua context, but he has also done some analysis on areas of relative demand, and he has looked at land value data as a key proxy for that, but I'll let him take you through that shortly.
I mean, I'm just puzzling as to when I can see how that concept would work in maybe a 5 to 10 year time frame. I can't see how the concept works in a 10 to 30 year time frame. And maybe that doesn't matter, but that's something that we'll question on. Yeah.
And I think perhaps at that point it is quite useful, I think, to and again Mr. Wallace will talk about this in more detail, but to refer to figure 24 of the demand, accessibility and demand analysis that Mr. Wallace prepared as part of the Section 32 report. And what that shows, I haven't got it up on the screen, unfortunately, but what it does show is the summary analysis for those areas that have highest accessibility and also do have high relative demand. And I think what that does show is that the areas of relative demand and high accessibility do tend to overlap. So that shows the city centre, Glenholme, parts of Glenholme, Owhata and Nongataha as meeting both of those criteria. And in my view, excuse me, where both of those criteria are met, there is a better case in terms of policy 5 for enabling greater building heights and density. Whereas the other two areas which that figure identifies as having high relative demand but lower accessibility are Springfield, Linmore and Kawhia Point. And in those cases, and in the context of the MDRS, it would be more appropriate to enable the MDRS as a means of enabling development to occur in those locations. But given that they have lower accessibility or poor accessibility in some cases, greater density beyond that would not be appropriate. And then I'll also just, in terms of the NPSUD guidance, just draw your attention to figure 14 of that guidance. And it's got quite a useful example, they call it example framework for determining heights and densities for areas outside of Tier 1 urban areas. And what it does show is this idea of a relationship between accessibility and demand. So in areas where there is high demand and high accessibility, there is really that greater imperative to enable greater heights and densities. Whereas if that demand is high, but the accessibility is low, while there is a need to enable intensification, that the imperative for that is potentially less. Yeah, that's quite, I've found that quite helpful. So just briefly in terms of policy 2, so that's really about ensuring there is at least sufficient development capacity, and at a broad scale that really indicates that more capacity is better. However, I do think it's important to consider this policy in the context of the others to ensure that there is a good degree of balance. That is, I don't think policy 2 is implying that that the supply of development capacity for high density housing should be limitless or unconstrained. And policy 5 is really important, as well as policy 1, in providing some context for policy 2. But also at the same time, even if sufficient development capacity is provided by the MDRS, this does not remove, in my view, those policy 5 obligations and the need to consider whether areas are suitable for greater heights and densities based on their accessibility or relative demand as a means of improving housing and business choices. So it's really trying to get that balance right, in my view. So applying that overall rationale to plan change 9, I've set out a summary of that strategy at section 8323 of the section 42A report. And that's really about, firstly, enabling the greatest heights and densities in the city centre 1 zone as the most accessible location and an area with high relative demand. 32 metres is proposed, which enables that 8 to 10 stories, which is, in my view, enabling, quite enabling in a Rotorua context. But it also does have some basis in the existing environment, and that it does correspond to the height of the Hinimoa Tower, which is on Hinimoa Street. Beyond that, the strategy is to provide for moderately lower building heights in the zones surrounding the city centre of around about 22 to 24 metres, reflecting their peripheral location, but there's still good level of overall accessibility. And this height also does assist to provide a transition to those lower density residential neighbourhoods as well. And beyond that, providing for those moderate building heights of 20 metres in those mid-sized commercial centres that I've talked about, recognising that they are located further away from the city centre, but they do still have a good level of accessibility because they are themselves centres which provide for a range of services and community facilities. So then turning to what would be a commensurate height, I think the relative heights enabled by the MDRS and that matters of development feasibility are important considerations. So With the three-storey height limit enabled throughout the residential 1 zone, in order to deliver the higher density forms of housing in those more accessible locations that I've spoken about, as provided for or as sought by proposed objective 4 in the strategic directions chapter, it is efficient and effective, in my view, for the zone rules to enable feasible building heights greater than 12 metres as a means of achieving that, so that we are giving the best opportunity for those apartments and higher density forms of development to occur in those accessible locations. And Ms. Fairgray has commented on heights and development feasibility, and she does outline that feasibility does generally improve with greater building heights, given the ability to spread the higher construction costs across a greater number of units. So in response to that, in areas of greater accessibility in the city centre and the residential 2 zone, I do support height limits of 5 stories or more generally, which is where that feasibility does start to improve for apartments with those higher density forms of development. So just before I move into the next section, would you like to pause for questions, or should I keep going, or just keep going? Okay. Okay. So just a quick comment in terms of creating quality environments. So Ms. Emling did comment on this. With increasing heights and densities, in my view, comes the need to ensure that quality living environments are achieved. And this is partly addressed by Policy 3 of Schedule 3A. However, I do support a wider range of amendments to the issues, objectives, policies and zone provisions to ensure that good design outcomes are achieved, but importantly within the context of the planned urban built form anticipated by the zone. So that extends to the design assessment for 4 or more residential units, the additional performance standards, and that restricted discretionary framework for new buildings within the city centre and the commercial zones. And I've just referenced there that this approach is also consistent with the Bay of Plenty regional policy statement, which does include some quite directive policies around high quality urban design, and that's referenced at policy UG8B and within some more detailed design principles included at Appendix B. So now just turning to the residential 2 zone extent, if we go to slide 3. Thanks. So I have addressed this matter in detail, and I've covered that in section 814 of the 42A report and 322 of the addendum. So firstly, in terms of the need for a high density zone, in my view, providing for that close to the city centre is the most appropriate way to give effect to the NPSUD, and specifically policy 1 as it relates to providing for housing and business choices. It would also better enable the efficient use of land in an accessible location, as I've talked about. And so in that sense, it is consistent with that proposed strategic objective number 4. So in terms of housing choice, the residential 2 zone does provide the opportunity for higher density housing to establish within that quieter residential environment, which does provide that different level of residential amenity than what one could expect for high density residential in a city centre or commercial environment, which might be a little bit noisier and have a bit more of a 24/7 atmosphere to it. Apartments can also offer that different form of living for people to terraces or walk-ups, which you might see in the residential 1 zone over time. They do tend to have typically smaller floor plates. They have access to views depending on their height and location. So there are a range of different factors to consider there in terms of its contribution to housing choice. So in terms of the extent, so Kāinga Ora are seeking a further extension, which you can see up on the screen there in that black hatching. And I have considered the evidence of Ms. Tate in some detail, and I have responded to that. However, I do continue to support the notified extent of Plan Change 9 or for the residential 2 zone. And my view is informed by the specialist evidence of Ms. Fairgray and Mr. Wallace, and they will talk to that. But I have put that in the appropriate section 32 and policy context. And just to firstly summarise, in terms of objective 2 and policy 2, both the notified plan change 9 option and the Kāinga order option would provide at least sufficient development capacity, and they would contribute to competitive housing markets and housing affordability. And Ms. Fairgray addresses this issue, and she observes that the significant capacity provided by the notified residential to extent, in combination with the medium density residential standards and the city centre and the commercial zones, would provide ample development capacity and competition within the market, such that there isn't a huge difference from a section 32 perspective when comparing those options or when assessing those options. And secondly, in terms of policy 5, the notified plan change extent does perform better from an accessibility perspective, and Mr. Wallace will talk about that. But that is not to say that the Kāinga order extended area performs poorly. It doesn't, but there are some notable deficiencies in the open space network which do contribute to its reduced accessibility in comparison with the notified option.
And of course, all of these things depend on take-up.
That's right.
Which is not something we have any control over.
Yes, that's right. And that's in terms of the notified residential to extent, it is reasonably extensive. It extends about 800 to 1,000 metres from the edge of the city centre 1 zone, and it's quite evident on the plan there. So it does provide significant opportunities for that higher density residential development to occur. And as I say, in that policy 2 sense, the competition in the market and housing affordability is met or achieved with that notified extent based on what Ms. Fairgray has advised. And then also in terms of
One of the things I'd be interested in, I guess, it's between you and Ms. Fairgray, I suppose, is in terms of the modelling, did you model smaller as well as larger? How did you settle on the pattern that you finally settled on for the high density?
In terms of capacity?
No, just in terms of area. Spatially, how did you decide the boundaries of this area?
Yeah, right. So there were a number of options that were considered. So the larger extent, which you can see generally aligns with the Kāinga order there, Kāinga order extent shown there, were modelled from a development capacity perspective. And Ms. Fairgray can comment on the results of that. And in terms of how we landed on the notified extent, that was a combination of the outcome of Ms. Fairgray's analysis, but also I think the accessibility analysis from Mr. Wallace, which was showing that the area further south was not as accessible as the area to the north, and that it would benefit from some further investment in the open space network to improve its accessibility over time.
Did the accessibility part of the analysis drive the western edge of this area?
Yes, it did. Yes. And Mr. Wallace will talk through that shortly, but that area does perform quite well, or particularly well from an accessibility perspective. It is located close to the high school and a range of open spaces, and also the West End shops at the southern extent. And it is located close to the city centre. I would also note in terms of that western extent that, in my view, high density forms of housing on Old Taupo Road would be an appropriate response to the condition of that road, given it's a busy arterial road, and that high density 6-storey development can provide a positive address to that. And it can also perhaps better absorb the effects of the greater height and density that's enabled, acknowledging that height in relation to boundary controls would apply on the western extent of that zone boundary to provide that integration with the residential 1 zone.
Yeah, no, we'll talk further about that one.
Okay.
Do-
So just two more points on that. So Plan Change 9 extent, in my view, in addition to the matters that I've talked about, would better support that vibrant, the achievement of that vibrant city centre, which is a key objective of the city centre zone, Objective 1. And it really does that by concentrating higher density development opportunities as close to the city centre as possible, where they can contribute to a greater concentration of people and density. And related to that, that would also, in my view, better support the coordinated provision of cost-effective infrastructure that would benefit both the city centre and that immediately adjoining high-density residential zone as well. So in terms, now just moving on to residential design. So a range of methods are proposed to achieve attractive, healthy and safe environments, which is the key outcomes sought by Objective 9 in the Strategic Directions chapter. So the methods in the residential 1 and 2 zones build on the MDRS in a way that is responsive to the Rotorua context. And a key method is that for design assessment for 4 or more residential units, which I've talked about, and the assessment criteria and the matters of discretion, which do provide a reasonable level of guidance to the council and future applicants. So in terms of the remaining areas in contention, except for some of the more fundamental issues around height and that sort of thing, they seem to relate to the building length standards that's been proposed and the daylight envelope that's proposed. Oh, thank you. That's proposed in the residential 2 zone. And so I'll just briefly comment on these matters, noting that again, Mr. Wallace has done some further design testing to address these ones. So in terms of the building length, that control is really about limiting the length of buildings alongside, alongside and rear boundaries to 28 metres, after which a 2 metre separation would be required. And the purpose of the standard is really to manage visual dominance and privacy overlooking effects to neighbouring sites, and really to encourage development to front the street in combination with the other design standards that are, or performance standards that are proposed in the zones. So I do continue to support this standard as it's proposed to be amended, because I think it does provide a greater degree of certainty for the council and applicants through a consenting discussion and process as to the appropriate length of buildings alongside and rear boundaries. I accept that that could be addressed through assessment criteria, but that option, in my view, would, again, as I say, would not provide as much certainty.
What does it default to if you don't comply?
Restricted discretionary. Yeah.
Right, it is.
And it does also enable continue to enable the efficient use and development of sites. So in that sense, it's not actually really constraining development. It's really about where development is located on a site. And the design testing of Mr. Wallace, I think, illustrates that, and it shows that development can achieve that full building coverage and compliance with the other standards within that building length requirement on a typical site.
Can I ask an offline question here, really, which is, have you, or generally, not you particularly, but have these provisions been workshopped with development industry to ground truth whether in actual fact it hits their preferences and so on?
We have had a range of discussions with submitters on this standard. So that's included some discussions with the likes of Classic, Kāinga Order, the Retirement Village Association and that sort of thing, but not beyond that, no. Yeah. And then just secondly, on that daylight envelope or height in relation to boundary standard in the residential 2 zone. So I support the notified extent, which is a 12 metre and 60-degree recession plane for that first 29.5 metres from the front boundary, and then the 4 metre and 60-degree recession plane thereafter. And I prefer that to the more enabling provision sought by Kainga Ora. The notified standard does continue to enable efficient development of sites, and Mr. Wallace has done some further design testing of that to illustrate that, albeit that it would require a further setback from neighbouring boundaries, but it would still enable a feasible, complying high-density apartment development on a typical site. And because of that, the notified standard, in my view, does more effectively manage those potential adverse effects on neighbouring sites, which is reflected in policy 11 of the residential 2 zone. Nearly there. So just on subdivision, so I have addressed this matter in quite a level of detail in the section 42A addendum. So in summary, having worked through all of the options in quite a degree of detail, I support a shape factor only approach of 10 metres by 17 metres applying to vacant lot subdivision on a what would be a typical suburban scale residential site. And having done some GIS analysis to determine what that would be a site below 1,400 square metres. So you'll see that reflected in the proposed provisions.
Sorry, and the 1,400 comes from where?
So Mr. Wallace did do some GIS analysis to determine what the typical size of a site in the residential 1 and 2 zones would be. And that illustrates that a typical residential site would be below 1,400 square metres, and that accounts for 95%, I believe, 95% of sites within the residential 1 and 2 zones. Yeah.
Call that now, thank you for that. And I recall an annotation, I think, against the evidence there, which is asking, well, what happens if you go to 1,200 or what happens if you go to 16? What's the difference?
Yeah, and that is always the challenge in setting a threshold of that nature.
Yes, but I mean, we'll pick that up with him. You want to pick up the 300 as well?
Yeah, I'll get to that. I can cover that matter shortly. So, but firstly, on those typical suburban sites, in my view, that shape factor only approach does provide greater flexibility to deliver those smaller and potentially more affordable houses on a site via a simpler consenting pathway. Because in the absence of this control, even if we did have a 300 or 400 square metre vacant lot site size, there is no density control if you go through a land use consent process. So this is just regulating the effects of one particular development pathway available to a landowner. But importantly, it is, in my view, it's critical that shape factor is sized to accommodate a complying development in the future, which might be 1 or potentially 2 residential units. I don't think it needs to be 3 residential units. While the MDRS does enable up to 3 as a permitted activity, it does not require a developer to construct or a landowner to construct 3 residential units. It's completely open to them to construct 1 residential unit on a site, which is why I support that the shape factor only approach. But I do propose removing constraint areas, which I have listed in the provision there, as well as areas for access and manoeuvring where parking is provided. So I have specifically excluded those because parking and access have not been picked up in the design testing that Mr. Wallace has done. So if a landowner were to so it was a rear site, for example, if they did want to provide car parking, they would need to demonstrate that that vacant lot has sufficient size to cater for that. So that leaves the sites larger than 1,400 square metres, and these tend to be those larger greenfield sites or those strategically sized areas that present the opportunity for comprehensive redevelopment, and that's really reflected in the fact that they apply to only 5% of total sites within the residential 1 and 2 zone. So I do support, in addition to a site shape factor, a minimum vacant lot size of 300 square metres. And in terms of how that is derived, it's to an extent, it is always slightly arbitrary when that limit is set. However, what I would note is, and Mr. Wallace can talk about this, 300 square metre site would enable three-storey residential units on a site. So in that sense, it does provide greater flexibility for a range of housing types to be delivered when you compare that to a shape factor only approach, which might enable, say, only one, or at a pinch, two residential units. And Ms. Fairgrave does comment on this in a reasonable amount of detail in her evidence. And her view is that on those larger sites, there are those different market conditions that may make future intensification more challenging through a land use consent process, assuming that a developer decided to do a vacant lot development first, which is certainly a possibility. And in terms of the need for an average lot size, Ms. Fairgrave does comment on that, and she does reference a potential average lot size of 425 metres. However, while I do agree with the outcome that's being sought, which is about making sure that development on these large sites provide housing variety and choice, in my view, there's not quite enough evidence to justify, from a Section 32 perspective, that additional control. And I would prefer, and I would support, a more flexible and responsive approach, which would be a additional matter of control, noting that vacant lot subdivision is a controlled activity anyway, which would refer you back to proposed policy 31B. So at least through that controlled activity consent process, you would have that consideration of the range of site sizes that would be provided, but in a more flexible way than a average lot size rule. So then moving through to city centre and commercial zones. I won't cover everything here, but there are just a couple of outstanding matters. So the first is in relation to residential activities above ground floor level in the city centre 2 and commercial 6 zones. Maybe we could go back to that first plan. There's that. So in my view, residential above ground floor in these locations would better support the vibrancy of the city centre. And again, that's referenced in Objective 1 of the city centre zone by enabling or providing opportunities to enable more people to live in accessible locations close within or close to the city centre. It may also support redevelopment of these sites, which, if realised, I think really does provide that opportunity to more positively contribute to the mixed character and amenity and safety of these locations. And I think that is important in the context of the built form that's there on the site at the moment. It's reasonably low density. There's expansive areas of car parking to the street, which doesn't necessarily, in my view, present or contribute to the visual quality of the city centre necessarily. And redevelopment with residential above ground floor as part of a wider development proposal just provides another opportunity to improve that level of amenity. And in terms of residential at ground floor in the city centre 1 and 2 zones, I won't dwell on this for too long, but just to note that I do continue to support enabling residential at ground floor on those peripheral locations, which are shown in that proposed figure, city centre zone 3. But noting that new buildings and additions to buildings do still require consent in the city centre zone as a restricted discretionary activity. So while residential would be enabled on those peripheral locations, the design of that residential at ground floor will still be an important consideration. And I have included some quite detailed assessment criteria to guide that as part of a future consenting process. And then just finally on other activities. So I have looked at the submissions from the Retirement Villages Association, Ministry of Education and Ministry of Corrections on retirement villages. I do support, and notwithstanding the issues of scope that Ms. Embling has gone through, I do support an approach to rest homes that is generally consistent with how residential units are treated. They are an activity with a similar range of effects, and they will form a significant component of the housing market in the future. And we do need to ensure that they're appropriately provided for in the planning provisions. I do agree that amendments to the standards around outdoor living space, outlook space would be appropriate, reflecting the need for reflecting those functional requirements. But I do think they are still an important matter to consider, particularly as it relates to on-site amenity. So I have proposed additional assessment criteria that will enable that assessment to occur in a much more flexible way while still achieving those outcomes. And further changes beyond what I've proposed, in my view, are not necessary. I know that there's quite a lot of detailed further amendments sought by RVA, and they really do, I think, add further complexity to the plan without necessarily a corresponding benefit, where a more targeted approach is appropriate, in my view. Education facilities. So I do not support education facilities of up to 200 square metres being a permitted activity in the residential zones. That would, I understand, provide for a facility of up to 50 kids on any site in a residential zone. And at that scale, it would at least warrant some further assessment through a consenting process, particularly as it relates to things like traffic and noise. And community corrections is the final comment. And firstly, I would say that this is more appropriately addressed as part of a future plan review process, particularly given the overlap of this definition with other definitions in the plan and the fact that we're not actually changing every single zone through this plan change. So there is that plan integration issue to consider, I think. The activity status of community facilities, I think, also really lessens the need to address this matter now. It's permitted in the City Centre 1 zone, it's controlled in the Commercial 1 zone, and it's restricted discretionary in the Commercial 6 zone. And those matters of discretion are quite similar to what would be assessed through a new building or alteration to an existing building in any case, which is proposed. And I think I might just leave it at that if you have any questions.
No, it'll take quite a while. You also questions arising from the addendum. Is that you as well?
Yes, in relation to the residential, commercial, city centre topics,
Okay.
and the additional activities.
All right, I've got a number of questions for you. The first lot arise from your initial section 42A report.
Mm-hmm.
And some of my questions you can answer if you can, and some of them you can just make a note of, sort of matters of detail. The first one is on page 52 of the 42A report. It's section
52.
1.3.3, paragraph 1.0.
Just let me get there. Sorry, what page is it? 53.
Page 52. So it's first paragraph under the heading in section 8.1.3.3.
I agree with the submission from RVA.
Yeah.
Yeah. Okay.
So the question is, you're recommending the words there, urban built character, and I was just wondering whether the words urban built form might be more appropriate, since they're the words used in policy 6A of the NPSUD, and their opening legal submissions council used the phrase planned urban form.
Yeah. Yeah, I'm just looking at policy 6 now, and that does refer to the planned urban built form.
Yeah.
So that wording would be more consistent with that. But I can perhaps consider that in a bit more detail and come back to you on that matter.
And just a matter of detail. So looking at the residential zone provisions that were attached to the initial 42A report, and you don't need to turn to this, this is one you can just make a note of.
Okay.
In terms of standard 6 capital A.5, where there's a diagram, the text talks about a minimum separation distance of 4 meters between the buildings, whereas the diagram has 2 meters. So just which is correct, 2 or 4?
Yeah, I did pick that up. It's 2 meters. Yeah.
So the text is wrong?
The text is wrong.
Okay.
Yeah.
Yeah, just still looking at those residential provisions. And if you have that appendix handy, if you can turn to page 53 of that appendix.
Of the provisions.
Yeah, yep. That's the first matter of discretion.
Yep.
Res MDA. This is a format I'm not familiar with in terms of some of the other district plans I've been a commissioner on, particularly ones in the South Island. And the question relates to the assessment criteria.
Mm-hmm.
And so when I look at provisions like this, I put a decision-making hat on. And the question is, how do these assessment criteria relate to the 42 policies in the residential chapter of this plan? Are they do they overlap? Are they consistent? Do they duplicate? Why do we need all these assessment criteria if we already have 42 policies a decision maker has to have regard to?
And that is a topic that we did discuss in quite some detail in pre-hearing discussions with submitters, and I do acknowledge that, and I know that other plans do simply refer to policies in the chapter, and that's a very streamlined approach. However, one thing I would note is this restricted discretionary framework for Rotorua is quite new, or it is new. Development is under the operative plan either permitted or controlled. So this design assessment will be quite a new practice for both council officers, council planners, and also planning consultants working in the area. So in my view, providing some further detail as to the particular design outcome sought in the assessment criteria would be helpful to help guide those discussions between the council and consultants as they will occur. But I do acknowledge your point around the link with the policies. And one thing I could look at is whether we could amend that assessment criteria to more clearly cross-reference back to the policies. So there's that really direct linkage there.
Yeah, and I don't know, have you done an analysis to see if there's any duplication? Because as a decision maker, it'd be a nightmare if the assessment criteria said something slightly different to something a policy covers, and then we'd be having to decide, is that deliberate or just poor drafting, or has that analysis been done?
Not specifically, but that's something I can certainly do and provide to the panel, and that may result in some refinements to the assessment criteria if we were to cross-reference to policies. Yeah,
that'd be helpful. And as a decision maker, less is always better.
Yep. Okay.
I'm not sure if I'm looking at the same text, but it doesn't really matter because the lead-in from the assessment criteria also, the one I'm looking at, which is, I don't know what page I'm on. Anyway, the lead-in, the one which is above the Res Z AC1 says, whilst not limiting the exercise of its discretion, the council may consider the particular matter below where indicated in the table above. So I mean, it's even more loose, if you like. It's not a prescription, but again, just picking up the Commissioner's point here, as we sit on some of these things, and whether it be as a duty commissioner or as in a formal hearing, those sorts of discretions are just a nightmare. So I guess that I'm on the record saying that I probably am actually, but they are quite genuinely. So I mean, it is something which perhaps we should give some attention to in terms of. I mean, the intent is laudable. Obviously, as you say, it's a new provision, new working provision. You want to give some direction, that's fine. But as we all know, as both as practitioners and as receivers of this sort of stuff, if the discretion is too wide, there's often a reluctance to close that gap by processing planners quite reasonably. They have a role to do. So yeah, pick up that idea, that'd be very helpful.
All right, thanks. And this is just a matter for you to take a note of. You don't need to answer that now. The question is, should CCZ policy 4 be amended to enable ground floor residential units to be consistent with other provisions? So just make a note of that.
Okay.
Time's sort of we're
CCZ
running out of
policy
time, so I
4.
don't need you to try and answer that now.
Okay.
Yeah, CCZ policy 4. Should it be amended to enable ground floor residential units consistent with other provisions?
Okay.
Yeah, but there is one provision now I would like you to turn to because I don't understand how the plan's intended to work.
Mhm.
Are you able to bring up commercial zones provisions? And I want you to look at comms R31,
31.
which in my copy is on page 34 of that document that was part of the original 42A report.
Give us a reference again, but the particular one,
Comms, COMZ, Rule 31.
31.
31.
And page 34, I think it's on.
Rest homes.
Yeah.
Yeah.
So
Okay.
my question relates to, again, it's in the third column, and I'm looking at the matter of discretion F. Can you see that?
One more.
Yep.
Yep.
Yeah, I can see that. Yeah.
Yeah, and so if I read that, the extent to which the activity will avoid, remedy or mitigate the effects of the non-compliance of achieving the purpose of the relevant performance standard, all well and good so far, and the objectives and policies relevant to the matter of discretion, which that's a circular argument, doesn't it? It doesn't
Yeah.
work. Should that say instead relevant to the performance standard?
Yes, and I just to note, these matters of discretion here, while they look new, we try to keep them the same as the matters of discretion for rule infringements for other activities, but that is not to say that it's correct. And yeah, I can certainly go away and take a look at that and see if that could be amended to be clearer.
Yeah, it's just a circular provision, which in my mind doesn't work.
Yeah,
Yeah.
okay.
And I want to take you to jumping around
That's right.
to
So I'll
the rule NHR4. So if we can, and if you can look at the addendum version of that.
So I'll just quickly make a note of this.
Yeah.
Sorry, what was the
NHR4, so the sort of the
NHR?
natural hazards rule.
I
Lauren?
might defer that one to Ms. Smith if that's okay. She is a reporting planner for the natural hazard provisions.
So should I save that question for later?
Yes,
Just
if
float
you
it,
wouldn't mind.
float it so that you can.
Okay,
hear it.
so the question is, I think if I look at NHR4(2), so the activity status permitted where, then it has your A, B, and then a performance standard clause. To me, the whole first bit of that A and B is really hard to understand. And I think the wording could be significantly clarified and simplified, which I've had a go at drafting. I'm happy to share with staff so they can consider whether or not this amended wording is more clear for a decision maker. I'll leave that with you.
Okay.
And I'm just wondering, in terms of some of the phrases that are used in relation to hazard, low, high, residual risks, is there a need for those terms to be defined so a decision maker actually knows what you want? Did you miss all of the question?
But we have made a note of that, and we can talk with Ms. Smith about it in the
Okay.
break and make sure that
Sure.
she's ready to answer
Why don't
that.
you do that? And if you need clarification, just ask me and I'll let you know what my concern was. But
Great.
But when you see the rewording I've done, you'll fully understand.
Okay.
And so just in relation to what you said now, so council had said that the 300 square metres minimum lot size on subdivisions for 1,400 or greater sections, Ms. Fairgrave was the expert on that, but you've said it's Mr. Wallace. So who is it?
I think it's a combination, to be fair. So from a policy point of view, perhaps if I just take a step back and refer to, if I can just find it, the subdivision provisions and the amended policy 31 that is proposed. So the outcome that we're seeking, and which I support, is saying on larger sites, encourage subdivision that provides a range of site sizes in a way that contributes to housing diversity and choice within a neighbourhood. So the 300 square metre site size, so that outcome is something that Ms. Fairgray talks about in her evidence, and she does reference that 300 square metre size. But in terms of how that's implemented, Mr. Wallace has done some design testing, and that does show, and it aligns with what you would intuitively think, that you could, on a larger site, accommodate a broader range of housing types.
Yeah, okay, so I'll ask Mr. Wallace about that, because I've read Ms. Fairgray's evidence, no, I've word searched it, and she only says she supports 300. She doesn't explain why 300 is appropriate. And I've word searched Mr. Wallace's evidence and his addendum evidence for the phrase 300, and it doesn't feature. So
No.
has he done some additional reporting that we don't have?
Yeah, and he can talk to that when he presents. But I think the key difference from a planning perspective is the 300 would enable 3 residential units to be constructed, complying with the standards, whereas the shape factor only approach would enable 1 or maybe 2.
And there's a whole narrative that goes between the land developers and the property developers, which I've spent hours listening to, and we will undoubtedly hear it all over again.
Yes.
So Mr. Wallace can present us with a diagram he's compiled that shows 3 complying medium density residential standard dwellings on a 300 metre squared lot with appropriate side yards and no more than 50% site coverage.
Yes.
But we don't have that at the moment.
Not at the moment, no. But we'll talk with them in the break and we can put that up on the
I
screen.
couldn't find it.
That's right. So draw for lunch.
Lunch now?
Draw for lunch.
Yeah, we've got a few more questions.
Yep. So yes, all right. Thank you very much, everybody. We will adjourn for lunch now, and we will resume when? Do you want the full hour, or do you want less than that? Let's cut the chase, and let's say back at 1:45. Thank you. All right, we're back on time. Thank you very much. And just a couple more questions for you. Thank you.
So I just have one more question from the primary 42A report. Can you hear me now? Better? All right. So I'm just curious if you could remind me why, and the question arises from page 136 of the report, but you don't need to go there. Just why have the words which will be free from inundation been recommended to be deleted from sub S9.1.A. Romans 1?
Again, I think that's probably a matter best addressed by Ms. Smith, who has addressed the changes to the natural hazard provisions in the subdivision chapter. That's
right.
Okay.
So that's one for her too. And if I go to the addendum report, just find it. So if you could turn to page 54 of the addendum report.
Yes.
And you see right in the second paragraph there of the far right column, 4 lines down, may provide the opportunity to relocate trade activities like MIDA 10. And this relates to the COM 6 zone. And my question was, have you talked to MIDA 10 about that?
No, we haven't talked to MIDA 10 about that specifically, but we have had some discussions with Pukiroa, who are the landowners of the site. And I do believe that they will be talking to their submission a little bit later in the hearing. So you will be able to hear from them about that specifically.
And the next question follows on from that. Very next page, top of page 55. The COM 6 zone does generally offer a lower level of amenity with large expanses of car parking to the street. And my question was, to what extent is that car parking utilised by the current activities on the site? And because when I go to the MIDA 10 in Napier, it's very hard to find a car park. And is that the case here as well?
So I haven't undertaken, or we haven't undertaken any specific parking surveys, but it is apparent when visiting the site that there is a significant amount of car parking provided. Again, that might be something that Pukiroa can speak to you about specifically. But I would also note, and Mr. Wallace has picked up on this in his evidence, that there may be some design solutions that enable that ground floor car parking, but enable some development to occur above that potentially. So there are design solutions there to manage that.
Yep. And final question arising from the addendum relates to page 66.
66.
And I think there's a recommendation to delete a reference to HHMD1 from that matter of discretion that's in red font. But I thought HHMD1 wasn't actually amended by this plan change. So I was wondering if the staff actually have a view on scope or not on this issue.
Right. I acknowledge that is addressing changes to the heritage provisions, which Ms. Binden is the reporting planner for. So it would be appropriate to address that question to her. Ms. Ending may have some comment on the legal scope component of that, though.
All right, that's all. Thank you.
Only one from me. Where does this come from in the paper you provided, paper in the documentation, or did you just create it for today?
It's just been created for today. Yeah.
Okay, it'd be great to receive this as an email copy.
Yes, we'll certainly do that.
To the author, I assume.
I'm not sure if Ms. Ebling was going to talk to this, but we thought, given the relationship of my topics with Mr. Wallace's evidence, perhaps he could present now, if that worked for you.
Yeah, that's fine.
Yep.
That's fine, Mr. Wallace. See you again. Now tell us, you're going to take us to your rebuttal, or are you going to hopefully not stagger us through your primary?
No. So what I've got for you today is I've prepared a brief summary, and based on some of the questions that have come through, I thought it would be useful to kind of take you back through some of that Section 32 material around the accessibility and demand analysis, because it does ultimately speak to some of the questions which have been raised in submissions. So I just want to kind of take you through some of the thought process that went into that, because I think as you kind of rightfully pointed out, Policy 5 is quite interesting and we haven't really had to deal with it through any of these IPIs yet. So I thought it'd be worthwhile just kind of talking you through some of the steps that we did to get to the conclusion. But probably I just want to, I guess, again, put on the record again, before I start, that I have been involved in a number of IPIs around the country already for both public sector and private sector. I've appeared before you, Commissioner Hill, and Commissioner Butchhusen already. I have done that work on behalf of Kāinga Ora. I'm also acting for a number of other private entities in Wellington and Auckland with a particular focus on commercial city centre zones. So I just want to be upfront about that I am kind of...
That's fine, and I'm keeping an eye on the consistency of your evidence before me as well.
Yeah, it's been my ultimate challenge for the past few months.
Yes.
So, okay, great. So I have a presentation. Oh, okay. Okay, so there's going to be a kind of a short presentation that I'll be able to talk to you, but I can probably just kind of start in terms of going through. I've got some words to kind of read before I kind of really need to dive into that. So I authored the accessibility and demand analysis that was contained in the Section 32 report accompanying PC9. I think it's important to note that, you know, there's reference to kind of accessibility analysis to inform plan development under the RMA through the NPSUD is new, but accessibility analysis itself is kind of a well-established concept in both New Zealand and overseas for a range of quite similar purposes. So in terms of my background, I spent a few years in London working at Transport for London, and one of our key tools that we used was called public transport accessibility levels. And through that process, that helped to determine particular requirements in terms of car parking ratios, cycling ratios, or based on those levels of kind of accessibility. So it's a concept which I was fairly familiar with prior to it coming to New Zealand. So that has kind of influenced the way I've gone about preparing this work. In terms of the actual analysis undertaken, there was a very broad catalogue of kind of services and amenities, which I'll sometimes refer to as destinations, which I considered are relevant for the residents' day-to-day living in Rotorua. And this is for a kind of a broad range of residents, not just, say, a 35-year-old male. So this includes things like schools, marae, different kinds of parks, so not just parks in a general sense, but sports fields, playgrounds, they all kind of serve different purposes. Where actual employment opportunities are, things like supermarkets, libraries, all those kind of important things that you might expect to need on a day-to-day or a week-to-week basis to go about your daily life. So we sourced this data from a number of sources, including Council's own internal GIS databases, central government databases like supplied by Ministry of Education, for example. I scraped a lot of data off Google Maps, thousands and thousands of points of data, and kind of went through those. And obviously sitting down with council officers themselves, and we tried to QA a lot of this data to see if it made sense on the ground. The data around employment is sourced directly from the census data, but that's aggregated at kind of a mesh block level. So there's no specific data on there's 50 people working in this building or whatever. It's at a general sense, but again, that was used as the best kind of proxy. And then from that work, using GIS software, basically all these different kind of destinations and things, we derived walking catchments, which is actually based off actual paths walking on the street. So not kind of a radial catchment, it's how far you would actually walk using the kind of street network or road network through parks or whatever. And walking was used as the kind of principal basis for determining that, because I think the concept of accessibility, I think, broadens out to things like cycling and driving. But if you're using driving as your assessment tool in a place like Rotorua, well, then everywhere is accessible. So what was the point? We really wanted to find out, really in the context of the other policies around, supporting reductions in greenhouse gas emissions, what would kind of be the best bang for your buck in terms of accessibility to inform the kind of requirements of Policy 5. So in total, 481 different destinations across the Rotorua urban area were catalogued. And for large destinations like schools or parks, individual points of access from the surrounding road network were also identified. So if a park had 5 entrances, we identified those 5 entrances and derived walking catchments from those. We didn't just take the centroid of it. So we tried to get it as accurate as possible. And this is kind of in line with the MFE guidance document that Ms. Morgan referred to earlier. In addition, 274 bus stops make up the Rotorua public transport network. And again, we use these. There was some variation between these bus stops in terms of how many routes they service. So bus stops which serve multiple routes were essentially deemed kind of more important, more valuable, because you can get to more destinations from them. But we took into account the whole bus network. So overall, almost 2,000 individual walking catchments ranging from 200 metres to 1,600 metres were generated across the entire Rotorua urban area. And those kind of came together in those series of maps, which are set out in that accessibility memo. And then from that process, we went through a process of weighting with council officers. So the weighting was used to understand kind of the importance of those facilities in a Rotorua context. And I'll use the example of a kind of a marae. They have a really important community role generally, but in Rotorua, that was identified as being something particularly important for the local community in terms of being able to access and live in close proximity to marae. So they were seen as quite a critical destination. And then secondly, it was to acknowledge that, well, yes, you're within a walking catchment, whatever that walking catchment is, but if you're 800 metres away from that destination, that's clearly less accessible than if you're 400 metres away. And it was to try and acknowledge just the general proximity improves as you get closer and essentially reward an area for that. So following that kind of weighting of the data, an overall kind of score was kind of derived and then spatially identified from kind of highest accessibility to lowest accessibility. Now to kind of separate that out, there is a statistical method and kind of cartography, which is called the Jenks Natural Breaks Classification Method. So that was used to kind of get those bands, and the way that that system works is essentially it helps get the limited amount of variability within each classification, but the most variability between different classifications. So all those areas are kind of consistent, but there's an appreciable difference to understand. So, yeah. So if we can just go through. So basically, this is a summary of what I've just said. What is accessibility? Basically, how many points a person can get to in any given kind of time. That's at its simplest form. You know, it's a range of destinations. It's policy 5 is different than I think what we've traditionally done, which is, we'll just put a catchment around a centre zone and that's it. There's a lot of destinations which are really important for people's lives, which aren't typically found in a city centre. Classic case, things like secondary schools, things that require a lot of land space. So in my mind, the way the policy is directed, it's trying to capture all those other things which are really important for people. If we could go through to the next slide. And then I think importantly, every kind of different destination has kind of different user groups, and that was reflected in terms of the types of walking catchments applied. So typically what you'd find for, say, a secondary school is teenagers are willing to walk a lot further to access a secondary school. There's a lot of data out of MOE around how far people access schools. So applying a larger catchment to a secondary school was adopted, whereas for a primary school where you've got younger children, parents don't typically let them walk as far and stuff, so smaller catchments were applied. And again, it was trying to reflect some of these differences. Again, when you've got major kind of, I guess, regional destinations, things like the hospital or library, again, there's only one of them, they're quite unique, but they were given kind of larger catchments to reflect that kind of function within the wider urban environment. Next slide, please. This, again, just a summary of that process. We can probably skip forward this one. So this is just a kind of a snapshot, and I wanted to kind of just run you through some of the differences and what that means. You know, we have these images provided in my evidence, my Section 32 report, but I just wanted to kind of explain some of the context around them. So what I've done here is I've picked kind of 3 sites, essentially high, moderate, low accessibility, that I wanted to kind of explain what derive those overall conclusions. So that starting at the top, the high accessibility area. So the area around the intersection of Ranulph and Pukeotua in terms of this analysis is essentially the area of highest accessibility in Rotorua using this methodology, higher than a lot of other parts of the city centre. So again, it kind of comes back to this point, is just because it's the city centre doesn't necessarily mean it is the kind of most accessible. Some of it kind of overlaps, but again, some of the proposed Res 2 zone falls in that area, which I consider to be more accessible than other areas within the city centre. So if we go through to the next slide. Now, I haven't got a key, but basically the point here is all those coloured elements contributed to understanding what this area's accessibility was. So you've got Marais, Plunkett, churches, the city centre zone, you've got schools, and what you can see on this image is not only the kind of density of these different destinations, but the general proximity to that kind of star in the middle. So all these things kind of contributed to this area being identified as having high accessibility. Now, if we go through to the next slide, an area of moderate accessibility. So we're moving down Ranulph Street towards Glenholme Primary. Again, you've got some immediately proximate destinations, some schools, early childhood education, churches, but you see that density of destinations start to fall away, and some of the other kind of key destinations are kind of pushed towards the kind of periphery of a indicative 800 metres there, just for context. But that's why the kind of areas start to fall away as you go south. It's really that kind of combination of the density and proximity. And then if we go to the final one, again, if we go right to the southern end of Ranulph Street, you see, you've got a park and a neighbourhood centre, and then a few things really spread out at the kind of edge. And this area, although kind of relatively central compared to a lot of Rotorua, you can't actually get to a lot, at least by walking from it. So this is why this area was identified as an area of low accessibility. So I thought that was useful in trying to explain some of the results that we've got to and how that has ultimately informed some of the decisions that we've taken. In terms of relative demand, again, kind of my interpretation of the way that policy was worded, and when you read it in conjunction with 5A, it's not talking about an overall aggregate demand. We need 10,000 homes. It's talking about where are desirable places that people want to live. It's kind of a more localized spatial distribution. And in that NPSUD guidance from the Ministry of Environment, a lot of the areas that they consider to be of high demand actually coincide with the outputs of the accessibility analysis. So areas around centres, areas close to good schools, areas close to open space and recreation opportunities. So a lot of the accessibility analysis, I think, supports an understanding of demand. And then we looked at other kind of more quantifiable metrics around land values, even where resource consents and building consents were going, the difference between land value and capital value ratios to understand where there might be opportunities to identify. And I think they generally kind of well aligned. So areas where using those other metrics where kind of high demand was kind of around where we have the Res 2 zone proposed. There were other areas like Linmore, which again, didn't perform as well in terms of accessibility, but it's kind of elevated. You've got, northwestern views out over the lake, so you can kind of understand why property prices would be higher there. Again, 3 stories in that location. When you look at all the other factors in terms of what policy 5 and policy 8 is kind of asking, I think, that seemed to satisfy kind of demand in that area, but it's really where you had that confluence of, I think, a range of factors in terms of both accessibility and demand where it kind of justified a different response, and that's kind of informed the development of that Res 2 zone and its spatial extent. So that kind of covers off that. So it might be an opportunity to kind of break and talk through any of that information now before we get into some of the detail around kind of the zone provisions, if that would be your preference. Okay, cool. I think so. A lot of what I found is a lot of it's kind of intuitive that planners would do, and they were kind of doing, but it provides a bit more of a quantifiable evidence base to put towards some of those ideas that have kind of informed planning thinking historically, is my general take. There are some kind of outliers sometimes when you see it that you might not expect. So the example here was Ofita performed quite well in the accessibility analysis and had a lot of questions around that. But when you actually look at it, there's high school, schools, you've actually got shops, supermarket, a whole bunch of parks. It actually kind of makes sense, even though it's not kind of intuitive, it's a bit tired and run down. But I think for the most part, it really just confirms what people would expect the answer to be almost.
I mean, I guess the question for me will come back to, how do you define the edges, and why are the edges defined in the places they are defined?
Yep. I can probably kind of go to that point now. I guess that the way the methodology was constructed is it was always intended to provide an indicative guidance, because ultimately we were going to be dealing with a situation with zones and zone boundaries. So it didn't want to be so precise that you're going down to a parcel level of, oh, this parcel's high, this parcel's low, this parcel's high. It kind of had to be broad, block by block scale. And I think, as you're right, there's always that tension of, well, you end up having to draw the line somewhere. So the proposal we did, and I guess it really only relates to the residential 2 zone extent, it was where we had those areas of kind of high or very high accessibility. And then we did a process of kind of QA and go, well, why were the results like they were? And so I've set out in kind of several points in my primary statement and rebuttal evidence, I think, around some of those specific things around, you start to get further away from things like the secondary schools or supermarkets and open space, which is where, as you head south, kind of down Fenton and Randolph Street, that level of accessibility drops, although it's very good compared to most of urban Rotorua. I guess it was that once you start looking at the actual services which made up those scores, I think things like supermarkets and stuff are really important if we're looking to drive kind of mode shift and get more people walking and cycling. You kind of need that proximity to enable it. So that was really the kind of incentive for where we kind of ultimately set the line.
Just like to, if I can just jump on your question around edges, because it wasn't a question I had before, but we've been busy reading through all this information, noticing where the blobs are. and then there has been some discussion around that. May not be a question for you, but I'm conscious that, you know, where the density is proposed for or to differ, and that's heights and that. How do they transition across those edges, communicate with each other? You know, from a higher density to a lower density, so that there's still a sense of community, rather than being one side of the divide and the other. Does that kind of make sense what I'm asking?
Yes, I think so. So, I mean, the primary way that was sought to be dealt with, although it hasn't been strictly adopted, was to use roads as that kind of buffer. You know, that provides, 20-meter kind of separation. Not every area is going to be built to 6 stories, but if there is, you've kind of got that separation. The only difference is obviously when we jump over the state highway to the west, where that hasn't been done. And it was a kind of an issue which I kind of grapple with, because I think as a professional, I think it's tidier and simpler to avoid kind of those zone interface issues, and to use road boundaries would kind of be my preference. But in terms of the results to that analysis, when you kind of jump over, that area is still very accessible. There's a lot going on over there. You've got multiple high schools, primary schools, supermarkets, parks. There's a whole bunch of really good things. It's on public transport networks, and it's still pretty close to the city centre. You've got the 2 largest employment nodes in Rotorua, the city centre and the industrial area to the north there, and good accessibility. So I felt that there was an opportunity to, again, provide a bit more kind of opportunity or variety, further out for that type of residential activity to occur. But, it's not, I don't think there's any easy way. The idea is height in relation to boundary addresses part of it and stuff like that. That can only go so far. But the main way that's kind of been addressed is to try and use kind of road boundaries to help manage a degree of transition.
Great, thank you.
So moving to the kind of city centre and commercial zones. So I've addressed this in section 5 of my evidence in chief, and paragraph 6 to 15 of my rebuttal statement. The increased heights enabled generally respond to the accessibility of these areas, although the difference there is really with the extent of the commercial 4 zone along Fenton Street. So obviously, as you get further south, accessibility falls away. The key rationale for the increased height along Fenton Street was associated with kind of a desire to encourage opportunities for redevelopment of that street. There's been some of the feedback that we received through both the FDS and kind of the plan change process was kind of some of the quality of the development, the nature of the existing motel and hotel accommodation along there isn't necessarily the best. There's a general desire to push a lot of visitor accommodation closer to the city centre. So trying to provide meaningful and useful pathways for people to potentially redevelop those motels was seen as a potentially good benefit. And the actual road itself, very wide, highly landscaped, again, probably somewhere that can handle increased heights in buildings quite well in terms of the overall kind of streetscape. So that was the kind of rationale along Fenton Street. With increased heights in these zones, there is invariably going to be an impact on kind of surrounding areas or existing and future residents within the commercial zones. So what we've done is we've offered a kind of a fairly pared back number of amenity related provisions around outlook space and minimum unit size, but that's to try and reflect that yes, there's kind of a minimum standard, which is generally appropriate in a unit, but they've got those other benefits. So if you're in the city centre, you're close to cafes, the library or parks. So you don't necessarily need a huge balcony or a huge apartment to fulfill your daily life. And again, it was that part about getting some more variety, both in typology and location and choice there. Some people will like living in the city centre. Some people will not like living in the city centre. So just trying to provide those options for the market to take up if it is attractive was really kind of one of those overall rationales. In terms of the residential development in the COM2 and the COM6 zone in particular, and to a lesser extent, some residential at ground floor in the city centre 1, there are some submitters requesting that we don't enable residential in those areas. I don't think it's appropriate based on where they are located within the wider urban environment next to the city centre. close to schools, close to parks. In my mind, they're actually very well suited to intensification, and even more uniquely, they are large consolidated land holdings where you're essentially dealing with one kind of developer. You don't have the kind of tyranny of cadastral boundaries affecting your development. So there's a really good opportunity to realise some intensive residential development in the City Centre 2, COM6 and COM2 zones close to the city centre, which would be more difficult to realise in the City Centre 1 zone and Res 2 zone itself, just due to the nature of existing land holdings. And in my experience, it's becoming increasingly common for these areas to do that. There is or at least in my discussions with a lot of my clients, there's a big shift in terms of the retail environment. There's a big focus on getting a residential base in these kind of commercial areas. So there is a kind of a captive market close to these areas. It's more attractive, and it helps with the overall kind of placemaking and making it an attractive environment that other people might want to come to, rather than just necessarily as an area which people drive to and leave. So again, I think getting more residential in those city centre and commercial zones, I think, is imperative to the overall kind of vitality and vibrancy of the city centre and its surrounds. In terms of the residential 2 zone, so I've addressed the need for this in section 6 and 7 of my evidence in chief, and in paragraphs 24 and 32 of my rebuttal statement. Just reflecting on some of the conversations this morning. So there's obviously that question around what does commensurate mean? It's probably not the most helpful policy directive from central government, but we have to kind of make a go of it. I think in my mind, when I come back to the accessibility analysis, looking at the kind of range of destinations available in and around the city centre, there really is a good opportunity for someone at various stages of their life to live there, to essentially live a car-free lifestyle as they're possible. So it's an area where we want to be encouraging as many people as possible, I think, to live in that area. And then it comes to the question of, well, we've got our 3 levels under the MDRS enabled. In my mind, that kind of sets a floor, and you go, well, is it appropriate to go above? I think in terms of my overall philosophy on this, I think there is a need to encourage more density close to the city centre. I would prefer a larger apartment building in the Res 2 zone than a bunch of smaller developments scattered out in the Res 1 zone. I think you want to still encourage development to occur as close to the city centre as possible. The MDRS doesn't really kind of do that. It kind of opens up those opportunities. So I think it's important to provide that differentiation. And 2, I think it comes back to a general idea around kind of feasible development. So, it's going to vary from site to site. Not every site will be able to deliver larger apartment typologies, but at least the work I've been involved in and the things I've heard is a good rule of thumb is around 6 stories is kind of that minimum to overcome the challenges of the increased structural costs of higher development, lift cores, all those types of things. So it's definitely not necessarily always the case, especially I reflect on places in Auckland with very high land values. A lot of the ridge lines overlooking the water, you can command quite substantial prices for apartments, so you can do lower level. But I think as a general rule of thumb, that kind of 6-story minimum, if you're going to do something in terms of a high density zone, is really your starting point. So we've come up with that level of around 6, maybe 7 stories, depending on internal floor configuration, which is, in my mind, appropriate, especially when you consider the heights that we're proposing within the city centre and commercial zones, and which were already enabled in the city centre zone. So that 22 metres that we've recommended is pretty comparable to the 20 metres already enabled in the city centre one. And in my opinion, the level of accessibility in the Res 2 zone is comparable to a lot of that kind of southern end of the city centre already. So I remain of the view that the 22 metres is appropriate. The key kind of points of difference which remain, apart from the fact that some people don't want the Res 2 zone at all, really are related to height in relation to boundary and the building length control. So the approach for the height in relation to boundary, I still think you can get efficient, simple building forms in a 12 metre plus 60. It enables 6 to 7 story development on an average site in that zone. But there may be a need to trade off. If you want that simple, tall building form, you might need to come further back off the site boundary. That provides opportunities for more space between buildings. I think that's appropriate within the Res 2 zone. It's not a commercial zone where we've got no yards, you can go straight up. it's that kind of point of difference. It's another different kind of typology, bit more opportunity for landscaping and openness. Similarly, the more restrictive height in relation to boundary at the rear of the site, again, that's just to provide a bit more kind of space and openness across development if it is to occur. It's kind of more in line with the idea of kind of perimeter block style development, but within the kind of constraints of the New Zealand cadastral pattern and kind of RMA system. So it's the alternative approach is used in Auckland already, albeit slightly differently. I have seen its benefit in terms of how it can encourage building to locate closer to the street, where the street can absorb some of those effects rather than necessarily the neighbours. So I think it's a positive approach to encourage some, I guess, more sympathetic outcomes to neighbouring sites, albeit there will still be substantial change to neighbouring sites. The building length control, again, so this has been kind of designed to work in concert with the height in relation to boundary control. It's worth pointing out that it still enables quite a large building. You can still get large apartment buildings within a 28-metre length. You can get runs of terraces comfortably within 28-metre length. But I think this was in part to address the issue of the kind of New Zealand cadastral pattern where you have typically longer, narrower sites. And what we're seeing everywhere is everyone runs a driveway down one side and you just get long buildings going down and they're all orientated over the side boundary. It is trying to act as a partial disincentive or at least a reason for people to kind of consider that in their design process and try and consolidate buildings into kind of one more efficient form towards the front of the site. In my experience, I've gone through a lot of resource consent applications where this kind of may be covered in more matters of discretion or assessment criteria, and you spend a lot of time kind of horse trading around where council, what they really want is, some definite building breaks or something like that. I think that's a better solution than just varying kind of materiality and doing little recesses on the facade line and stuff like that. Starts to make things very complicated. I think longer term maintenance issues start to get in there. So I think this is a kind of a simpler way of potentially managing that issue. And I think it's really important as you get those taller buildings above ground floor. So a 6-story building where you're looking over your neighbours could be quite intimidating. So to try and at least alleviate that to a degree, I think is an important outcome, which is why I continue to kind of advocate and support it.
What's the evidence for this being successful?
There are a number of jurisdictions in New Zealand already which utilise the kind of maximum building length control, and the evidence I've seen, it does kind of they do it in slightly different ways. They might have a dedicated recess dimension or something, which I've seen you must have a recess of say 6 metres by 4 metres back or whatever. It just generally leads to slightly smaller building forms in some places. In some places people obviously challenge it and go through it. There are situations where it could be appropriate. And again, it only applies to side and rear boundaries. So it's probably unlikely to be triggered in a lot of instances. It's just for those really, really large sites. In my experience, a lot of developments, especially in Auckland now, are adopting this approach of breaking up building forms to address the street and have a number of smaller buildings behind. I know when the unitary plan first came out, although they don't have this control, the matters of discretion have kind of got it there where you were seeing those long runs of terraces just perpendicular to the street. Now there's been a definite shift, I think, within the development community to break off the front of development, have it kind of respond to the street and have a series of terraces maybe running off to the back. So slightly different circumstance, but I think in the Rotorua context, providing that kind of upfront, at least kind of certainty for council officers and applicants, I think is an important component which leads to recommending this control. So I couldn't probably point you to any hard and fast evidence. Part of it's
In the back of my mind is the question, is it enough? If in actual fact you're trying to actually change behaviour in that way, is it a strong enough control?
Well, yes, and I mean, I had it. I mean, I think we had it stronger in the notified version. I think some issues were pointed out by other parties around things like permitted baseline and stuff like that, which potentially made it a bit challenging to implement in that version, which I kind of had to accept, which is why I think I've recommended modifications to kind of address that issue. I would probably prefer it to go further, kind of in line with what was notified, but acknowledge that that may not be possible in terms of the way the overall MDRS framework has been set up. So I guess it's a compromised position on my behalf in terms of what I think is a good outcome and what the kind of MDRS is essentially.
I mean, I'm still thinking, and I haven't actually got my head around it yet, is whether in actual fact policy 5 makes a difference to the way that you approach that particular issue, because you're not talking about simple MDRS at this point. You're talking about height and density, commensurate with, et cetera, et cetera.
Yes.
Oh, well.
So the final bit we wanted to talk about is related to that subdivision. So Commissioner Hill, you obviously heard me recently talking about this at a little bit of length. My position has evolved since we've notified, and I've been involved in these other IPIs. So my stance has moved a little bit, and I've tried to set that out. I still think generally within the existing urban area where you've got development that's already occurred, I think it's important to provide increased flexibility for that other kind of development pathway using the kind of shape factor approach, allowing for kind of smaller sites. The 8x15, which I advanced in my evidence initially, kind of had time to reflect on some other evidence that I received and acknowledge that it was quite inflexible, especially when you have some varying topography and stuff. So I've slightly amended my recommendations around that to provide a bit more flexibility. I think it's important to note the intent was to not enable a 3x3 on this vacant lot subdivision. I don't think that's required. There's nothing to require you to build 3 units. I think this is just an option to enable some smaller scale, kind of gentler density, still consistent with the overall idea of intensification, but just provide that kind of other opportunity or pathway. So I actually think it was important that the development kind of limits the ability to do that kind of 3x3 development on these smaller vacant lots. And then I kind of added to that, I think there's some practical realities of if someone was to do this, well, they'd still have to either kind of sell off the land or rent out the apartments. And if they are really average, if they trigger a whole bunch of issues, are they likely to go ahead? Are they going to be competitive with what else is being offered in the market in terms of rental prices and stuff? So I see kind of the risk of kind of bad outcomes to be fairly low. They would still be subject to kind of development controls around outlook and yards, which essentially set the baseline for acceptable. So I'm comfortable with that approach. Where there is opportunity for maybe differences, where you have that difference between an established area and a kind of greenfield area, which is zoned for development, where I guess in a greenfield area, you've got a lot less kind of constraints. It's really a kind of blank canvas for you to address it as you kind of see fit. But those areas are also at the generally at the periphery of the urban environments where we kind of want to be directing more development closer to. So I think that idea of if you are going to have a split, having it kind of in those areas, those larger greenfield lots is where you would do it. And that testing I sent through for the 300. Yes, please. Sorry. So I just so when we were looking at the kind of vacant lot in general, we were doing some testing around the 120 to 170. This is just an example of a 300 square meter lot. Obviously, a lot of it comes down to lot dimensions, but here's an example very crudely of where you can fit in a 3-story terrace with sufficient room for vehicle access on site. Obviously, it needs to be refined through the design process, but broadly speaking, you can fit in a 3-story terrace with vehicle access, car parking, meeting all your kind of outlook yard requirements. Vehicle access would be a big driver for ultimate outcomes because it can chew up a lot of land. So in this example, the outlook space and outdoor living space would be achieved from the first floor. If you could skip to the next slide. Oh, maybe it was the slide before. Oh. Okay, there was another option where you didn't have car parking, and again, you can comfortably fit 3 stories in on a kind of typical 300 square meter lot. obviously a lot more generous once you remove the need for on-site vehicle car parking. I'm still of the opinion that you should be assuming people don't have to provide car parking. Here we go. So that's again trying to show that you can comfortably fit kind of 3 stories, 3 units in a 300 square metre, which I think was the part of the kind of rationale that Ms. Fairgray will discuss with you. But again, I think the 300 is quite generous in terms of what you can do. It'll really come down to individual design decisions, where roads are located, where open spaces, how that's going to dictate height in relation to boundaries. So 300, it's smaller than kind of typically used to, but again, you've still got a lot of flexibility in 300 square metres. And again, I don't think you want to go too large, because once you start going higher and higher, you start to move away from a subdivision pattern, which couldn't be described as anything close to, say, medium density development. And it would be fully reliant on then people coming in and doing subdivisions for comprehensive or developing to the 3x3. So I think there is a balance to be struck, but yeah, I'm confident that the 300 at least provides that opportunity for more intensive building opportunities, should it be required. So that's really all I had to speak to you today. So happy to take any further questions.
Thank you. Just looking at those 2 diagrams there, that one and the preceding one, the different colours, is that 3 different units, or is it all one unit?
It's the different units.
So you can fit 3 3-story units on that.
Yes. And each of those are around 125 square metres.
And can we get copies of those 2 diagrams? I don't recall seeing those.
Yeah, I just pulled them together in the lunch break. But
it's helpful.
But you've been thinking about it for a long time.
well, I've got a whole suite of 3D models I could swing open to the panel if you like.
Yeah, you said in it, and correct me if I'm wrong, that in terms you were responsible, if not fully or partly, for defining the spatial extent of the high density residential 2 zoning.
Correct.
And it appears to me from your evidence you've based that primarily, if not wholly, on accessibility.
Accessibility, and I would say demand as well.
I was going to ask to what extent your analysis has been tempered by demand, because when I look at Ms. Fairgray's evidence, she said over the long term, which is a 30-year horizon, there's not an extra 9,700 dwellings required. She estimates only 5,600 of those would occur within the urban area. And yet the high density residential zone has a capacity for 25,200 additional dwellings, of which 14,700 would occur within the HDR zone and the rest within commercial centres. So I guess my question is, why is the notified Res 2 zone so big when it doesn't seem to be necessary to cater for the demand that's been put before us in evidence?
I think the main reason is you cannot guarantee what sites will or won't come forward. You need to provide that opportunity. Yes, there's currently limited demand for attached typologies in Rotorua over the 30-year period, although, I guess there's a lot of uncertainty over that 30-year period in terms of what that kind of uptake will be. But I think you've got landowner motivations, you've got site feasibility, which will vary by site. Heard feedback where, say, the geothermal conditions in Rotorua can have an issue in terms of what's feasible in terms of building height. Other sites may be suitable. It's all going to vary site by site, kind of landowner by landowner, developer by developer. So I think as a broad principle, I think it's important to ensure that opportunity for the market to take up more intensive housing is made available. And the smaller the area you do that, the less opportunity there is to realise potential for apartment development.
So how did you take Ms. Fairgray's demand estimates and use those to determine where the Res 2 boundary should be?
I didn't take Ms. Fairgray's demand estimates in that sense to limit the Res 2. It was, I guess she was more focusing at that kind of aggregate citywide demand scale, whereas I was more focused on how I read policy 5B as a more localised understanding of demand. Where do people want to live? Around nice parks, around nice schools, close to amenities, good land values, all those types of things. And that's what's kind of informed that Res 2. This is where you had combination of those accessibility traits and kind of good land values that could support redevelopment were kind of converging in that Glenholme North area.
And did you do any ground truthing with developers to say whether or not they would actually want to take up this opportunity in the Res 2 zone?
We've had, I haven't been involved in a lot of the consultation. I mean, we've discussed we've discussed high density residential extensively through the development of the FDS and the plan change. We've had lots of discussions with the likes of Kāinga Ora. Kāinga Ora obviously interested in high density residential. One of the issues in Rotorua currently is a lot of the development market is essentially home builders, vacant lot, they'll build a house, sell it off. So you don't actually have that local capacity currently in the market who go out and look for kind of apartment style development. Retirement villages are probably a slight exception to that, where they are kind of doing those models. So part of it was also signalling to the kind of wider development community, which may not exist in Rotorua, that, you know, if you are looking at that type of development, you know, Rotorua is a place where that could occur, and within Rotorua, this is where it's going to occur. But I don't suspect that on day one of a approved plan change that you're getting a whole bunch of apartment applications, because I don't think you've got the capability within the local market yet.
Just two matters of detail. One arising from your evidence that formed part of the original 42A report, or that came in at the same time. And if you could turn to para 9.4 of that evidence, which is on your page 33.
Yep.
And you say there, I'm looking at the last sentence, that the shape factor, and I acknowledge you've come up with different shape factor now, a slightly bigger one, but you say it must be free from things like excessive easements, flood hazards, maximum site gradients, etc. Do you think it's important that those elements are specified in the rules?
Yes, I think they should definitely be within the.
Okay, so substandard S 1.2 as currently put to us doesn't refer to those specific elements. It just has a general kind of phrase. Says it has to be capable of accommodating complying development. So I take it from your answer, it would be helpful if that actually was more explicit and referred to these matters that you have raised.
Yes.
Yeah, okay. I think I've got one more for you. Let me check. Oh, yeah. So in your rebuttal evidence, paragraph 6.9.
So, sorry, what paragraph?
6.9, so the bottom of page 18.
In my rebuttal or primary?
Rebuttal.
They may have been renumbered subsequent to the one
It's
I've.
the very last paragraph before your conclusion.
Oh, okay, yep.
Yep. So I was interested in what you said there. You say both the Res 1 and Res 2 are inconsistent with the provision of more intensive housing and could promote lower density residential uses. And you consider both options unnecessarily block off different consenting and development pathways for no obvious urban design benefit. It kind of made me think you don't really agree with what's being promoted here. So what's the solution in your mind?
I would probably say it's fair to say there was some slight differences of opinion amongst the wider council team around this matter. I think my primary interest is really enabling more intensification in and around centres, which is why I kind of advocate for the shape factor approach now rather than the minimum site area. Yeah, that's, you know, I guess I tried to kind of explain it before, and that's kind of really where I sit. I'm less. I really haven't turned my mind into a lot of detail around those outlying greenfield areas in terms of vacant lot subdivision. Previously, as part of the Waikato hearing, I kind of discussed it at length, I think, with Commissioner Hill around what I'm seeing in terms of developers coming to the market, where I think they are naturally offering a range of kind of site sizes, smaller to larger, as part of kind of comprehensive development. So my experience is that the market is kind of regulating itself in terms of what people actually want, in terms of that product. If they're going to spend X hundreds of thousands or millions of dollars on a new home, they have expectations around site sizes, building typologies, floor areas, and those types of things, and those kind of regulate, what happens. So I think my general position is, I think within the existing urban area, I think we want to provide as many kind of pathways to enable intensification as possible, to provide different opportunities for different, mum and dads to subdivide off the back of their lot or something, rather than just relying on home builders or large scale apartment developers. I think it's important to get that kind of range of options to potentially provide different typologies at different price points for a range of people.
There's quite a general answer. You sort of, that paragraph in my mind, you throw a grenade into the provisions. So I'm really wondering, what solution did you have in mind? And could you be a bit more specific about it?
Well, my solution is I don't think there should be the minimum lot size approach within the existing urban area. I believe, if the shape factor approach applied to greenfield, I think that could work as well. But I think it's important that whatever standard you set at greenfield, because it is different, it is located on the periphery. I think whatever standard you set, you don't necessarily want to set it so high that you're just basically putting in place where all you can do is kind of low density residential subdivision. I think you want to be able to capitalize on the fact that you've got a large site which is relatively free from constraints, and you kind of want to maximize the limited urban land you've got left. So that's kind of where I've kind of come to. In theory, it's a lot easier in greenfield because you don't have these issues with existing property lines and stuff. So you shouldn't really encounter a lot of these kind of issues with smaller scale subdivision.
Yep. So I've written down your solution is no minimum lot size in the existing urban area. And where did you get to on the greenfield then? Just say that again.
I'm probably sitting on the fence, to be honest, in terms of greenfield. I can't wholeheartedly go, yes, we need a minimum of 300 in greenfields. My experience to date is people are delivering smaller than that, and they're delivering acceptable design outcomes. But if you are to kind of set a level, 300 does provide that opportunity for that 3x3 development. When you start to go smaller than that, it becomes increasingly kind of challenging. So that seems like a reasonable approach if you are minded to go that way.
Yeah. Right. Thank you.
So that is the question I asked earlier, which was the magic of the 1400 meters square.
So what we did is we looked at, and we actually did look at other options around 1200 meters, 1500 square meters. So it was this idea of, well, what is the typical site in Rotorua and the existing kind of Res 1 and Res 2 zones? And about 90% were smaller than 1200 square meters, and 95% were smaller than 1400 square meters, and I think it was about 96 were smaller than 1500. So the large sites that you had left were predominantly schools or unzoned reserves, those types of things. And then there's a few large sites scattered around the Rotorua urban area. So that 1400 number felt to be pretty representative of kind of where infill development would occur, and kind of setting that trigger for a parent lot if that rule was to apply. So that was really the logic.
What's the risk if you don't have an upper number?
In terms of?
Well, you don't staple in the 1405 or whatever the number is, or 1200 or 1500. What are you trying to achieve in terms of that last few percentage points? The last few percentage points, it just became, it was more for kind of simplicity to kind of capture as much as possible. Starting to try to figure out where exactly you get that kind of 99 or 100%, which isn't a kind of reserve, an unzoned reserve or school, kind of started to become a bit kind of difficult and time consuming. And that seemed like it was a fairly logical
number that was pretty representative of the developed area of Rotorua.
I have to try and think what I've heard before, what I've written before, and what I shouldn't be hearing now. But yes. Thanks for a moment, anyway.
Thank you.
242. One more.
Well, we will return to the section 42A authors now and just continue with the more technical matters. But if I could just clarify one matter in response to a question there. There is a rule sub S1.2, which is the site design factor, which refers to the shape factor plus the list of constraints that are to be excluded, just if you wanted to look at that. And it is in Appendix 1 to the addendum. The rule is SUB-S1.2. And it should show the new amendments that are proposed in the addendum.
Yeah, thanks. Yeah, that must be there. Yeah. So that wasn't in the initial version. It's coming now. Yeah, it's good.
Smith.
So I'm, excuse me, another one of the section 42A report authors, and I'm hoping to take you through a summary of the key matters addressed in the sections of the 42A report and the addendum that I authored. So starting with natural hazards, and in terms of natural hazards, the plan change focused on those hazards that were considered to present the greatest challenges for intensification. So that's geothermal and flooding hazards, and that was with consultation with the regional councils. With respect to flooding, Plan Change 9 proposed the following changes to improve the management of flood risk in the context of intensification. And these are detailed in the Section 42A report. Number 1, amending the performance standards for impervious surfaces in the residential 1 and 2 zones. That's already been mentioned a few times today. So from 80% and 100% to 70% and 80%. And there's also a related policy and matter of discretion relating to impervious surfaces proposed. Clarifying the requirements for minimum floor levels and setting the design flood to the 1% AEP with an allowance for climate change, which is consistent with the practice, the current practice in implementing the Building Act hazard provisions. And that's also in NHR 4 that we've also discussed a few times. Introducing a new restricted discretionary rule to allow for a specific assessment of building within areas that are susceptible to flooding in NHR 4. And the threshold proposed for this requirement for the assessment is where the flood depth at the building site is anticipated to be more than 300 millimetres in the design event of a 1% event with an allowance for climate change. And also introducing supporting policies and matters of discretion to reflect this approach, which are in NHPA, NHPB, and NHMD1 for matter of discretion 1. This requirement for a flood risk assessment through the restricted discretionary rule was assessed as a new qualifying matter in the Section 32 report and again in the Section 42A report. It was difficult to quantify the impact on development of on development capacity of this rule. On some sites, the flood hazards are likely to be managed through site design, including minimum floor levels, with perhaps no overall impact on capacity. And in areas where the development is more constrained, it is likely that these areas would also be subject in any case to restrictions under the Building Act, which would reduce development capacity, notwithstanding this requirement for a flood risk assessment. In addition, Plan Change 9 also proposed the streamlining of subdivision rules and performance standards, which is an existing qualifying matter that's discussed in 8.5.2.1 of the Section 42A report. We received a number of submissions on flood hazards, including from the regional councils, Waikato and Bay of Plenty regional councils. And in response to these submissions, I have recommended amendments to wording of rules, policies and matters of discretion, which are set out in the Section 42A report. And then based on further evidence from Mark Iverme, Lucy Holden and Hannah Craven from the regional councils, I understand that they are generally supportive of the approach proposed by PC9, but seek some additional wording changes. So in the addendum, while I have not supported exactly the relief sought by the regional councils, I have attempted to accommodate what I interpret as their underlying concerns with respect to managing risk off-site and intolerable risk, with some additional wording changes, which is set out in the addendum. So I can carry on to geothermal hazards. Yeah, carry on. So with respect to geothermal hazards, Plan Change 9 proposed a new policy, which was to minimise the risk to people and property from geothermal hazards, including by locating the discharge of any geothermal gas away from confined spaces on a site, and a corresponding performance standard, which was NHR 8 in the notified version, which required that within the geothermal systems overlay, which covers the central part of Rotorua, that any venting structures necessary for gas shall be directed to a vehicle access way or street. The development of these methods and policy was informed by a risk assessment that was commissioned to help develop Plan Change 9. And you can find that in Appendix 14 of the original Section 32 report. But importantly, it was assumed at that time, when PC9 was developed for notification, that the building consent process provides significant opportunity to assess and consider mitigation for geothermal risks. You can see a discussion of that, for example, in the risk assessment report on page 20. The regional council's submissions, however, noted concerns about the scope of the Building Act and sought a greater role for the district plan in managing geothermal hazards. So to assist with the response to these submissions, the council, with funding assistance from the Bay of Plenty Regional Council, agreed to commission a legal opinion on the extent to which the Building Act and Building Code can be used to address geothermal hazards. And that's in Appendix 6 of the Section 42A report. So based on this advice, my understanding is that the Building Code, it does contain various clauses that provide scope for the council to require assessment and specific design with respect to durability, structural stability, and the ingress of harmful gases and potentially heat. However, there are limitations with respect to the management of impervious surface levels, wider surface treatment, site design, and the potential to exacerbate heat and gas issues in the surroundings and future development potential. So in the Section 42A report, I supported the key relief sought by the regional councils, but with some modifications. And if adopted, this would result in a new performance standard requiring a site-specific assessment of geothermal hazards and mitigation measures to be submitted with building consents. So this is all in the Section 42A report. The evidence of Lucy Holden on behalf of the Bay of Plenty Regional Council was generally supportive of this recommendation, but sought that an additional clause be included with respect to compliance with the assessment. In the addendum, I supported this, but again with some modification. Kāinga Ora, in their further submission, was generally supportive of the relief sought by the regional councils, but considered further refinement was necessary. And now the evidence provided by Ms. Tate on behalf of Kāinga Ora suggests that an alternative restricted discretionary rule for building is preferable where the hazard assessment identifies a hazard. I, however, do not support this alternative as approach because I consider that this rule would be too subjective. Right, so now turning to transport.
Yeah. Questions at the end, yeah.
Okay, carry on. Plan change 9 proposed with respect to transport, mandatory and non-mandatory objectives and policies that have relevance to transport, matters of discretion for residential units and building design and site layout in the city centre and commercial zones that also have relevance. In residential zones, it proposed to increase the number of units that can be served by private access as a permitted activity from 8 to 20. And it also proposed to amend Appendix 1 to require a lower order traffic assessment for developments with 20 to 99 residential units. And this is noting that an integrated traffic assessment is already provided for in the district plan for developments with over 100 units or 100 or more units. In response to submissions and the evidence of Mike Nixon, Paula Meredith, so Mike Nixon is from Commute Transportation Consultants, Paula Meredith, who is our Land Development Engineering Manager, and Craig Goodwin, who is our Waste and Climate Change Manager. I recommended in the Section 42A report and the addendum some further changes, including additional standards for private accesses to address maintenance, access for emergency services, delivery vehicles, and rubbish collection, and to clarify how you calculate the number of units on to determine whether the performance standard had been exceeded. Refinement of the matters of discretion, inclusion of a reference to cycle parking within a policy, CCZ policy 5 for the city centre zones, and removal of standards relating to separation of access to front doors from manoeuvring and parking areas. In the Section 42A report, I also recommended that the traffic impact assessment requirements of Appendix 1 be clarified with respect to rest homes. And this was on the basis that Plan Change 9 may result in amendments to the discretionary status of rest homes and remove the ambiguity about whether they are residential units in terms of the requirements of the appendix. And based on the evidence of Mr. Nixon, the threshold I recommended for the integrated transport assessment was 100 rest home units. With rest home units also considered to include rest home beds in a care facility. So based on the evidence circulated before the hearing, I consider that this is the most contentious remaining issue in relation to transport. The Retirement Villages Association and Ryman Healthcare seek that the threshold be increased. They argue because retirement villages result in less traffic than comparable size residential development, and the traffic doesn't occur at peak times. So you'll find that in the evidence of Ms. Williams, paragraph 105. However, I continue to support the recommendation in the Section 42A report based on the evidence of Mr. Nixon, and that is while rest homes may have a lower traffic generation than standard residential developments in peak hours, there are a range of relevant matters that should be addressed in an integrated traffic assessment. So turning to infrastructure. So Plan Change 9 proposed only a small number of related changes to provisions addressing infrastructure, some new objectives, that development is supported by adequate infrastructure and services. Those are residential objective 5 and objective 12. Policies for these zones relating to the consideration of infrastructure in relation to developments for 4 or more residential units, and those are in policy 7 and policy 16. And a corresponding infrastructure matter of discretion. In the Section 42A report, I recommended wording changes to the policies and matter of discretion to address submitted concerns. I also recommended a water servicing performance standard be inserted for residential development in response to the submission of Fire and Emergency New Zealand. And this would require that developments that will not be connected to a public reticulated water supply demonstrate the alternative water supply is adequate for firefighting in accordance with the code of practice. So the most significant remaining issues noted by submitters in their pre-circulated evidence were a request for CHIEL consultants to broaden the policies for consideration of the adequacy of infrastructure so that it is not limited to applications for 4 more residential units. And amendments sought by the Fire and Emergency New Zealand to the recommended water servicing performance standard so that it would not be limited to those that are connected to a public reticulated water supply, but would also apply to developments that require a higher level of service. I do not support either of these requests as explained in the addendum. Regarding the request to broaden the policies about ensuring adequacy of infrastructure so that consideration is not limited to 4 more residential units, I noted that council does not currently have such policies or matters of discretion for permitted levels of development. And despite the increase in the permitted level of development under the MDRs, I consider that there has not been sufficient evidence to demonstrate that this policy is necessary. And I did not support the request to broaden the performance standard for demonstrating firefighting water supply to developments that require a higher level of service, because I consider this uncertain with respect to what is requiring the level of service and what the level of service is to which the development can be compared. And now the rail and gas corridors. So submissions were received from Kiwi Rail and First Gas that sought additional provisions to protect the rail and gas corridors from adjacent development. First Gas sought a performance standard for requiring consultation with First Gas for sensitive development in the pipeline corridor, which would be mapped adjacent to transmission and strategic distribution gas lines. And Kiwi Rail sought that a 5-metre no-build setback be introduced adjacent to the rail corridor to ensure that people can use and maintain their land and buildings safely without the need to extend into the corridor. In other words, that side and rear yards be increased. In the Section 42A report, I recommended that both submissions be rejected. I did not consider the relief sought by First Gas efficient in the context of existing before you dig the online service. And I was also unclear from the information provided as to where the performance standard was sought, and no further material has been received from First Gas. So my recommendation remains to reject the submission. And with respect to the Kiwi Rail submission, I was concerned that it would need to be assessed as a new qualifying matter, that no such assessment had been completed, including where it would apply, the effects of development capacity, the effects on development capacity, and the need for the restriction in the context of an unused railway corridor. And I was also concerned that Kiwi Rail had misinterpreted the district plan with respect to whether eaves could overhang into the yard. Further evidence has been provided by Kiwi Rail and has provided some further information about the use of the line. It is currently partly used for tourism. It has the potential to be used to carry logs, but according to Kiwi Rail, is more likely to be fully invigorated for use as a tourist passenger service, and it has also been identified as a potential passenger line. Kiwi Rail states that such activities have the potential to be impacted by adjacent building. So I agree that the rail corridor could provide a basis for a qualifying matter, but on the limited information provided, I continue to recommend that the submission be rejected. Now turning to financial contributions. Under the discretionary elements of Section 80E, the plan change proposed amendments to provisions for financial contributions for reserves, and these are in Section 8.10 of the 42A report. And most notable were a reduction in the rates for reserve contributions from 5% to 3.5% of land value for most zones and 2.5% of the nominal land area for rural zones. And the enablement of taking of financial contributions for reserves from permitted residential units. There were also changes proposed to the objective for reserve contributions, which is also clarified as their purpose to align the purpose with intensification and the consequential shift in focus to the development of existing reserves. Most submissions supported the changes, but one submitter did seek that the contribution rates not be reduced. Another sought that reserve contributions instead be addressed through development contributions. And the council has already noted an intention to consider this option, but in the meantime, I consider that the proposed changes are appropriate and should be adopted. And submissions were also received in respect of financial contributions for infrastructure, which are not proposed to be amended through this plan change. Now rezoning. So submitters sought that 4 areas be rezoned to residential. The plan change itself did not propose to rezone any areas to residential. The evaluation of options in the Section 32 report addressed zoning only in respect of the issue of whether a high density residential zone should be incorporated and where this should be located within the confines of the existing residential 1 and 2 zones. In the Section 42A report, I recommended that the rezoning submissions be rejected. I stated while that some of these proposals may have merit, further analysis would be required before progressing to rezone these areas. No Section 32 assessment had been completed, and nor had a natural hazard risk assessment and structure plan been completed for the larger sites as required under the Bay of Plenty Regional Policy Statement. I was also concerned about a lack of participation of stakeholders. Of the original submitters, only Somerset has circulated additional evidence, which relates to their request to rezone a 14-hectare site at 171 Fairy Springs Road from Commercial 5 zone, city entrance tourism, to Residential 1 zone. The site is currently the subject of a referral under the COVID Fast Track Consenting Act for the development of a retirement village. And the site has been identified for potential rezoning to Residential 1 zone in the draft future development strategy. And while a number of technical assessments have now been circulated, these relate to the development of a site for retirement village, and my recommendation remains to reject the submission. And my last point is on community housing. Ara Potama, Aotearoa, the Department of Corrections, has sought that the definition and provisions for community housing be deleted on the basis that this is just a residential activity. And the Ministry of Housing and Urban Development has also sought changes, that is to amend the definition of community housing to remove the limit of 8 persons and to provide for community housing as a restricted discretionary activity beyond the occupancy limits of a permitted activity. A number of further submissions were received in opposition to these submissions, while Kāinga Ora's further submission supported the Ministry of Housing and Urban Development. I recommended in the Section 42A report that these submissions be rejected, as evidenced by the recent resource consent hearings on emergency housing. Community housing can have a range of effects on the environment which require consideration, and I was not convinced that the relief sought would be more appropriate, and considered that further input from stakeholders and consideration would be required to develop a restricted discretionary framework. Ms. Tate, in her evidence pre-circulated on behalf of Kāinga Ora, also agreed that more work is required to determine the appropriate way forward, and that's at paragraph 14.4. Thank you.
Just a couple of questions relating to the flooding provisions, which were bounced to you from the earlier speaker. I've already given you some wording relating to NHR4, so just imagine we'll be getting a reply report in due course from the officers.
Yeah,
So
I can give you a preliminary reply to those wording changes on the design standard. Essentially, I think that it read well.
Okay, thank you for that. I had another question relating to NHPA and the same issues arise in relation to MHMD1. And it's just around some of the terms that are used in there, specifically residual risks, acceptable level of risk, and then environment. And my question was, and you don't have to answer this now, you can reflect on it and come back and reply, but unless you want to answer it now, do those terms need to be defined? And I'm particularly interested in the word environment, which is defined in the RMA, which is in that RMA definition has some quite vague and nebulous terms in it, including amenity effects and values that affects the things that are higher up in the definition. And I was wondering if you were happy with that definition of environment featuring in these provisions, or you had something more specific and nuanced in mind.
I do, to be honest, I do have some reservations about that broader reference to environment and how that will be implemented in practice. That I recall that that part was inserted on the submission of Waikato Regional Council to align with their regional policy statement. I do think it will be more complex referring to that and when it comes to implementation. But I do understand there may be some aspects where this purely property focused analysis, that was how it was originally drafted, if we were to stick with that as well. So yeah, I mean, I don't have a final answer. I think it is something really complex. I can give it more thought.
Yeah, I'd appreciate that. Just as a decision maker, I'd struggle to know what that required of me, particularly if I'm then directed to the definition of environment that's in the RMA. I just don't know how I would make that provision work. And then my other question, which is bounced on to you, was just a query about why within sub standard 9.1.A. Romans 1, it's an amazing numbering system you've got. Why the words "which will be free from inundation" were recommended to be deleted from that provision. It seems to me that provision relates to having a foundation that's suitable for the intended use, and to have it free from inundation would seem to be quite sensible.
Oh, sorry, I might have to.
Yeah. So the standard is sub 9.
So it's a subdivision one, did you say?
Yep, sub S9. Yeah, site serviceability, and you just recommended deleting those words in red font, and I just don't understand why, because they seem quite sensible words.
Oh, I believe that was because of the awkward crossover with the other subdivision specific rule. There's an actual subdivision rule which has triggers consent if your site has inundation. So it was an awkward double up in provisions. I can refer to the rule that has the.
Right, well, can you maybe also reflect again on that and see if, upon reflection, if it's sensible to delete those words, because just taken on their face, if the foundation needs to be free from erosion, subsidence and slippage, it would seem odd that it's allowed to be unfree from inundation.
Yeah, I think that the inundation is the only one that has its own specific subdivision rule that creates its own activity status.
Okay. That was all. The rest of your 42A report was clear. I don't have any questions or clarification. Thanks.
Kia ora. Just one question, going back to the Somerset submission and request to rezone. Putting aside the analysis, I'm just curious, I'm assuming if they're successful, what has been referred or will be referred? The Minister has referred it, right? So that they'll go through a plan change and what have you through the fast track process. I'm curious whether in your mind we need to give any weight to that pending rezoning and consent, notwithstanding that just because you're doing fast track doesn't mean you get consented. Yeah, just wondering from a PC9 perspective whether we need to give any weight to that pending development.
I would give it limited weight. I believe that it's been accepted for processing and for the activity itself as a resource consent. So I would give it limited weight.
Thank you.
Well, just looking at the provision that you're proposing, which is NHR 8, Rule 8. Just to understand what's being proposed here, as I read that, the provision only kicks in at the point of time in which you make an application for a building consent.
Yes.
So basically the responsibility is on the building consent to actually determine whether or not a consent is required. That's how it's structured. And that's how Rotorua operates between the two sort of regulatory arms.
Yeah, it is supposed to dovetail with that process and the existing geothermal assessments that are routinely required as part of building consent processes, and just provide a clear status for basically telling people that their geothermal assessment, geotechnical assessment should cover geothermal.
Do you have any other provisions in the plan that actually rely upon some other part of the organisation to trigger an alert of this sort?
To trigger a geotech assessment?
No, just to trigger. I mean, here the responsibility is not on the resource management part of the regulatory arm, but it's on the building consent regulatory arm to actually advise. It just seems to me it's an unusual performance standard in my view, and I just wonder whether it's actually appropriate, because if in actual fact non-compliance is, it's only a restricted discretion for non-compliant, which again, I guess there's an argument that might be a bit light, given that the matter of discretion is measures to otherwise meet the requirement, which is, that's my gloss on it. Seems a bit lightweight given the potential import of the issue.
Yeah, and I think that was the point of Kaingoura as well, where they suggested that perhaps there should be a restricted discretionary activity. It is complex because we're balancing the fact that the geothermal system itself is very big, whereas the sites that have the problems within it are nowhere near as large as the actual geothermal system. So it's that cost benefit, efficiency, effectiveness balance between trying to, if we were to require restricted discretionary activity for the sites in that geothermal system, that would be quite an onerous and would add costs, whereas the actual sites that we're wanting to target are only selected within that. So the approach that we have suggested is trying to be efficient by building on to what is the main compliance step for the council, which is looking at building consents and tagging along with the geotechnical assessments that are already required. So it's trying to create a really efficient system, and also practice that. It's not that this practice isn't already occurring. We already do look at geothermal hazards as part of building processes. It's that we're providing a more rigorous status around that and greater expectations around what the assessment should cover.
So basically, if I can put it in my words, this is filling the hole that the building consent has in it. And so you're trying to find a workaround that actually secures that. I'm not sure this does it. I am a bit concerned about the way that that's framed up, and you might want to just have a think about whether there's a slightly different way of casting that. It doesn't necessarily have to default to restricted discretion. You could play around with controlled activity, for example, for the production of something. But I'm not. Yeah, if this is an issue, and it is clearly an issue. It's not an issue everywhere, obviously. It's not an issue everywhere within the system, but it is a health and safety issue. And need some confidence in actual fact that's a system that's going to work. So to leave that on the table for a moment.
Okay.
Right. And also because, of course, it's a Section 6 issue as well. Any late-breaking thoughts?
Just to follow up on that, just looking at that provision in the addendum rule NHR8, and you've added provisions to say the building consent application shall be consistent with the recommendations of the geotech report, which is all well and good. But if it's not consistent with it, then it triggers a land use consent requirement. But isn't that kind of too late because they've already lodged their building consent and they're ready to go? So I'm not quite sure that works, or it works efficiently anyway.
Thank you.
We're just proposing a slight change to the program. Taking into account availability of people who have travelled here, plus also the topics that Kim Smith has just dealt with. We thought it might make sense to have Mike Nixon deal with the transport issues and then John deal with the geothermal hazard at this stage, and then we'll move back to the 42A report on the other topics.
Well, thank you for that advice, and I'll now give you some advice back. I've been letting things run a little bit because I wasn't aware how many people may have been watching and therefore needed to have some of the detail and so on that you've been going over. It appears that there's not a lot of people. In actual fact, we are not the Women's World Cup, which, is sort of, we're sorry about that. We thought we were star attractions, but so I'm going to start shortening things up quite appreciably from here on out with respect to matters. So there are two issues. One is if people are actually reading from prepared summaries, we have those in writing, please. And secondly, don't read from them. Just from now on, staff, and that goes for witnesses as well. We just want you to hit the main points in a couple of minutes, and we'll go straight into questions at that point. If we want to go any further, we'll take it further, but we need to start catching up on some time. So if you wouldn't mind. And Mr. Nixon, welcome. And you're the guinea pig, so there we go.
No, thank you very much. Good afternoon.
Can I just ask one further question related to that same issue? It would be helpful if you were able to indicate whether there are any of these technical witnesses who you don't wish to ask questions of.
Yes.
You did mention potentially Mark.
Yes, we
Pennington.
haven't identified anything at this stage that we need Mark Pennington for.
The other one I perhaps wondered about was Craig Goodwin.
Oh, waste collection.
Yes.
What a glorious name. Yes. No, I don't. Do you have any waste issues? Oh, yes, we're going with the no-goes. I think Mr. Goodwin's fine. I think we can excuse Mr. Goodwin, certainly Mr. Pennington. And sorry, you're good. You're good on those. Anyone else? Oh yes, no, we definitely will. Mr. Conver will come forward. Geothermal won't terribly long.
Rutazano, what does he do?
Three Waters? I think. Probably I don't know if we got any questions.
I don't.
I mean, I think the Three Water infrastructure stuff is really just information, isn't it? I'm not sure.
It is. It's the high level.
Yeah, I mean, I don't recall that there's anything in Mr. Manzano's evidence that's going to be challenged. It's just a statement of how things are at the state of play. So, I mean, I think we'd be quite happy to excuse them unless overnight we have some breaking things and we could advise on that. Yeah.
Thank you.
I mean, I'd be facetious and excuse all your witnesses, but that might be, yes, right.
So just hear her excusing Goodwin, Manzano,
Pennington. Yeah, cool. At this point. And do we have any update on Miss Fairgray's condition?
She is planning to travel down tomorrow, but she doesn't know whether she will be well enough to present her
She
evidence
shouldn't
tomorrow.
be travelling in that case.
I'm leaving that to her.
No, yeah, I mean, we can take her. We can take her remotely if that's an option for her. We'd be happy to do that.
Yeah. I have spoken to her today. Her preference is to attend in person, but it may be that we need her to
But it's our
present on
preference that
Wednesday.
matters. Yes. All right. Okay, Mr. Nixon, thank you.
Right, back to it. I did prepare an executive summary within my evidence, so I'll just quickly skip through those main points as Yep, I think you should already have a copy of it, I think. Yeah, so the key things are to retain the notified access width standards for 9 to 20 dwellings and provide some additional requirements for on-site rubbish collection, emergency and delivery vehicle access, and no reverse manoeuvring to from the road network. Update Appendix APP1 to provide further detail on design requirements for turning areas on shared access driveways and residential zones. Retain the existing access width provisions for 1 to 2 residential units and 3 to 4 residential units. However, add further qualification that if the shared access driveway is greater than 50 metres long, then the formed access width must be increased to 4 metres to enable access by fire appliances. Retain the existing and notified ITA threshold of 100 residential units, and retain the notified traffic assessment requirement for developments with 20 to 100 residential units. In summary, that's what I've recommended and what's been adopted in the provisions to date.
Thank you, Mr. Nixon. I hadn't realised you were just going to read from your evidence in chief. That's fine. That's fine. That's good. Thank you for that. Yeah, I'll as you say, I think the planning team has generally accepted your recommendation on that.
Yeah, just one question, Mr. Nixon, your paragraph 5.15. We made a recommendation regarding shared access driveways for 9 to 20 residential units in a turning area. Has that been included in the recommended amendments to the provisions or not?
Yes, it has, my understanding. I'll just quickly check.
Okay. Yeah, that's right, because as the chair's just said to me over the page, you say no amendments were proposed in this regard. So
You still seem to have a concern about the turning circle for the larger council waste collection truck. And since we've excused Mr. Goodwin, he might want to hear that answer.
Yes, that was the intention, was to have that still in there. I can't see it on the copy I have. I'll just confirm. Yeah.
Right. Just an indication of whether that was an oversight or whether you've decided not to. It's in Appendix 1.
Yeah, that was the intention, was to have that in there. And that also, by having the ability to accommodate the rubbish truck, we could also accommodate fire appliances as well.
Good.
So Appendix 1 to what? Appendix 1 of what? Is that? Just a minute. Appendix 1. Yep. So whereabouts, what page is that on?
Part 4.
Yeah, that doesn't address the issue that's in paragraph 515 of Mr. Nixon's evidence, does it?
So, Mr. Nixon, have you got that? You turned that page up on the turning standards.
Yeah, like I said, I've got a copy here that doesn't specifically state the requirement for the 10.5 metre truck.
Yeah.
Yeah.
So I'm just, oh, sorry, it's on the page over. Yes, it is. It's design and construction. Yeah. So APP1, section 3, design and construction. And that's 3A, Roman numeral 5. And the sentence is turning curves
for private access
driveways for residential units. A 10.5 metre rigid truck shall be used for the design of turning areas.
That does it.
Yes.
Thank you very much.
All right. So we should note that your evidence where it says this hasn't been done, we should change that to saying it has been done.
It was all about timing that came along after this was done. Yep.
Okay.
All right. Thank you.
Is that it?
You're done.
Thank you very much.
Part of the new input.
This is on the production of notes. Another thing.
Yeah, okay. No, I mean, I think one thing I did notice, it was a conjoint study, I think you indicated, but there was no indication as to whether or not all parties agreed with the outcome report. I'm assuming that that is the case. That we don't have any sort of critical submissions from the councils, for example, on that. No, if you tell us that in actual fact parties were happy with the final outcome and recommendations. Mhm. Right, right. I mean, were there any significant issues that were unresolved amongst, at least amongst the experts rather than non-experts?
No, not in terms of the hazards.
Mm. 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 Yeah, yeah, okay, all right.
Yeah. Yes, just looking at your evidence, para 5.5 on page 5 of your evidence. Have you got that there? No, I need you to have a look at it. So can someone give them this evidence, please?
Mm.
Yeah, page 5. And just looking at your recommendations and trying to tie it in with what's been recommended to us in the provisions from the planning officers. To your knowledge, have your H and I been included in the provisions recommended to us? And if not, should they be? Hmm.
And as far as my convinced is that for H at least, there's no development within 5 meters. Yeah. And also change. A consent or proposal that would come in, we have to consider the geothermal risks on each site. So at that point, we to assess. I'm actually unsure.
Yeah, but from your point of view as an expert, should that be reflected in the provisions?
Most certainly should. And the reason why the high, there is a setback at 5 meters, but the 5 meter corridor is just
Yeah. Okay. Now looking at your paragraph 8.1b on your page 7. And this is the council's reporting officer or the planner's response to your expert advice. I'm interested in B, the rejection of the proposed performance standards regarding the venting of structures. And you say this performance standard could still be effective. So is it your advice that that standard should be retained in the provisions?
No, the purpose of this paragraph was really to say that the intention was for these venting structures to be highlighted as necessary through the report.
Right. Yes. Okay. Yeah. So you'd be comfortable as long as the report that was prepared by the geotech expert evaluated that matter. Okay, right. And finally, just in relation to 8.3. You say there, the last bit, the site-specific assessment will be expected to detail safe setbacks from surface features and the 5 metre setback from bores. So in your mind, is the 5 metre setback from a bore a minimum requirement? So that should always be at least 5 metres?
Yeah, absolutely. And that's would be sufficient, but
yeah. And in terms of a setback from surface features, do you think there should be a similar or different default setback, that a minimum setback that should always be imposed regardless?
It will depend on the nature of the surface feature. But that's one of the reasons why we didn't.
Okay. So there's no merit in having a minimum default setback.
Well, at the moment, it's
5 meters.
5 meters. So
5 metres from bores, and is it 5 metres from surface? Okay. That's all. Thank you.
Just go back to that question that you asked on with respect to the venting matter, which has been deleted or proposed to be deleted from NHR 8. And then there's a list of matters that the report should deal with. But there's no specific reference to venting structures within those specifics. Is that something that you think should be in there, or is the generic requirements in that reporting requirement sufficient?
the practice now would be always
And this practice note that's proposed, is that in train?
Yes.
Okay. So is that something that should perhaps be introduced into the advice notes if that's going to be around about the time when we get to a point of recommendation? I mean, if there is a practice note, it might be an idea to think about locking it into this particular provision. No, just leave that with you. Yeah. No. All right. Thank you, Mr. Brisky. Right. Now we're back with the 42As now. Ms. Bindon, is it? I take it. Yes, right. So we're going heritage.
on historic structures within Rotorua. And the report by Mr. Markoma was limited to commenting on the sites, the historic structures, which were in zones that had been proposed to be upzoned. So that was the residential 1, 2, and commercial 4 zones. Plan change 9 also proposed, Plan change 9 proposed these amendments to better manage the adverse effects on historic heritage structures in response to the increased height and bulk permitted by plan change 9. So the changes included the introduction of a new restricted discretionary rule for buildings or alterations on the same site as historic heritage structures, and then associated matters of discretion with that one. We received, I guess, a number of submissions, including from Heritage New Zealand, who sought some changes to the extent of place as proposed in the heritage report. And we've since met with them, and both Mr. Markoma and Ms. Byron have come to an agreement on those extents of place and what they might look like for those sites. Yeah. So while both experts now agree that some additional protection of the historic structures might be needed, including taking those to some additional adjacent sites, in my opinion, the lack of notification, an extension of the application of the rule would raise issues of natural justice. And I'll leave it at that, I think. Yeah.
in relation, has suggested the inclusion of a performance standard in relation to the treatment and management of wastewater. I agree with the points raised by Mr. Little, and through rebuttal, I have now proposed an advice note to address these concerns. So sorry, that was a very fast, quick summary of the public hiring provisions. I have also considered the partnership with Te Arawa as part of the 42. Would you like me to go on to that now, or questions? Okay. So through submissions, concerns were raised in relation to the Rotorua Lakes Council current partnership with Te Arawa. Although this is not relief in terms of the relief sought in terms of the provisions of PC 9, through the partnership with Te Arawa, RLC will continue to work closely with all partners, including the Te Arawa Lakes Trust, in ensuring that housing is delivered in a way that meets the needs of all iwi. A submission was also received, noting that RLC has legal obligations to Māori regarding engagement and decision-making under the treaty. And the submission raised concerns that simply including a statement of iwi and hapu aspirations will not meet the basic council requirements and obligations. I acknowledge the submission and note that the draft FDS strategy is currently being developed, and it is intended that this strategy will address the issues and points raised by the submitter, including the incorporation of a statement of iwi, as per in accordance with the MPS UD.
Kia thanks for that. So I'll re-ask the question I asked earlier. It seems you seem to be the guy to talk to about it. So the definition that Kāinga Order suggests for Papa Kāinga, and the chair picked up there's also a definition in the district plan regarding Papa Kāinga housing.
Yes.
If we were of a mind to adopt your recommendation, I'm just curious whether there's any consequences of doing that for other parts of either PC9 or of the district plan.
I don't believe so. The definition proposed by KO. So you're right. Currently in the plan, there's a definition for Papa Kāinga and a definition for Papa Kāinga housing. The proposed definition, I believe, would cover both aspects or cover all aspects. But in terms of any flow-on effects throughout the plan, I don't believe so, given that the provisions are tailored towards Papa Kāinga itself in those residential zones, essentially, and the rural zones in particular.
Okay.
So no, I don't believe there would be an issue.
Can I just follow that through? I'm just curious. I mean, the current definition of Papa Kāinga housing is that the provision of more than 2 residential units on Māori land for tangata whenua who have mana whenua status includes kaumātua housing. What is the purpose of that? If in actual fact there is a broad brush definition accepted of Papa Kāinga, which includes residential and civil activities and so on and so forth.
Agreed.
Is there
Agreed.
does that definition of Papa Kāinga then become irrelevant, or does it have meaning elsewhere in the plan, which again might trip up whatever what someone's trying to achieve? Don't need to answer that now. Just happy to put that on the table, and you can come back to us on that one. And I mean, it would seem to me that definition, just on the face of it, the definition of Papa Kāinga housing is no longer needed, and as a consequential, they could be deleted. But I leave that to staff to come back.
I've got
supplementary.
another couple of questions, or 2 more questions. Did you prepare that part where the Rangitaitaya Road, residents of Rangitaitaya Road asked for rezoning to?
Yes.
Yes. Okay. So, and then the solution was that Papa Kāinga, the proposed Papa Kāinga provisions could resolve the issue that they were looking for.
Correct.
And then there's the other matter that the surrounding residents that may be affected by any rezoning, right? Either Clearwater or Waikanae. I'm not a lawyer. I don't know, one of those 2, right? Yes. Okay. That was 2 questions. There's one. So one more. I'm curious to regarding Te Aroha Lakes Trust submission on, and I know that that's been headed towards the FDS, but I'm curious in terms of the general sense that you've gotten from engagement with either Marae Hapu or iwi in terms of council fulfilling its responsibilities to tangata whenua, such as they define themselves within Te Aroha.
Yeah, sure. I believe we did a significant amount of engagement with both mana whenua and iwi. Iwi and Hapu and mana whenua. And in particular, there was a working group established that dealt with the Papakanga provisions specifically as well, to work with them to tease out what would would work for iwi and Hapu essentially.
Okay, great. Thank you.
Thank you. Just looking at your recommended amended definition of Papakanga, and it includes ancillary activities, which you put in the brackets: social, cultural, educational, conservation, recreational, and commercial activities. Just a quick flick through the definitions. Social activities aren't defined in the definitions of the plan. Cultural activities aren't defined. Conservation activities aren't defined. Recreational activities aren't defined. I haven't got to commercial activities yet, whether or not they're defined. So that's an issue. Educational facilities are defined, but not educational activities. So I just wonder if it might be an opportunity to nuance this a bit to refer to definitions that are in the plan for some of those features, or some of those ancillary activities. And why I say that is because when I look at the relevant rule, which I think is rule PKR1, it's just a general permitted activity rule. And it includes a different range of features. It includes, as well as residential units, includes places of assembly, commercial or industrial activities. Industrial wasn't in your definition. It includes social services, but not social activities. And it includes health services, which aren't in your definition. And then the only constraints on those activities are they need to be set back 100 metres from any residential unit, and they can't exceed 500 square metres of gross floor area. Now, to me, that seems like an extremely benevolent provision. And so my question is, in relation to all of those ancillary activities, or whatever they might be defined as, if you come back with some different wording, do all the other performance standards in the plan that relate to those activities, commercial, industrial, etc., apply regardless? Or does this override them?
So there's an oversight. So we would, if we adopted the Kāinga or the proposed definition, we would assume those activities as detailed in the definition there. But you're right, they would have to be defined in the plan as well. Yeah.
I guess I'm just concerned about the very broad nature of amended rule PKR1, given it's a general permitted activity rule, and there seemed to be a paucity or an absence of any standards relating to all of those ancillary activities. And I'm not sure if that was intended, or if it is intended, was it appropriate, or if it was just an oversight, and if some quite significant reworking of that provision was required.
Potentially.
Yeah, but just a concern, don't have a solution in mind, but just raise the issue with you.
Great, thank you.
Sorry, just discussing with the chair, just in relation to that discussion I had with Mr. Brzezinski on geothermal. I just want to make sure that in your right of reply or prior to that, that you follow up on these matters that were raised in his evidence, that his 5.5 clauses H and I, and they are some kind of standard relating to impervious surfaces in relation to geothermal hazards. I think the rules only refer to buildings, and the definition of building doesn't extend to impervious surface as far as I can see. And then there was the 5 metre access corridor. I don't see that in the provisions. It might be there. I'm just not that familiar with your plan. And then the other requirement that he stressed was necessary as an expert, which was a 5 metre separation from bores. I don't see that in the provisions unless I'm missing it. So just those 3 matters, I just wanted to make sure you do cover off in your reply to us. Thank you.
Makamba, yes. Yes. Yes, it's changing time since there's no more Jeremy. It's yes. 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 Yes, the thing that I do, and I'll just caveat that with my initial report, which is an appendix. I was hitting hard on the expectation that any building development, whether on any of these 6 historic heritage sites or next door, should be, I was hitting the point hard that I was my suggestion is that they would be vetted by, for instance, Heritage New Zealand for particularly the properties that they obviously have an interest in, category B. Mostly from the point of view that seeing what's been happening around the countryside with Tier 1 in particular, and knowing what we do or what I do on a weekly basis and have done with Heritage New Zealand and the local council heritage team, if there is one, it seems to be the best way to get an outcome. So the consultation, you go with the design early, you try it, you come back, you go with the design early, and you just develop it that way. And then we were fortunate to have enough to meet with and talk with Robin Byron from Heritage New Zealand and cover off the 6 properties in particular, and pretty swiftly come to agreement. At that same time, when we were in a position to be able to talk and discuss through each of the properties, the penny was dropping more. Initially in my report, I was looking at potential. Some of the sites have potential, like the Pukehangi site, the cottage there, massive site, that's got lots of potential. So there's lots at risk. Less so with the more established, like the Glenholm, Miller Street and the other properties. So in short, yes. Yes.
Tēnā koe. And refer back to a question I asked earlier. There's agreement to replace the word setting with effective place, and it's capitalised. And we were discussing earlier today about whether that should, whether there are consequences in using that term in terms of what it means, and therefore as an example, the definition you use in your evidence should then be a definition within the interpretation chapter.
Yes. Setting as opposed to extended place. Extended place, if I talk about that first, it's a recognised term, EOP, in the built heritage circles that we deal with when we're talking about there's a heritage building of whatever type, whatever classification, and it has an extended place. So that's effectively the curtilage or the boundary or the identified setting. So as opposed to setting, which is the surrounds of a heritage building, but we don't know whether you're 10 miles away or 10 meters away. So my suggestion here to, no, I won't say a pun, but my suggestion here to literally limit it and for clarity for all parties was to push the extended place, because it has, it's a specified area. And that could apply to any building, whether it be new or old, in relation to historic heritage. I don't know if that makes it any clearer.
Yes, my familiarity is more in the Waihi Tapu and Waihi Whakahira space. So at times the extent of that space is in the eye of the beholder, and that beholder would, their extent will depend on where they sit in the conversation and what their perceived benefit or actual benefit or cost is from their position. So how do, if it is a defined area, who defines it, and then so that we know that, from this point, there's the geographical map of it, there's a blob of it.
I'll answer that in two ways. If it's a building, a 100-year-old villa in the middle of town, any town, in this case, for instance, Miller or Robertson House, it's quite clear that there's the cadastral set out boundary, which often coincides with the extended place, simply because over 100 years, as long as that boundary hasn't shifted greatly, you get established trees and you get this, that, and the other, and ancillary buildings that are built within the boundary there. So it's an easy thing to literally get your pen and go around like that, and then that gives you at least a defined curtilage from which the suggestion is that you get resource consent should you want to do anything within that extended place. But second example would be St. Peter's, the church. Is any more point? Yes. And that, the more I thought about that, the more there's so much going on there. There's the marae, there's the church, there's the Orapa, there's the lake, there's Hennemore Rock. And I don't quite know what the answer is there, because as you say, it depends, it's in the eye of the beholder as to what in this case, the setting would be. And the setting in this instance would be someone who rounds the corner past the marae and they see this, and it's probably from there that they see that that's the part that should be protected. And I come back to, I suppose, my point about the consultation, because if it's an example like that, that's one where it needs a lot of talk about and consultation about, well, who's interested in the setting and who's trying to define the setting. And so I wouldn't say conveniently, but I suppose just from a practical point of view, thinking it as a practicing architect, thought about the extended place curtilage is a more appropriate thing and practical thing to hang your hat on than the word setting.
Okay, so using the example of a house, a villa within a cadastral boundary, then in terms of its extended place, it could be that cadastral boundary, but then the setting, it's not like you'd want to bang up a 6-story building on each of the 4 sides, because so long as you take care of the daylight angle and all that jazz, whatever the terms are. Does PC9 protect against that?
Ms. Bindon talked about natural justice, and that's where, if we look at that, then it does, to the extent that it's fair and reasonable, I would suggest, in that we take the example of, there's only a few in this case, but the example where you have the cadastral boundary and right next door, there's the potential next year in 5 or 10 years' time for a multi-unit development to go on there, as long as they're complying with whatever, the Res 1 or the Res 2 or Commercial 4 suggests. But this is, again, the two key points the themes that have been pushing through in my report and my evidence to some extent is the consultation and the Heritage New Zealand buy-in and discussion with them. Not so much because they'll say, no, you can't, but it just gives everyone the best opportunity to have the experience and I guess the practical awareness to be able to bring to the table 100 other options that have been done before elsewhere around the country. And so it's not all brand new news. And the second option, which I personally think is a really important one, is to advocate for good design. And good design is not 15 different materials. It's good design. So that's not particularly what we're talking about. I've tried to say here, if there's any way to try and make a provision or provisions through the resource consenting and the building consent that the design is vetted. I don't know quite how to do that, how that could be done.
Okay, Paul, just to put you on the spot as the expert, if we were to adopt extended setting, would you advise using your definition and your evidence in the interpretation sector?
Yes.
Chapter?
Yes.
Kia ora.
Kia ora.
I'm disappointed. I thought you brought us the Holy Grail today, but you obviously didn't. Yes. Yeah. I mean, I don't think we've got any provisions in the residential provisions now that actually require consideration, do we? Of if there is a scheduled site next door, to have any consideration for that at all? Or is that we've got some global provisions, but do we have a specific provision that requires that to be paid attention to?
Not in the residential zones, no.
So just to summarise where we've got to, the provisions now in front of us that you can't have an additional building within the site of one of your 6 notable built heritage buildings, but there's no provisions because of scope issues controlling what can happen next door to those sites. Is that where we've ended up?
Just so that I'm clear, was the first part of your question suggesting that you can't have any new building within site? What I was advocating for is additions and alterations, certainly, but not new development.
Yeah, not a whole new building, but you could alter.
Correct.
Yeah,
correct.
So that's where we've ended up, but we can't consider because of scope issues what's happening next door.
No, and if I think of other examples around the country, it's hence the reason why I'm pushing for whatever it is that's next door should be of a design standard, so that you stand the best opportunity of getting a good design for those people, but also it's something that when you look at it, it's a good design for these people. That's the hard thing to nail down.
Just Ms. Emily, in terms of what your reply, I'd be interested to know legally in terms of our powers under clause or section 99 to address issues that are potentially outside scope of submissions but are raised, during the hearing in response to submissions, whether in terms of clause 99, we could look at some adjoining section provisions targeting things on sections adjoining these 6 notable built heritage sites. It would be a shame to miss an opportunity to do that if there is one available to us within the law.
And what that might be. Yeah. I mean, it's likely to be limited to a matter of discretion, nothing more. But if we can flag it, then perhaps we should think about that. I just wanted to be clear. I'm not sure whether I heard you too correctly on that issue. It isn't. There's no prohibition against building a new building on a site that contains a heritage structure. It's simply a restricted discretionary activity, isn't it? That's what it's not clear.
Should there be a prohibition?
Okay, sorry. If I was a developer and I got hold of one of these heritage sites and I thought I could lop off the back there and build something there, that's where the discussion has been with Robin Byron from Heritage New Zealand, and I have agreed that no, that should not be allowed. Yeah. However, if I own the existing heritage property and I'd like to build something within that under my own steam, whatever that ancillary building is, then yes, it's a discretionary activity to conform with the form and the materials and the proportions, etc., whether it's attached or detached.
Yeah. And so do the recommended provisions capture that? Is that what's in front of us? Who's the planner who's in charge of this?
I mean, the question I would ask is there a limitation on subdivision of one of these properties? And I wouldn't assume there would be. It would be a very bold thing to try and put into a plan, but be interested to hear. Because that would be the obvious route then. You simply subdivide, and then once you've subdivided, that's it. Yeah. Yeah. The case of last up, best dressed, isn't it? Yes. Yes.
This is just the summary.
Okay. You got more than one copy, or you just got one copy? Well, don't take your own away. So that's fine. That's fine. We can follow you. You're putting it up on the screen, presumably, are you? Sorry, hang on a second. Let's have one hearing, please. Thank you.
Okay, so I just thought we've transversed a lot of the sort of initial context issues, which, paint the picture of housing need and obviously the demand. We'll obviously hear more from Ms. Fairgrave as well around the demand picture. But what I could do is I could jump into section E on your summary document, which is really talking about the future development strategy and its timing, as opposed to transverse the contextual stuff. We got the PowerPoint. So I think if we just move to slide 8. Just move to slide 8, I think, on there. Yeah, just keep going.
So is
Yeah,
your
that's it.
summary document that you're going to speak to now that we don't have a copy of, is that on the webpage?
No, this is a sort of a summary, just that, it's not on the webpage. This summary, it was drafted yesterday for, but we should have copies, don't we? I know.
We can provide that to you, but I think that Mr. Matthew is going to summarise his summary now for you.
Yeah, so
this will be the even reduced version.
So anyway, yeah, so just in terms of the future development strategy, I suppose it's quite important to just paint the context that beyond PC9, we're looking at, obviously, it replaces, the FDS essentially replaces the previous spatial plan, which was done in 2018. And I think a key thing is, and we spoke about policy 5, is that it addresses policy 5 in the longer term, obviously out to 30 years. So key aspects of that is making sure that we achieve well-functioning urban environment, but also I think provide at least sufficient capacity. So not just sufficient capacity. And you'll sort of see that as I go through this very quickly, that we talk about providing more capacity than what we've defined through the HPA. The HPA talks about 9,740 new dwellings, which is obviously the demand plus the additional 15% in the long term. But in the future development strategy, we talk about providing 12,300 new homes.
Yeah.
And that's purely to have options on the table, because it's such a long-term picture that we can either bring forward capacity or push capacity out. But essentially what I'll be talking to is really what comprises that 12,300 picture. The other aspect is that obviously a key thing is the integration of planning decisions. So this really, I suppose timing is quite important. We're working towards informing the 2024 LTP. I suppose timing in terms of the plan change, bit awkward, because obviously you've had this plan change. We've got the plan change hearing now. We'll be having the future development strategy hearing at the end of August, on the 28th and 29th of August. Obviously this as a draft was notified, I think was mentioned on the 1st of June, and it's had its consultation period, which closed in the middle of July. So we're in the process at the moment of really going through the submissions and gearing up for a hearing. Just in terms of the capacity picture, as I mentioned, we provide for a greater amount of capacity, 12,300. And that, just to mention a few things, we've heard some of it today, is to address some of the constraints, particularly in the central area around geotechnical issues and the realization of apartments and that kind of topology in the central area, but also in terms of, I suppose, both developer sophistication and also the amount of leasehold land that we particularly have out east provides quite a bit of challenge, and obviously seeing, I suppose, development coming on stream at scale. So in terms of the picture that you have up on the screen, really this provides, I guess, a spatial picture of the future development strategy. The grey area that you see on that map is our existing urban footprint. So it's the existing urban area as per the district plan. The yellow areas are what's proposed in terms of new greenfield areas or greenfield locations. The mauve areas are the greenfield, and those are the light mauve kind of oblong rectangular areas are what we proposed in terms of new greenfield business locations. The circles really on the map are just really showing the significance of centres, and I'll touch on that because the model that we proposing through the FDS is obviously, as far as possible, achieving a compact city model. So that's why you'll see the existing, the proposed greenfield locations quite close to the existing urban boundary. And obviously, I'll touch on it a bit later, but obviously wanting to achieve density around the centres as far as possible. So really just moving on to, I guess, the implementation, if we move to the next slide. If you just click the slide again. Yeah, next. Yeah, and again. So obviously if you can leave it there. So starting point is really PC9, which is enabling higher density across the grey area, which is existing urban area. Obviously residential one doing quite a bit of heavy lifting in terms of plan enabled capacity. But feasible capacity is obviously very different in terms of what's reasonably expected to be realized, and that's why and then in terms of short-term residential is what we've circled in black there, and it's really, you can see in Nongatawa we've identified the orange areas are future residential, which would be residential one. That light green area is rural residential. And those are all what we've factored into the short to medium term. And in terms of the NPSUD, that's 3 to 10 years. I suppose the orangey or peachy coloured slice of land at the top there, which is the Delbeth, below Delbeth Road, is we factored into the medium term. And then to the right of that, or the east of the State Highway 36, is what we factored into the longer term. Also, if you swing all the way around to the east side, you look at Ofata, beyond that, we've got, and beyond Wharenui Rise is a sort of a lighter pale yellow color is the is what we've also factored into long-term residential. So I think the key point is we've staged the greenfield development. If we move to the next slide, I think obviously particular relevance to this plan change is also looked at future long-term high density, and long-term high density obviously being, but if we move back, sorry, to that other slide. Yeah, if we just move back. Obviously long-term being from 20 to 30 years out, saying, look, if we want to deliver centre development, effective centre development, we should be looking at increasing intensification in the longer term. So what we have looked at is Nongatai, and I'll touch on the Glenholme area because that's obviously contiguous with the existing high density zone. And then out the Tina shopping area, Ofata area is also where we've looked at potential long-term high density. So I guess a key thing in response, if we move across, particularly to KO, if we move to the next slide, is really the phasing of high density. So Mr. Wallace touched on the assessment that was done, effectively the heat map that looked at accessibility, and that's a slice of it focusing on the central area on your left-hand side. And I think that was a key basis for us in terms of determining well-functioning urban form, is to look at that accessibility mapping and then identify those long-term, because I guess demand's less of a factor in the longer term. When you're looking out to 30 years, we sort of looked at the heat map to guide us around where you would anticipate to see high density. And if you look at the central area, we focused in around moving further south. If we click the slide quickly. Really, it's leveraging off the fact that most of the, I guess, accessibility good factors are around the city centre. And the central, which have already been proposed through PC9 to be upzoned. And if we click on the next slide. So first phase of intensification is really proposed through PC9. When I say intensification, I'm talking about high density. And the second phase, if we click on the slide there, we've really looked at that piece of land that goes out to Rimu Street, Rotorua Street, which links up to the racecourse. The racecourse in sort of discussions could potentially become available in the longer term for residential development. And therefore we thought that would make sense to look at it in the context, I suppose, of future high density zoning. It also, I think, particularly what you've outlined in the evidence is that we have the opportunity to monitor uptake of intensification. And we found that we felt that a more phased approach to addressing high density will allow us to, I suppose, monitor the potential redevelopment or the redevelopment potential over time. And I think that's quite important in terms of, I guess, being quite careful in terms of where we focus intensification. Ms. Morgan touched on it a bit earlier, and I think Ms. Fairgrave will talk to it as well. I think it's important that we don't see sporadic, I suppose, piecemeal development that happens over a large area. And we really focus in on concentrating that development where we can obviously get economies of scale with respect to transport, proximate, the use of existing infrastructure. So that was the logic, I guess, of phasing the high density as opposed to really looking at a larger extent, which is proposed by KO in terms of the medium term or short term, should I say, and rather pushing it into the longer term through the future development strategy.
And the key on all of that in terms of phasing is obviously triggers and how you actually manipulate the triggers. Does FDS go into the sort of the triggers that would make you move, would encourage council to make the move between phase 1 and 2, for example?
So, perhaps what I didn't touch on is, I suppose, the evidence is on a 3-year cycle. So we start our next, sort of cut that first bit out, but I would have spoken a bit about the HPA, and the HPA, our housing and business capacity assessment, I guess, informed this initial test in terms of the plan change. But when we review, we thought through the HPA cycles, we'll be able to then identify to see whether we're actually seeing significant uptake, particularly within the central area. And I think equally the FDS being a strategy gets reviewed every 3 years. I know we've got to then go through a full process every 6 years. So we felt that those were the natural triggers. We are also required to monitor housing indicators as well through the NPSUD. So I suppose those will be quite important in terms of us testing whether we've gone far enough or whether we, whether we've gone far enough. Yeah, sorry, that's it from my side.
So it's part of the background, an important part of the background from council's point of view. I guess it would be interesting when KO comes forward as to whether or not what's proposed there sort of satisfies them in terms of them holding back into their aspiration at the moment. So we'll hear that on Wednesday, I guess. Any questions?
Yes. You get just two questions in your evidence at your 3.5, para 3.5, and you've mentioned it in your verbal summary that the draft FDS provides for achievable development capacity for 12,300 houses. Now, in Ms. Fairgrave's evidence, she refers to the figure of an additional 9,700 houses, which you've clarified should be 9,740, but it doesn't really matter. She thought up to 5,600 of those would occur in the existing urban area. So with that same ratio, 5,600 over 9,700, would that same ratio apply to your 12,300 figure in terms of what might be expected in the existing urban area?
Yeah, I mean, I suppose the way we broke it down in terms of the FDS, we spoke about 7,000 within the existing urban area.
7,000, yeah.
Yeah.
Okay.
So
No, that's good. And just one other question. And it's apparent to me from Ms. Fairgrave's evidence that the high density residential zone as notified in PC9 provides way more development capacity than is required by either the 9,740 or the 12,300, particularly if you ratio that down to what might be an existing urban. And given the evidence we've heard from Mr. Wallace that it would be good to concentrate high density development as close to the city centre as possible, and given also that the uptake of the high density zone will be dependent on developer aspirations, but wouldn't it be prudent at this stage to omit the HDR zoning that's currently indicated to the west of Old Taupo Road, which is the furthest away part of that HDR from the city centre? Given that you've oversupplied plan enabled capacity and you want to concentrate around the centre, wouldn't it be prudent to omit that little sliver to the west of Old Taupo Road?
yeah, so my view is that we, as far as possible, take a bit of a centres-based approach, and Malfroy Centre is right on the fringe there, and I thought that effectively that nodal approach would make more sense. Some would argue, I guess, that Old Taupo Road itself becomes a barrier, but I think there's quite a lot of merits, I guess, in making sure that that centre is serviced by high density. So it was more on the basis of a centres-based approach that we would support that. Because within that central area itself, which is quite extensive, you would still want to see centres develop. I suppose it's quite you would, as far as possible, want to encourage density around your commercial facilities.
Sliver of HDR to the west of Old Taupo Road, where up to 6 stories residential development is envisaged. That's solely to service the Malfoy.
Well,
Commercial
yeah,
centre,
I suppose
isn't it?
also the corridor itself, which would lead through to that, having density on both sides of the corridor.
What do you mean, the corridor itself?
Well, Old Taupo Road, it's essentially would then function as a sort of a key corridor.
It already is, isn't it?
Yeah, but in terms of servicing, I suppose, greater residential development, you would realise that more with, and you'll be able to obviously address that corridor through treatment to allow for a better living environment, high density living environment.
I'm impressed you only need 2 days of hearing for that. I'm impressed that you only need 2 days of hearing for that. Yeah. Well, we might attend out of interest. Right. You got anybody else today?
But it's left us with 2 witnesses to go. One is, of course, Ms. Fairgray, who's not available today. We do have Paula Meredith here today, if you did want to hear her evidence today.
Jean, what do you think?
We have one question for her, but
Right.
I can give it to you and she can answer.
Come forward. Thank you. Yeah.
Let me just bring up the evidence.
Yeah, can you just close that file? That's not very helpful. Let me open that again.
In the microphone on. Oh, sorry, do you want to give any kind of summary?
I was just going to read the executive summary, but you've already received that. So if you just chat your question, if that's
Right.
easier.
Yep.
Straight to questions.
So
So
go straight to questions.
just in relation to your paragraphs, 4.1 and 5.5, I'm just got to check my own writing. It's 5.5 and 5.8. Yeah, 5. So in relation to your paragraphs 4.1 and 5.8, and the first paragraph relates to sub S 9.2.B point Romans 4, and 5.8 relates, unless I got it wrong, to res standard 5.8. I didn't see the provisions that have been recommended to us quite went as far as what you had recommended in terms of the wording in your evidence. Have you had a chance to review what's been recommended to us by the planners, and if so, are you comfortable with it?
Yeah, I did read a very short sentence in the recommended plan change, but I think it covers what we need to cover.
So you're satisfied that your recommendations you've made to us and in your evidence are adequately covered in the provisions that the planners have put up to us?
Yeah.
Okay, that's just wanted to check that.
Yeah.
That was all.
Was there anything more you wanted to tell us?
No, I think you've got it all covered.
Oh, don't be so confident.
I was just here to help you understand how we actually process consents, but
Well, certainly that's an important part of the picture, very important part of the picture. Yeah. But as you just indicated, if you're confident in the provisions that are coming forward and that they're administrable, then that's good to know.
Yeah.
Thank you.
thank you.
Yeah. Right.
Caught up.
Always do. No, not unless you want to. We didn't think we need to. So we just got to do the decision for there. And Byron. Yeah. Right. Well, I think we're there. And you'll advise us whether Miss Fairgray really is on sufficient form for us to hear her in the morning.
She has advised that she won't be available tomorrow.
I think that's very sensible by the sounds of it. Yeah, so we'll obviously make some other timetable for that. So in that case, we're scheduled to hear from the trust, not the trust, the Heritage New Zealand, and maybe somebody could make a call to see again whether we need to convene to hear that. Tomorrow seems a bit sort of heavy-handed, although I do look at Wednesday, Thursday, and my heart sinks. Along with PC9 at that point. So, yes. So yes, maybe if you converse with her and just see what's going to be convenient. I mean, if we need to convene, get a message to us and we'll just convene and deal with that issue. Or she may feel that it's not necessary. I mean, we don't have any questions of her, I think, do we? I don't think so. I mean, there seems to be resolution. Well, there certainly is resolution. Unless she's got some additional issues with the provisions that are being recommended, I can't see there's any benefit in actually talking to her. Yeah. So maybe just, you're looking puzzled? You're just looking puzzled.
Was that in relation to Ms. Beaver?
No,
Sorry,
that's
no,
Heritage
no.
New Zealand.
Heritage
Yeah,
New Zealand.
yeah, no, that's
Oh.
fine. We'll have a discussion with them and just confirm.
Yeah.
Yes.
Because
Yeah.
otherwise we'll hit the decks with the site visit in
Yes.
the morning at time to be decided. So yes, if you can let us know as soon as possible, and then we'll. You definitely need pants, I can tell you that. Yes, right. All right, so if there's nothing else, we're adjourned until, I'm not quite sure when, probably Wednesday, but yeah, let's say we're adjourned until Wednesday unless people hear any differently. So thank you all very much, and thank you for helping us to catch up on time. We really appreciate that.